Page 12, 62 to 66. Page 13, 67 to 73. Page 14, 74 to 76. Page 15, 77 to 82. Page 16, 83 to 89.
My lord, serial number 84 minutes. Connected matter is listed on 12th minutes. Kindly post it on 12th.
CEO Zilla Panchayat Belgavi yaru? Belgavi ZP?
Shivraj Hiremat.
Hiremat. R6 Zakir. 84 Shri Shivraj Hiremat, who has appeared for respond number 6, accepts notice for respond number 9 also. Connect with so and so and relist on 12th.
Page 17, 90 to 95. Page 18, 96 to 100.
Serial number 99, my lord. Kindly on day after tomorrow, my lord.
My lord, it's a no confidence motion, my lord.
There is a function was there in a senior office, senior home, my lord. Kindly on day after tomorrow, my lord.
No confidence motion ಯಾವತ್ತಿದೆ?
Already
ಆಗೋಗಿದೆಯಾ?
ಆಗೋಗಿದೆ,
Stay ಇದೆಯಾ?
Stay ಇದೆ, my lord.
Stay vacant.
stay, my lord.
No, my kindly on day after tomorrow.
ಏನಿದೆ ಸಬ್ಮಿಷನ್ ಹೇಳಿ ಆನಂದ್ ಕೊಳ್ಳಿ ಏನ್ ಬರೋದ್ ಬೇಕಾಗಿಲ್ಲ.
Hardship covered matter, my lord.
ಏನ್ ಕಂಟೆನ್ಷನ್ ಏನ್ ಹೇಳಿ ಅದ್ ಮುಗಿಸಿ.
Kindly on tomorrow, my lord.
ನಾಟ್ ರಿಕ್ವೈರ್ಡ್ ಏನಿದೆ.
One submission.
One.
Serial number 62. It was supposed to be listed on 14th, my lord. It's listed today. We have to comply with the amended cost title.
We'll see.
Please.
One, Sadiq Budwala.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾರ ಬರೀ ಮೆಮೋನ ಪಾಸು.
Sorry, my lords. Now I submitted on of list number 1, my lords. To oversight, I thought it was list number 1, my lords. Now I submitted serial number 84. I have submitted, my lords. It was of list number 1, my lords.
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಅಲ್ಲಿ 84 ಇಲ್ಲ.
Sir, please.
Preliminary hearing 2, Prashant Swami.
Yes, Prashant.
Case of absenteeism, lords, is absent for 2 months without authorization. The court also holds at para 12 of the or page 15. No documents are produced. Para 12. The petitioner, in support of his claim that on account of illness he could not attend to the duty, has not produced any documents to substantiate his claim. Documents produced by petitioner at exhibit P1 to P3 are not related to the grounds of medical claim as claimed by the petitioner. The court sets aside the order of the dismissal and directs for reinstatement with 50% back wages. On the ground that 33 2B has not been complied with.
50% back. Issue notice to respondent returnable by March 20. By 21st March, the operation of the order date 6/11/2019. Stay back.
Please, though lords, now he has filed an application for executing
So it will go on increasing.
No, he has, my lords, filed an application for executing this order, the 50% back wages.
6/11/2019. How are you asking for 19? What have you been doing for last 6 years?
Lords, it was filed and my lords kept. Now, since he has filed an application.
19 in the, you not implemented it, waiting for him to file execution.
That's my lords.
Not fair.
Emergent notice, my lords, I will.
Emergent notice to respond returnable by 4th March, please.
Suraj.
Please. This is the education matter, my lords, were granting aid. My lords, though the petitioner was, my lords, not.
Respond number 1 has not been admitted. So whether he is over 40 or not doesn't matter.
Please, my lords. Now, one submission, my lords. The respondent number 1, my lords, is said to have, my lords, transferred to the petitioner school.
Who is for respond number 1?
My lords, I have.
Yes.
He is, my lords, transferred to the petitioner schools in the year, my lords, on 27/7/2007.
Hmm.
Now, my lords, the school is notified to be granting, notified to be aided, my lords, on 14/9/2007.
Hmm.
Till, my lords, the filing of the petition, appeal before the, my lords, tribunal on 21/9/2010. He has not raised any contention that, my lords, he is entitled to, my lords, paid in terms of, my lords, the grant in aid.
You're never admitted to grant in aid. Your respondent number one was not, as per what the government advocate is saying, you're not admitted to grant in aid. So where is the question of giving you grant in aid?
One submission to that, my lord's question. My lord, there was a proposal, my lord, sent by, my lord, the respondent, my lord, the petitioner society, my lord, recommending, my lord, names of the assistant teachers serving in the institutions.
Where is the
My
recommendation?
lords,
Third. What's your name?
my lords, there, my lords, your lordships may kindly peruse, my lord, from paragraph number 2, my lords.
Hmm.
ಫಸ್ಟ್ ಪೇಜ್ ಕರ್ನಾಟಕ ಲಿಂಗಾಯತ ಶಿಕ್ಷಣ ಸಂಸ್ಥೆ ಬೆಳಗಾವಿ ಇವರ ವತಿಯಿಂದ ನಡೆಸುತ್ತಿರುವ ಎಸ್.ಸಿ. ಪಾಟೀಲ್ ಕನ್ನಡ ಮಾಧ್ಯಮ ಹಿರಿಯ ಪ್ರಾಥಮಿಕ ಶಾಲೆ ಅಂಕ್ಲಿ ಚಿಕ್ಕೋಡಿ ತಾಲೂಕು ಬೆಳಗಾವಿ ಜಿಲ್ಲೆ ಈ ಶಾಲೆಯಲ್ಲಿ ನೇಮಕ ಮಾಡಿಕೊಂಡಿದ್ದ ಶ್ರೀ ಆರ್.ಎನ್. ಪಾಟೀಲ್ ಇವರು ದೂರು ಸಲ್ಲಿಸಿ ಲೀಗಲ್ ನೋಟಿಸ್ ನೀಡಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಈ ಪ್ರಕರಣ ಇತ್ಯರ್ಥವಾಗುವವರೆಗೆ ಒಂದು ಹುದ್ದೆಯನ್ನು ಕಾಯ್ದಿರಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಸೇವಾ ಜ್ಯೇಷ್ಠತೆಯಲ್ಲಿ ಕಿರಿಯರಾದ ಐ.ಎಸ್. ಪಾಟೀಲ್ ಅವರನ್ನು ಕೈಬಿಟ್ಟು ಉಳಿದು 5 ಜನ ಸಹ ಶಿಕ್ಷಕರ ಸಹಾಯ ಅನುದಾನಕ್ಕಾಗಿ ದಟ್ ಇಸ್ ಇನ್ ಗ್ರಾಂಟ್ ಇನ್ ಏಡ್, ಮೈ ಲಾರ್ಡ್ಸ್, ಒಳಪಡಿಸುವ ಕುರಿತು ಸರ್ಕಾರವು ಪರಿಶೀಲಿಸಿ ಈ ಕೆಳಗಂಟೆ ಆದೇಶಿಸಿದೆ. ಇನ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಕಂಡೀಷನ್ಸ್, ಮೈ ಲಾರ್ಡ್ಸ್ ಕಂಡೀಷನ್ ನಂಬರ್ 3, ಮೈ ಲಾರ್ಡ್ಸ್, ಸದರಿ ಶಾಲೆಯಲ್ಲಿ 7 ಜನ ಸಹ ಶಿಕ್ಷಕರನ್ನು ನೇಮಕ ಮಾಡಿಕೊಂಡಿದ್ದು 7ನೇ ಹುದ್ದೆಗೆ ನೇಮಕ ಮಾಡಿಕೊಂಡಿದ್ದ ಶ್ರೀ ಆರ್.ಎನ್. ಪಾಟೀಲ್ ದಟ್ ಇಸ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 ಅಸಿಸ್ಟೆಂಟ್ ಟೀಚರ್ ಇವರು ದೂರು ಸಲ್ಲಿಸಿ ಲೀಗಲ್ ನೋಟಿಸ್ ನೀಡಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಈ ಪ್ರಕರಣ ಇತ್ಯರ್ಥವಾಗುವವರೆಗೆ ಒಂದು ಹುದ್ದೆಯನ್ನು ಖಾಲಿ ಇರಿಸಬೇಕಾಗಿದ್ದು ಸೇವಾ ಜ್ಯೇಷ್ಠತೆಯಲ್ಲಿ ಕಿರಿಯರಾದ ಶ್ರೀ ಐ.ಎಸ್. ಪಾಟೀಲ್ ಇವರನ್ನು ಕೈಬಿಟ್ಟು ಸದರಿ ಶಾಲೆಯಲ್ಲಿ ವಯೋನಿವೃತ್ತಿ, ಸಾವು, ರಾಜೀನಾಮೆಗೆ ಇನ್ನಿತರೆ ಕಾರಣಗಳಿಂದಾಗಿ ಖಾಲಿಯಾಗುವ ಹುದ್ದೆಗಳಿಗೆ ಭವಿಷ್ಯದಲ್ಲಿ ಭರ್ತಿ ಮಾಡುವಾಗ ಪರಿಶಿಷ್ಟ ಜಾತಿ, ಪರಿಶಿಷ್ಟ ಪಂಗಡದ ಅಭ್ಯರ್ಥಿಗಳನ್ನು ಭರ್ತಿ ಮಾಡಿಕೊಂಡು ಶೇಕಡ 18ರಷ್ಟು ಮೀಸಲಾತಿಯನ್ನು ಕಾಪಾಡಿಕೊಳ್ಳತಕ್ಕದ್ದು. My lord, this, my lords, the order passed by the government, my lord, on 28/7/2009, my lord, shows that the government, my lord, has kept one post vacant, my lord, for grant in aid post. My lord, now this until, my lord, settled.
You admitted to grant in aid.
I was not admitted because of the pending of the dispute, my lords, between me and, my lord, the society. Hence, my lord, until, my lord, the disposal of the dispute, until the settlement of the dispute, my lords, my claim could not be considered is what, my lord, the order says. Now, my lord, by virtue of the impugned order, my lord, passed by the tribunal, my lord, if it is in my favor, my lords, then, my lords, I would be very well be considered, my lord, to the grant in aid post, and, my lords, the grant in aid salary can be very well be extended to the respondent number 1, my lords. And, my lord, on earlier occasion as well, my lord, the respondent number 1 had submitted, my lord, to this honorable court memo along with that gazette notification, my lords, wherein it said, my lord, one-time concession should be given, my lords, to the teachers who are working continuously, my lord, in the institutions. Lord, age, my lord, is not a bar, my lords, for the release of grant in aid, my lords, salary, my lords, to the assistant teachers.
May make one more submission.
Yes,
Please.
My lords, one more submission.
Just one more.
Sorry, my lords.
When was grant in aid given to the school?
2007, my lords. That is,
In the year 2007 date?
please. 6/10/2007, my lords. So, my lords, my submission, my lords, from 6/10/2007 till 2008, my lords, he has not taken any steps, my lords, seeking, my lords, admission to grant in aid.
Your conduct as a school leaves much to be desired. Why should not we cancel your grant in aid itself?
Conduct.
610 admitted, you allege that 1/3/2008 till 31/3 is not, has been absent, and you dismiss him
That is, my lords,
within 4 months to make one more post for who you want.
that post is, my lords, anyhow reserved, my lords, by the
He has
government.
appeared for the interview. And you say that he has never admitted. You are the one who came in the way of him being granted, giving grant in aid post.
Fact, my lords.
And you are now saying, blaming it on the government.
You know, I'm not blaming it on the government, my lords. The fact is, my lords, that as on the date of the admission to, as on the date of notification for grant in aid, my lords, he was not eligible, my lords.
What he
He
is
had
not-
crossed the age limit.
That we have already told you what we think about it.
Please. Thereafter, my lords,
That's why we told you, you are put on notice.
please. But, my lords, since 6/10/2007 till, my lords, 2008, he has not taken any steps, my lords, for
You dismissed him on 31, when did you dismiss him?
3/2008, my lords. 31/3/2000.
8.
2008, my lords.
Yes.
Till such time, my lords, he has not taken any steps for seeking, my lords, admission to grant in aid.
He was waiting for you. Your recommendation had happened. Then you came in the way and said not to give him grant in aid.
Now, my
That
lords,
is why you approached the government. And then you dismissed him pending that.
my lords, alternatively, if I
We
may,
have put you on notice, we are cancelling your grant in aid.
that may,
Cancel is grant. This is not the way to deal with it. You are, just because you are a school management, doesn't mean that you ride roughshod over people's rights.
we have, my lords, his conduct is also to be, my lords,
We are more concerned about your conduct as the management of the school. What is his conduct? You are not able to prove anything before the EAT. Except to say that some parents have complained is one letter you gave as exhibit D2.
Please.
With the tribunal has categorically held, you have not been able to prove anything. Even the names of the parents you have not given. Forget leading their evidence.
Lords, in
You have
any-
set up everything.
Please, normal, one submission, Lords. Anyhow, my Lords, one post is already reserved by the government.
Why should that be now?
That
From
can,
2008 till now,
Please.
for 17 years, you have created havoc. You have been there for 17 years, good enough.
initially, my Lords, it has been, he's been litigating, my Lords. Initially, the appeal was, my Lords,
All because of you. All the litigation is because of you.
my Lords, in any event, my Lords, so, since the one post is already reserved. to the
Sorry, Mr.
government,
Badoli, you were put on notice.
or short accommodation, my Lords, day after tomorrow.
Nothing. Even now, if you are agreeable, we are not agreeable.
Like-
Petitioner is
My
before
Lords,
this court,
2 days notice, my Lords, because it,
seeking for the following.
the
relief.
question of other students and teachers is also, my Lords.
We'll shift them to another school.
My Lords,
You don't deserve
2
to be
days,
in
2 days
existence.
accommodation, my Lord. Or tomorrow, my Lords, if I may seek,
We'll direct you to pay 50 lakh compensation to him
that I'll seek instructions.
for 17 years.
As per the tribunal's order,
2 lakhs, 35 lakhs.
I'll advise them to comply with the tribunal's
Just
order.
a salary.
Now he's receiving meager salary of 4,000. They are receiving, my lord, 90,000 as per my instructions.
Yes, to?
Person who are on the grantee need, my lord, receiving 90,000 as on today, my lord.
90 na 19?
90, my lord.
90.
He's attained the age of superannuation. I'll, my Lords, seek instructions to,
No
my Lords,
problem.
I'll advise them to comply with the, my
The
Lords.
entire difference will be paid from your pocket, not from granting aid,
Please,
which you are trying to do now.
I'll advise them, my Lords.
4,000 you are getting.
Now I'm getting 4,000 per month.
I'll anyhow tribunal's order, my Lords, is
6,000 into 12 into 17.
tribunal, that is what the tribunal's order is, my Lords.
You'll have to pay from your pocket.
2 days time, my Lords, I'll instruct, my Lords, them to, my Lords.
Don't try to pressurize him and make him agreeable. If you agree for
Certainly,
anything,
certainly not.
you won't get anything less. If you agree for anything less, you won't get anything.
No.
It's 2 days time.
We were not agreeable to item 3 of the EAT's order. That we will set aside. Should not be from the government. Should be from your funds. Because of your conduct. A perusal of the
This is, my Lords,
documents-
even serial number 3, it doesn't direct the government, my Lords. It directs the petitioner,
That is not clear, we'll clarify it.
please.
Because
That's
the
what it
papers
says.
indicates that the petitioner school had been admitted to granting aid on 6/10/2007. And shockingly, immediately thereafter on 31/3/2008, the respondent number 1 was dismissed from service on account of being unauthorizedly absent from 1/3/2008 to 31/3/2008. Respondent number 1, having served the petitioner institution from the year 1990, 2 na 3 na?
1/6/1992.
1/6/1993,
1992.
92. It is only after the petitioner was admitted to granting aid that the above step was taken. The tribunal has also categorically come to a conclusion that the allegations made by the petitioner school against respondent number 1 was not established by the school. In that view of the matter, it would be for the petitioner to make payment of the salary due to respondent number 1 as per the scale of the granting aid from 6/10/2007 till date.
Please.
Learned counsel for the petitioner is directed to inquire and make a submission as to by when the said payments will be made. Interest would be made from and out of the funds of the petitioner school. Released on 17th February.
Please.
Please.
18th, 17th ಇಲ್ವಾ?
He is also some inquiries I am also.
18th, right.
Please.
ಅವ್ರು ಕೊಡ್ಬೇಕಾಗಿರೋ ದುಡ್ಡು ನಿಮ್ಗೆ.
because Kasturmata also may not be available on that day. I am also.
ಅಂದ್ರೆ ನಮ್ ಕೋರ್ಟ್ ಇಲ್ಲ ಅವತ್ತು. We are on holiday.
He told me yesterday.
So we'll also go on.
Blush.
4 Shivaswamy, Ram Prakash, yes. Shivaswamy,
ಏನಕ್ಕೆ ಇದು permitted to be withdrawn ಇದೆ. ಶಿವಸ್ವಾಮಿ ಇಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋರ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿರೋದು ಇದು ಬೆಂಗಳೂರಿಂದ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ ಇಲ್ಲಪ್ಪ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆ ಹೊಸ ನಂಬರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ
Not sir, I applied for petitioner in this case.
Your name has to be printed.
Not. Am I audible, madam?
ಹೇಳಿ
Not, I applied for petitioner in this case. I filed a NOC of Wakalat for petitioner, my lords.
Registry is directed to print the name of Shri Praveen S. Pattar and Vishwanath E. Kiresur as that appearing for the petitioner and delete the name of Shivaswamy and Ram Prakash A.S. as that appearing for the petitioner. Is it ready now?
My lords, a week's time may be granted, my lords.
The request of counsel for the petitioner released on 18th.
Please, my lords.
5 SR Hegde,
Please, my lord. It's mandamus, my lord, writ of mandamus. My lord, the petitioner's position has been regularized and patta has been issued in the 1976, my lord. Accordingly, as per annexure K and K1, my lord, representation has been given to the respondent authorities to survey the land and to enter the name of the petitioners in the concerned record of rights.
Where is the allotment letter?
My lord, annexure A to A15. ಹಕ್ಕುಪತ್ರ ಹಾಕಿದೆ ಎಲ್ಲರಿಗೂ.
And AGA accepts notice for respond number 1 to 4. CMC Sirsier,
ಲಿಂಗೇಶ್ ಕಟ್ಟಿಮನಿ.
Lingesh Kattimani is directed to accept notice for respond number 5. Petitioner is before this court seeking for the following reliefs. The petitioners, the possession of the ancestors of the unauthorized possession of the ancestors of the petitioner in RS number 55 of Sirsi was regularized while various Hakkupatra issued in the year 1986.
On submission, my lord. As per annexure M, my lord, it's covered by the one of the occupants already has been. So this honorable court has been page number 1828, my lord. Annexure M.
Page number
128.
128.
Positive reaction has been issued, my lord.
The petitioner having succeeded and made a representation on
My lord, there are two representations, my lord. Annexure K and K1.
ಬೇಕಾ ಪ್ಯಾರಾ ಅಲ್ಲಿ ನೀವು annexure
K and K1, my lord.
date ಏನು
Dated. My lord, one is 21/8/2017,
21
8/2017, and 26/12/2016, my lord.
at annexure K and K1 series for carrying out a survey of the respective plots, fix the boundaries and enter the names of the petitioner in the record of rights in column number 9 of the RTC. The same not having been done, the petitioner is before this court seeking for the aforesaid relief. Now, counsel for the petition submit that one other person whose possession was regularized had filed WP number 114763 of 2015, which came to be disposed by order dated 22/3/2019, and as such the said order would be equally applicable to the present case. A peril of the said order and the facts of the present matter indicate the same to be more or less the same. In that view of the matter, I pass the following order. Writ petition is allowed, a mandamus is issued, respond number 1, 2, and 3 are directed to arrange for survey of the land in question after notice to all concerned and take necessary steps for marking the boundaries and causing the entry of the names of the petitioner in the relevant, in column number 9 of the relevant RTC within a period of 6 months from the date of receipt of a copy of this order.
My lord, another similar matter ಇದೆ. This is the another similar matter with respect to same.
ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದೆಯಾ?
ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ.
ಮತ್ತೆ ಮೆಮೊ ಮೂವ್ ಮಾಡಿ.
Okay, sir.
6, Ravi Hegde.
Lord, the annexure K and L, my lord, the order passed on issue number 1 and 2. Both are under challenge.
There is no interim relief. Yaru, who is the respondent?
Lord, Kesad Prashant Osmani or
NWKRTC.
NWKRTC. NWKRTC.
Prashant Osmani. Shri Prashant Osmani is directed to accept notice for the respondent. Counsel for the petition served 2 sets of the petition along with annexures on said counsel released on 24th.
Seven, Vinod Shankar Pawar. Vinod Pawar.
Paso.
8, Srinivas Nadman.
My lord, petitions of the land users of Hidaka Dam with the project, my lord. There was a land was granted to the petitioner to cultivate the land, and as per the Annex B, some of the forest land were converted to due to the for the displaced person. As per that, Annex A to A4 was issued. Now the government, the petition was filed, a direction was issued to mutate the name. In the contempt, they produced a document saying that as it is a government, as a forest land, we cannot enter the mutation, mutate the land in the name of the petitioners. As per Annex L, I'm sorry, Annex M 85. The Tahsildar issued an endorsement saying that as per the forest department, the forest land, so we cannot enter the names.
85.
Yes, my lord. The next page, my lord, starting.
This forest land, how was it granted?
No, it cannot be, your lordship. When it will lordship enter in the record of rights, in the documents, forest land, it cannot be entered, your lordship, in the name of the petition that we have given the endorsement.
But how did the
Annex
Annex
B, my lord.
A series come to be issued?
Annex B, my lord.
Huh?
It is the government order saying that these
Annex D,
lands
page number ಹೇಳ್ಬೇಕಪ್ಪ ನೀವು Annex D.
page number 38.
38.
Type copy is page number 41, my lord. In the last para, my lord, 41 page, last para, this area of 3,225 has been inspected jointly by all departments, that is forest department, executive, so and so. The same is stated to have also been approved by the land grant committee members, consisting of MD, so and so.
Release of 3,225 acres.
In the some other persons who are also granted the adjoining land, my lord, their names are ordered to be mutated.
The land grant committee chose a forest land.
Yes.
Release of 5,522, 3,225
Yes, it
was
is
to be
there, Your
sought
Worship.
for.
To this petition also, it is,
Compensatory 5,522 acres, 552 acres was to be given. Yenaithu.
that, Your Worship, for other persons, Your Worship, it was granted as per that, Your Worship. But to this, Your Worship, it is an endorsement issued that it is forest land, Your Worship, so it was rejected.
Now, what happened to de-reservation of 3,225 acres? And compensatory allotment of 5,552?
I have to get information.
My lord, next the Tahsildar issued a revenue inspectors.
Minister's notice for respond number 1 to 7. He is called upon to get instruction, make a submission. The actions taken pursuant to Annexure B, being the direction issued by Divisional Forest Officer, Belgaum Division, on 18/11/1975.
Right.
An affidavit of respond number 6 to be filed in this regard by the next date as to whether 3,225 acres have been de-reserved from forest and 5,552.27 acres and alternate land has been made available for forestry purposes.
Right.
List on 18th.
Right.
9, Prashant Pasmani.
So the petitioner, my lords. Petitioner, my lords, NWKSRTC. The workman, my lords, had filed an application under 33C2, lords, claiming interest on delayed payment of leave encashment. This issue, my lords, whether he can file such an application with 33C2 directly in the absence of any award, lords, already settled, because 33C2 is only an executing provision. The court exercises its executing powers. Since there is no prior award or settlement, in the absence of any award judgment. There are 11, my lords. Similar issue, my lords, where the employees, my lords, retired employees that directly approached this honorable, approached the labor court under 33C2. The court holds that this application is not maintainable. Lords may kindly see, after my lords referring to the judgments, para 17. My lords may kindly see it, para 16, the reasonings there, my lords, para 16.
Issue notice to respondent returnable by 18th March in view of the order date 15 December 23 in WP number 102544 of 2023, more particularly para 16 thereof. The operation of the order date 14/12/23 passed by Additional District and Session Judge Gadag in application number 12 of 2017 at Annexure A is stayed till the next date of hearing. Process fee and copies to be furnished by end of day 12th February, failing which the interim order will stand automatically vacated.
10, Kelpati, SS Betturmat.
Property of the petitioner was acquired for the purpose of finding of road, my lords. Portion of the property was covered, acquired by the respondent authorities.
Interim relief enilla.
Ill. Covered by judgment, my lords, it may be taken. Respond number 1 and 2, government, my lords.
And AG accepts notice for respond number 1 and 2.
Respond number 3, VM Shilwan.
3 VM Shield 1.
Shilwan, my lords.
4
4 and 5, CV Angadi, my lords.
CV Angadi 4 and 5.
6, B Sharanabasu.
V Shanabasava for respond number 6. Counsel for the petitioner to furnish 2 sets of the petition along with annexures on the said counsel, relist on 18th.
Please.
11, Raja Raghavendra Naik.
The petitioners, my lord, the petitioner number 1 has donated the land to the my lord for establishment of a school at Hirebedarkal village, Yelburga Taluka. Now, my lord, the deputy director of education at Koppal, my lord, sent a proposal, my lord, with respect to our own landed property for 4 acres for acquisition for, my lord, the construction of a high school. And my lord, as per the notification, immediately after issuance from the Hyderabad Karnataka Development Board, Some of the villagers themselves have given a letter to the department saying that our land may be acquired. But the assistant commissioner and deputy commissioner and DDPI, they are, my lord, initiated, my lord, immediately process with respect to, my lord, acquisition. Kindly see, my lord, where the letters were, firstly, my lord, the annexure C. Annexure C is the, my lord,
You already given 9 acres, 35 guntas.
no, my lord, in 35 guntas, 35 guntas of land is given to, donated by me, my lord, petition number 1, to the establishment of school at that village, my lord. Later on, now, my lord, the notification is issued by the government of Karnataka for, my lord, a high school in that area at annexure C, my lord. And immediately, my lord, the annexure D, where the villager by name, my lord, the letter is annexed herewith, where, my lord, they have given a letter that our land may be taken as 4-acre land for acquisition.
But where is that land situated?
Please, my lord.
Next to this 35 guntas or further?
Next to this 35 guntas itself, our land is there. Annexed.
ಇವಾಗ ವಿರೂಪಾಕ್ಷಪ್ಪ
ಅಲ್ಲ your land ಇಲ್ಲ this land is not with respect to adjacent to that school. ಅಲ್ಲ but my lord, when I have donated my land for 35 guntas of school, now my lord, again they are asking to my
May I
land
make
and
a
property
submission?
only, my lord.
The next is the lordship, it is a premature. Now he cannot question at this.
Premature ಅಲ್ಲ because they have initiated and my lord, their objection is filed by me and my lord,
Can consider their objections only. They
ಇನ್ನ
cannot question.
acquisition notification ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ ಅದು. It is only
ಅವರು
premature, your lordship, he cannot.
because annexure G
Proposal stage ಅಲ್ಲಿ ಇದೆ.
proposal ಆಗಿದೆ, ಆಮೇಲೆ they say that they have issued a letter at annexure G, my lord, at page number, my lord, 36.
Can't be challenged now, Mr. Naik.
Because they say that, my lord, ನಿಗದಿತ immediately ಉಲ್ಲೇಖ ಪ್ರಸ್ತಾವನೆ ಅಡ್ಡಗೊಳಿಸಿ ಕಳಿಸುತ್ತ ಹೊಸ ಭೂ ಸ್ವಾಧೀನ ನಿಯಮಾನುಸಾರ
And
ಪರಿಶೀಲಿಸಿ.
AGA accepts notice for respond number 1 to 5.
Please.
Petitioner is before this court seeking for the following reliefs. What is being challenged is a proposal to acquire the land of the petitioner, which is still pending consideration and no orders have been passed. The submission of learned counsel for the petitioner is certain other villages have come forward to make available their land,
please,
for use as a school. If that be so, it would be for the respondents to consider the same and pass necessary orders on the said representation and the proposal in accordance with law. The petition being premature cannot be considered now and is as such disposed.
Please.
12, Srinam Sachapure.
My lords, petitioner is challenging the preliminary and final notification, my lords. Though these notifications, my lords, are of the year 2013 and 15, till date, my lords, possession was not taken over. My lords, the emergency clause under section 17 of the act was invoked, my lords, but till date, my lords, possession is with the plaintiffs. No notice was issued, my lords, and my lords, only on Friday.
Town Development Authority ಯಾರು? ಅಪೇರ್ ಆಗಕ್ಕಾಗತ್ತೆ ಆಗ್ತಾರ GK Hiregold. Who is the standing counsel for 3 and 4?
Special
Balkote.
Bagalkote town.
And AGA accepts notice for respond number 1 and 2. Shri GK Hiregold is directed to accept notice for respond number 3 and 4. Counsel for the petitioner served 2 sets of the petition along with annexures on the said counsels. Released on 18th.
My lords, may I request, my lords, for a stay of
2013, how can we
my lords, my lords, along with this memo, I am producing the photographs, my lords, to show that on Friday, my lords, they started, my lords, trying to take possession high-handedly, my lords. A complaint was also lodged. But they said unless there is an order from this honorable court, nothing can be done, my lords.
You are challenging a acquisition of 2013 now.
Lords, but that was without notice to these petitioners.
Respondents are restrained till next date from taking any coercive steps.
Please, my lords.
13, Sabil Ahmad.
Writ of mandamus seeking, my lord, dispose of the FDP year 2017, my lords. My kind request is that, my lord, page number 194 may kindly be perused, the typed copy of the order sheet, my lord. Though the respondent number 2 to 6 are not related to the family of the petitioner, not related to the property in question, my lord, their third occasion, they filed, my lord, including application, the same was rejected, my lord. Subsequent to that, my lord, they filed a suit, my lord, decree is not maintainable, my lord. The suit was partly decreed and went in RA, my lord. The same was dismissed and confirmed, my lords.
So then there have been proceedings which are happening.
Not at all, my lord. My lord, the trial court, my lord, heading towards the matter day by day, my lord. Not to disposing the FDP, my lord. Though it is filed in the year 2017, my lords.
Yes, but because there were other proceedings which were there and which were pending.
No, my lord, no proceedings are pending with respect to the same, my lord.
RA ಅಲ್ಲಿ time ಆಯ್ತಲ್ಲ.
But as per the Annex JRL, my lord, this court circular, my lords, they have
RSA copy was received on 15/4/24.
no stay order was by this honorable court, my lords.
Yes.
Three consecutive time, my lord.
There has been application. We can't direct like that, Mr. Sabir.
Three,
If there are applications filed, that will have to be
three
considered.
consecutive times, my lord, the same court, my lord, rejected the impleading application, my lords.
Yes.
It's my kind submission
For
to
the
this
court
court,
to
my lord.
pass orders, we can't
Please.
direct mandamus on that basis.
Annex JRL may kindly be, my lords.
Is before this court seeking
Lords,
for the.
Annex JRL
following
for a
relief.
moment, my lords.
Notice to the respondents is dispensed with in view of the proposed order to be passed. What is essentially sought for by the petitioner is for a direction to the second additional senior civil judge Ballari to dispose of the FDP proceedings in FDP number 9 of 2017, which is stated to be pending from the year 2017. A perusal of the order sheet indicates that there have been several applications which have been filed, which have been considered by the FDP court and orders passed. Hence, no fault could be found in the FDP court for the proceedings to have been pending for till now. The FDP court would pass necessary orders in the said proceedings on the basis of the application which have been filed, since those would also have to be considered. As such, I do not deem it fit to issue any direction in the present matter. Petition stands dismissed.
Please, your lordship.
14, Shivraj Balloli, please.
Lords, the judgment debtor is before your lordships. Judgment debtor, my lords, is a city municipal council, my lords, Hospete. There was a decree, my lords.
TMC is the judgment debtor.
Please, my lords.
You don't have money.
No, my lords, this is
Suit for?
suit for, my lords, permanent injunction. Decreed, my lords, decreed on, my lords, 14/10/19, sorry, my lords, 9/4/1986. At that point of time, my lords, it was town municipal council, Amravati, my lords. Now it has been upgraded as city municipal council, Hospete.
Yes.
Lords, my only submission is the impugned order is passed by the my lords, executing court. Arriving at a conclusion that, my lords, the petitioner has willfully disobeyed, my lords, the decree of permanent injunction, and as such, my lords, has directed for attachment of movables of the petitioner. My only submission is, my lords, from what it can be gathered from the records, my lords, is that as at the relevant point of time when the original suit was filed by the, my lords, decree holder, my lords, there was a culvert which was, my lords, constructed on the decree holder's property. Now, my lords, the observation made by, and that, my lords, at that point of time, the town municipal council, Amravati, was restrained, my lords, from carrying out any construction over the petitioner's property, otherwise than in accordance with law, my lords. Now, my lords, the decree holder again alleges that, my lords, the present CMC, my lords, is attempting to, my lords, widen the road without due process of law. There is no finding by the, my lords, executing court.
What is your statement? You are not interfering.
My lords, we are under the impression that it is a culvert and public road.
That means you are interfering. Your
Lords, but
impression
now, after, my lords,
contrary to the orders passed.
my lords, it was then Amravati town municipal council.
Owned
Now,
by it.
I understand, my lord, I agree.
Will dealing from whatever your CM.
No, my lords, I agree. We are bound by it, my lords. I'm not denying that. Now, my lords, my submission is, we will not, my lords, interfere with the.
Why did you interfere?
Lords, there was officers would change, my lords. They would have not, my lords, decree would have not come to their light. Subsequently, my lords, after.
Is that a submission you are making, Mr. Badalli?
From TMC Amravati, it has been upgraded to CMC Hospete.
EP 10 of 90, now we won't interfere. You have persisted in the EP saying there's a culvert and it's our culvert and we are doing what we are required to do.
No, we had only attempted. We have not done anything, my lords. That was under the impression that it is a culvert, my lords, of.
Even after having been brought to a notice, why did you not just tender an unconditional apology and close it? Why did you litigate it for last 6 years?
It was. My lords, I'll,
This kind of
my
things we'll
instructions.
deal with it very
My
strongly.
instructions are that, my lords, we are not going to interfere. And if your lordships, my lords, direct, we will also file affidavit, my lords, to the
We'll
said
direct
effect.
the CMC will come under DMA.
Please, my lords.
We'll direct the DMA to take action against the
We
concerned
will
officers for having
Lords,
violated.
there is no willful disobedience.
For the DMA to verify.
Even the order passed by the executing court, it is, my lords, clear that there is no willful disobedience. My lords, willful disobedience would be, my lords, when I know that, my lords, this is the order, and my lords, despite my lords being aware, I am doing it.
2019, when it had been filed, you should have just gone and said.
Thereafter, we have not done anything, my lords. Thereafter,
apology kottidira.
We'll tender apology.
You tried to defend it.
But it's in my.
It was brought to your notice that there's a decree. You should have challenged it. A decree may be right, may be wrong.
And
the decree is a decree. You have to follow. You can't say.
I'll file, my lords, undertaking that, my lords, without due process of law, we will not. I mean, we will not interfere with the petitioner's possession.
We'll direct an inquiry by the DMA into your offices.
Already
No
they have
point in-
formed a road, my lord.
They have formed a road.
Yes, they are utilizing.
The photographs.
Yes, I will take photographs. Photographs are there.
This is not. As per my instructions, we are not using it.
We have requested to, under due process of law, you can acquire the land, but they are not ready to acquire the land.
As per
Now,
my.
the photographs at presently I don't have, my lord. I will secure it. I have produced paper.
Then there won't be any.
I did not have any instructions on this, my lords. I'll seek instructions as per my instructions, my lords.
Finding in Dharwad, every authority is trying to take the land and form a road or maybe for public purpose.
But it has to be in accordance.
Acquiring.
It has to be in accordance.
Acquire it and do it. Pay them the compensation. Then it's not, let us not use the words.
I'll seek instructions, my lords, on.
Respond, give it a response, submit that the petitioner has high-handedly formed a road. She seeks bond, is granted a week's time to place the photographs on record. Relist on 18th.
Please.
Please.
I'll also secure instructions.
Secure instructions.
15, Mallikarjun Swami. Hirema.
The petitioner. The petitioner's application seeking conversion of the land was rejected. Lords were pleased to pass an order on 29/1/2025, directing the government to secure the file pertaining to the order, since no reasons were assigned for rejection. On 6/2 again, time was sought.
Application number 624059.
Yes. Tomorrow, Your Lordship. Tomorrow, file is not traceable.
And AJ seeks for 2 days' time to comply with the order dated 29/1/25. If the same is not complied by 13th, the second respondent shall be personally present before this court. Relist on 13th at 2:30 PM.
Please.
16, Venkatesh Karvik.
2:30.
So dependent petition, my lords, application filed under for framing additional issues is rejected by the trial court, my lords, in page number annex E, my lords.
Suit for?
Suit for, my lords, declaration, my lords. Declaration and injunction.
Where is the first set of issues, early?
My lords.
First set of issue, Annexure C.
Annex E, my lords, I file application for additional issues. The suit is barred by limitations. I specifically taken in my written statement, my lords, in page number.
Page number?
All, my lords.
Written statement, early?
One mission, written statement, my lords. Page number, but Para number 8 of the written statement, my lords. Para number 8 of the written statement. The cause of action shown in the para number 6 of the plaintiff is not proper. The plaintiff have no cause of action to file the suit because the defendant have constructed the building in their property after due permission.
You said it is barred by limitation.
That was not word, my lords, but the compound wall between the property of the plaintiff and defendant since 1986. So now by 2013, my lords, they have filed the suit for declaration. claiming that property.
The plaintiff himself illegally and high-handedly put up the structure on the compound wall.
Yes, my lord, compound wall. And there is no cause of action to file the suit as claimed by the plaintiff. So
No
here,
cause
my
of
lords,
action go no limitation go
my
bada
lords,
vyathyasa
I
ಇದೆ.
have filed a suit on my lords 2013 for injunction.
Where's your application?
That is, application is, my lord,
Suit is barred by limitation.
application on party I number 21, my lords. Application under order 14 rule 5 read with section 151 CPC. In a specific pair number 3 of the, my lords, my affidavit, I state the plaintiff has filed the suit for declaration of mandatory injunction against the defendant. Defendant number 4 has specifically taken content pair number 8 and 12 of the written statement that subject matter suit is between the construction of compound wall. As per the written statement, that compound wall constructed on 1986. The suit was decreed on 1990. Earlier, I have filed suit against the same party, my lords, 1990, my lords. And it was decreed, my lords, that we have owner of the property on this front. Subsequently, my lord, we have took the permission in 2013. So then after he abstracted to the possession of the property, my lords. So as per the, my lords, I have produced the evidence also.
Their construction is RCC building has been
RCC
put up.
building,
Your
mane-
contention is
under
compound wall.
open plot ittu.
RCC building go compound wall go ವ್ಯತ್ಯಾಸ ಇದೆ.
ಅಲ್ಲ ಓಪನ್ ಪ್ಲಾಟ್ ಇತ್ತು, ಅದನ್ನ ತೆಗೆದು RCC ಬಿಲ್ಡಿಂಗ್ ಮನೆ ಕಟ್ಟಿದ್ವಿ.
ಹಾ.
ಸೊ ಆ ಮನೆ ಬಾಜುನೇ ನಮ್ದು ಅವ್ರ ಪಶ್ಚಿಮಕ್ಕೆ ಗೋಡೆ ಇದೆ, ಇಬ್ರದ್ದು ಮನೆಗಳ ಮಧ್ಯದಲ್ಲಿ ಗೋಡೆ ಇದೆ. ಸೊ ದೇ ಹ್ಯಾವ್ ಪುಟ್ ಅಪ್ ದ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆನ್ ದ ವಾಲ್, ಮೈ ವಾಲ್. In between that compound wall, there was a compound wall, my lords. If they have to file the objection on 1993 ಅಲ್ಲಿ ಮಾಡ್ಬೇಕು, that a suit was in favor of me on 1990.
ನೀವು ಸರಿಯಾಗಿ ಅದೇನ್ ಅವರ್ಮೆಂಟ್ ಏನ್ ಮಾಡಿಲ್ಲ.
ಅವರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅಂದ್ರೆ ಪ್ಯಾರ್ ನಂಬರ್ 8 and 12 ಅಲ್ಲಿ ಅಷ್ಟೇ ತಗೊಂಡ್ವಿ ಸರ್.
ಅಷ್ಟೇ.
In pair number 12, my lords. 12 also, my lords. The suit is
No cause of action.
only bar by limitation ಅಂತ ಬಂದಿಲ್ಲ, but cause of action on the compound wall on 1990, my lords. So trial court given a finding that is on 2013. Earlier to that, my lord, we have filed.
Garvi, your contention is that you are not encroached on any portion of the property.
We have not encroachment. They have encroached my property, my lords.
Their contention is you have encroached. Your contention is you are not encroached. For you to claim limitation, you should first say that I encroached it 12 years ago. As admission ಬರಬೇಕು. ನೀವು admission ಬರಲಿಲ್ಲ ಅಂದ್ರೆ no cause of action correct ಆಗಿ ಹೇಳಿದ್ದೀರಾ.
ಪ್ಯಾರದಲ್ಲಿ ಬಂದಿಲ್ಲ.
ಅದು ಬರಕ್ ಸಾಧ್ಯ ಇಲ್ಲ because it would be
ಅಲ್ಲ ಅದರಲ್ಲಿ ಏನಾಗಿದೆ,
contradictory.
On 1990 we have 1986 we have filed a suit against the same party, my lords. That is earlier vendor, my lords.
Limitation ಬರಲ್ಲ. Your contention is you are not encroached.
I have not encroached, but so they have put up the structure on my that compound wall between the both parties.
Barred by limitation ಯಾವಾಗ ಬರುತ್ತೆ?
So
when you accept that you have encroached.
Yes, yes.
Barred.
Please.
After 12 years.
Please.
ಇವಾಗ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ accept ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ ನಾವು ಮಾಡಿಲ್ಲ. ನಾವು ನಮ್ಮ ಜಾಗದಲ್ಲಿ ನಾವು ಕೊಡ್ತಾ ಇದೀವಿ.
Petitioner is before this court seeking for the following reliefs.
Then I withdraw the petition, my lords. Please.
After arguing for some time, Shri Venkatesh Karvi, learned counsel for the petitioner, seeks permission to withdraw the above petition. Accepting his submission, petition is dismissed as withdrawn.
17, Srinand Pachapure.
In this matter also, the deputy commissioner rejected the application without assigning any reason for conversion. Last occasion, they were 2 times they was short time to take instruction.
Hence, your reconversion application is rejected.
Online endorsement only.
As per the order of Assistant Director, Your Lordship, it was rejected. That Your Lordship, he has given the opinion that Your Lordship, the to which local body, Your Lordship, it is not relating. It was not clear. On that basis, Your Lordship, he recommended for rejection of the.
If it is not clear, you should ask for clarification. You can't reject.
Otherwise, reconsider and model.
Rejection ಹೆಂಗ್ ಬರುತ್ತೆ?
Because Your Lordship, he could have called them, Your Lordship, to furnish the relevant.
Submission is not clear, hence rejected.
Even the Tahsil also, Your Lordship, recommended for a conversion.
The petitioner is before this court seeking for the following reliefs. The grievance of the petitioner was that the deputy commissioner has rejected the application for the conversion of the land of the petitioner without any reasons in terms of Annexure A. Hence, the learned AGA was called upon to obtain instruction, make a submission if any reasoned order has been passed. Today, the learned AGA submits that the deputy director, Yaru?
Nippani, Your Lordship.
Deputy Director, Town Planning.
Town planning, Nippani, Your Lordship.
Nipani had opined that it is not clear as to which planning authority the application related to. And in that background, the Deputy Director Town Planning had recommended the rejection of the application. And as such, the respondent Deputy Commissioner has rejected the application. Such a reason and action is unknown to law. If at all the Deputy Director Town Planning was not aware and or from the application it was not clear as to which town planning authority the application related to, a clarification could have been sought for from the petitioner. Be that as it may, when the survey number, the village, taluka and district details have been furnished by the petitioner, the Deputy Director of Town Planning could have always ascertained from his records as to from in which town planning authority the said land falls under. Hence, the recommendation made by the Deputy Director Town Planning is not capable of being sustained and as such is rejected. In that view of the matter, I pass the, furthermore, the Deputy Commissioner could not have, on the basis of such a recommendation, reject the application of the petitioner without any reasons being provided. The endorsement at Annexure A under the heading reasons only indicates inverted commas, hence, comma, your reconversion application is rejected, inverted commas close. And the earlier reference is made that the application has been rejected on 11/28/2024 at 11:01:39 AM. It is but required for any authority rejecting an application to provide reasons and for the said reasons to be also uploaded onto the online portal in which the online application has been made for conversion. None of them having been done and a barred rejection order passed, I pass the following order. Writ petitions allowed. A certiorari is issued. The endorsement dated 28/11/24 issued by respondent at Annexure A is quashed. The matter is remitted to the respondent for fresh consideration in accordance with law. If there are any clarifications required, the respondent would be free to cause such clarification from the petitioner. The Principal Secretary, Revenue Department, is directed to instruct all officers coming under his jurisdiction to upload the reasons for rejecting any application filed by a citizen using the online platform provided by the Revenue Department. A compliance affidavit to be filed in this regard within 4 weeks from now, that is on or before 14th March. Though the above petition is disposed, relist on 19th March for consideration of the affidavit of the Principal Secretary. Registry is there, print, AG's name is there.
But one submission. Annexure D is the transaction report. The Taluka case worker, Tehsildar, Revenue Inspector, the Deputy Commissioner case worker, ADC recommendation, all have approved, my lord. Only Deputy Commissioner rejected.
Tahsildar also
All
recommended.
files are cleared, unnecessary, my lord.
Tahsildar also recommended for.
And
the action though.
and this property is in Hukeri, my lord, Hukeri Taluka. They say that Nipani Bharathan.
Even in my records also, Tahsil also recommended for conversion.
Yes, certainly. The only reason why they are passing this orders is clear.
Only assistant director has recommended, it was rejected.
Surrounded properties all converted, my lord.
Within 15 days, remitted for that.
Please.
18, J. Shetty.
Appearing for the
Yes, Mr. Shetty.
petitioner. Plaintiff's writ petition. Suit is for my lord, declaration that he has got the right up way and also for grant of injunction. My lord, in fact, there is one typographical mistake, my lord, has been kept in the plaint. My lord, instead of mentioning, my lord, the year as 1974 at para number 5 of, my lord, the plaint, it is mentioned as 1967. That one to Malad, he wants to make a correction to that.
ಅದು ಕರೆಕ್ಷನ್ ಮಾಡೇ ಫೈಲ್ ಮಾಡಿರೋದು.
ಇಲ್ಲ ಇಲ್ಲ ಅದ
ನೋಡಿ ಪೇಜ್ 23.
ಇಲ್ಲ ಫಸ್ಟ್ ದಟ್ ಈಸ್ ದಿ ಇನಿಷಿಯಲ್ ಫಸ್ಟ್ ಅದ ಆಮೇಲೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಒಂದು ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲಾರ್ ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲವಾಯ್ತು, ಹಾಗಾಗಿ ಅದನ್ನು ಇದು ಎಲ್ಲವಾಗುತ್ತೆ ಅಂತ ಹೇಳಿ ಕರೆಕ್ಷನ್ ಮಾಡಿ.
In stage ಏನಿದೆ ಸೂಟ್? What is the stage of the suit?
It is posted for now the dependents evidence has also been over.
Arguments.
So Malad, this unless Malad, this in fact exhibit P6 Malad has been produced with that the agreement is of the year 1974 only. It is allowed to Malad produce the documents. Now if it is not corrected, there will be a variation of plenty pleadings and evidence Malad. That's the on that count cannot, his right will be debated.
ಕಬೂಲಿ ಪತ್ರವು 1974 ಅಂತ.
74 ಅಂತ ಹೇಳಿ ಇದೆ ಆಕ್ಚುಲಿ 74 ನಲ್ಲೇ ಮಾಡಿರೋದು. ಕಬೂಲಿ ಪತ್ರನ ಹಾಜರು ಮಾಡಿದ್ದೇವೆ. But by mistake Malad, in the plaint Malad, it is mentioned as 1967. In fact,
Where is the written statement relating to
written statement Malad, the filed by the other side Malad at page number.
para
They
file
denied.
ಬಗ್ಗೆ?
They have denied. In fact, the originally property belongs to the same person.
What do they say as regard para 5?
ಯಾವ್ದು?
657.
They denied Malad everything.
They denied the Kabuli Patra.
Yes.
Where is the Kabuli Patra?
Malad, page number 32. Malad, Kabuli Patra has not been produced, but it is.
Shows the Kabuli.
Malad, I will read it.
It's been marked in evidence.
In fact, Malad, the one owner sold it in favor of the plaintiff as well as the dependents. So far as this property is concerned, there is a right of way to go to the property, land belonging to the petitioners. That has been accepted by the original.
Date.
Last ಕೆಳಗಡೆ ಇದೆ 23/2/1974. 74. That is marked, Malad, in fact, without any objections. And Malad, the difficulty, Malad, is that 1967 until by mistake, Malad, it was.
Issue notice to the respondents returnable by 15th April. The further proceedings in OS number 93 of 2015 pending on the file of the civil judge and JMFC Biadgi is stayed till the next date of hearing. Process fee and copies to be furnished by end of day 12th February. Acknowledgement of service on the respective counsels for the respondents to be filed on or before 17th February. Failing either of which, the interim order will stand automatically vacated.
19 Abjit Konkar.
Lords, on behalf of petitioner counsel is out of station. Lords, may I request any date on the next week? The petitioner counsel is out of state. Lords, I request a date for next week.
But he sought for correction of the survey number, Your Lordship. Whether in earlier petition, Your Lordship, whether he has mentioned the correct survey number, I cannot.
Learned AGA accepts notice for respondent 1 and 2 counsel for the petition served 2 sets of the petition along with annexures and said counsel. Relist on 21st February.
Obliged.
20 Vijay Kumar Faratti.
Petitioner challenge annexure G is the impugned order, whereby my lord, miscellaneous filed for restoration of the suit has been allowed. Earlier, my lord, the present petitioner filed a suit for specific performance contract on the basis of the agreement of sale said to have been executed by the respondent's husband. What the agreement of sale was executed on 30/3/2016. In pursuant that, since he did not perform his part of contract, suit was filed, and in the said suit, my lord, he appeared. Defendant appeared, but he didn't file WS. In pursuant that, suit was decreed, and my lord, the entire amount was paid, and the sale deed has been executed through a court commissioner. After decreeing of the suit, my lord, the wife and children after
Sale deed has been executed.
Sale deed executed through court commissioner. And after delay of 2 years, 9 months and 15 days, my lord, the wife and children file a miscellaneous for restoration of that suit. Now that is allowed, and it has been remanded back for continuing the suit. Said it, my lord, it has been executed. And even entire amount I have paid. 12 lakhs has been paid.
When did the husband expire?
Not, sir. On 22/2/2020.
22 to after the decree.
After decree, my lord. He was well aware, and even, my lord, the wife was well aware as to regarding the present proceedings going on. She says that, my lord, she was staying in her parental house. She was not aware of all those proceedings going on.
Where is the reference to the date of his death?
Please, no.
Reference to the date of his death,
Death in her, please, in her petition only. Page number 45. Page number 45. It is a petition filed by respondent in fourth para, last line.
He
The
expired on
defendant,
22
and during the treatment, he expired in the hospital on 22/2/2020.
Issue notice to the respondents returnable by 16th April. The order dated 2/12/2022 passed in mistakes number 1 of 21 by the senior civil judge Bailongal at Annexure G is stayed till the next date of hearing. Process fee and copies to be furnished by end of day 12th February. Acknowledgement of service on the counsel for respondent before the trial court to be furnished by end of day 17th February, failing either of which.
21, Dayanand Bandi.
Lord, the land in question is 4 acres of a land adjoining National Highway number 63 comes within the city limits of Ballari, my lords. So my erstwhile owner, that is in the year 2003, had applied for a conversion of a land from agricultural to non-residential purpose. My lord, though the land measures 4 acres, my lord, only 3.75 acres was permitted, ordered to be converted, and 0.25, that is 25 cents, which is adjoining a road, is reserved for a road development. So, my lord, after in the year 2013, after 10 years, I purchased this property and I again applied for a conversion of land from residential to commercial. Again, my lord, only 3.75 is converted and 0.25 is reserved for a development of a road. Then, why Lakshmikant Reddy, my lords?
And AGA accepts notice for respond number 1 and 2. Shri Y. Lakshmikant Reddy is directed to accept notice for respond number 3. Counsel for the petitioner to serve 2 sets of the petition along with annexure on the said counsel released on 18th February.
My lord, the preliminary hearing.
Bharat?
My lords, because very short point.
22-8 taken as nil. Plaintiff arguments on 4-9-23, 6 adjournments. Thereafter, IA 12-113 came to be filed.
Lords,
After 6 adjournments after the matter being
Lords,
posted
out
for
of
arguments.
6 adjournments, my Lords, DW1 was absent for 3 occasions, my Lords.
And it was allowed at 300 rupees.
Ah.
And thereafter also you did not cross-examine.
Thereafter, my Lords, what
Again,
happened
it
is,
was,
thereafter one adjournment was given, my Lords, and thereafter on the next occasion, my Lords, what happened is the advocate took his father to the dialysis, my Lords. The same was, award in the
you have taken
content of
12
the affidavit.
adjournments. Don't keep on saying dialysis. Nobody appeared also.
My Lords,
What document have you produced to show that you have taken him for dialysis?
my Lords, the advocate's father, the advocate was absent, my
The
Lords,
document.
plaintiff was present, my Lords.
Show us a document.
My Lords, affidavit we have filed, my Lords, on,
Show us a document, Mr. Counsel.
Lords, on the next occasion.
ಇದು ಇಷ್ಟು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಸ್ ತಗೊಂಡ್ಬಿಟ್ಟು ಒಂದಿನದ್ದು ತೋರಿಸ್ಬಿಟ್ಟು ಹೇಳದದ್ದು ತೋರ್ಸೋದು ಇಲ್ಲ.
My Lords,
ಇದೆಯಾ ಡಾಕ್ಯುಮೆಂಟ್ ಏನಾದ್ರು ಇದೆಯಾ ಹೇಳಿ.
my Lords, on the next occasion I will produce the document.
Counsel for the petitioner after argument seeks for and is granted a week's time to produce
My Lords,
necessary documents to indicate that the counsel for the petitioner had taken his father for dialysis on the concerned date, that is, ಯಾವ date?
15/3/24, my Lords. 15/3/24.
15/3/24.
Lords,
Released on 18th.
Lords, pending it's a writ of petition.
You will produce it tomorrow?
Lords, kindly.
Yes, tomorrow.
My Lords, the trial court is hurrying with the
So
arguments.
WhatsApp ಅಲ್ಲಿ ತರ್ಸ್ಕೊಳ್ರಿ.
We'll produce tomorrow, my Lords.
Tomorrow.
Please.
24, Harsh Desai.
Yes, Ms. Desai.
Lord, the procedure, my lord, established statutorily under the new Land Acquisition Act is not sought to be, my lord, changed or diluted. The role of the Special Land Acquisition Officer with regard to payment of compensation, my lord, is now sought to be changed, and Karnataka Niravari Nigam, my lord, must directly make the payment by way of letters and circulars.
How does it matter?
My lord,
You need only compensation.
yes, my lord, if it is not paid.
Who is not paid?
No, if it is not paid, my lord, I will have to run behind the Niravari Nigam, whereas the act, my lord, mandates that it is the land acquisition officer. My lord, the role of the land acquisition officer is not just to acquire the land, my lord, but also adjudicate and ensure that just compensation is paid to the land losers. Now, if it is Niravari Nigam, and my lord, it can lead to an arbitrary situation where I will be, my lord, forced to go and appear before the Niravari Nigam, and if I have to, my lord, sue, it is not a statutory authority, my lord, I will.
But you have to appear before it will be SLAO who will have to pay, do everything.
Yes, my lord.
The amount will come from KNNL.
My lord, if
Disbursement by SLAO.
no, that is why, my lord, on page 58, your lordships may kindly see.
58. Yes.
The third ಭೂ ಪರಿಹಾರ ಮೊತ್ತವನ್ನು ನೇರವಾಗಿ ಫಲಾನುಭವಿಗಳಿಗೆ ಬ್ಯಾಂಕ್ ಖಾತೆಗೆ ವರ್ಗಾಯಿಸುವುದು ಮತ್ತು ಭೂ ಪರಿಹಾರ ಅನುದಾನವನ್ನು ಪಿಡಿ ಖಾತೆಯಿಂದ ಅಧಿಕಾರಿಗಳ ವೈಯಕ್ತಿಕ ಬ್ಯಾಂಕ್ ಖಾತೆಗೆ ಜಮಾ ಮಾಡುವುದು ನಿರ್ಬಂಧಿಸಲಾಗಿದೆ. And then, my lord, this acting upon this, your lordships may kindly come to the previous page, my lord.
Yes.
This is by the state government. ಕರ್ನಾಟಕ ನೀರಾವರಿ ನಿಗಮ ಅಧೀನದ 16 ಭೂ ಸ್ವಾಧೀನ ಕಚೇರಿಗಳಿಗೆ ಮತ್ತು 2 ಉಪ ವಿಭಾಧಿಕರ ಕಚೇರಿಗಳಿಗೆ ಮುಖ್ಯ ಲೆಕ್ಕಾಧಿಕಾರಿ ಕರ್ನಾಟಕ ನೀರಾವರಿ ನಿಗಮ ಧಾರವಾಡ ಇವರ ಹೆಸರಿನಲ್ಲಿ ಲೆಕ್ಕ ಶೀರ್ಷಿಕೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಭೂ ಸ್ವಾಧೀನ ಪರಿಹಾರ ಮೊತ್ತವನ್ನು ಪಾವತಿಸಲು ಹೊಸದಾಗಿ ಪ್ರತ್ಯಕ್ಷ ವೈಯಕ್ತಿಕ ಠೇವಣಿ ಖಾತೆಯನ್ನು ಖಜಾನೆಯಲ್ಲಿ ತೆರೆಯಲು ಈ ಕೆಳಕಂಡ ಷರತ್ತುಗಳನ್ನು ಮಂಜೂರು ಮಾಡಿದೆ. ಮಹಾಲೇಖಪಾಲಕರ ಅಧಿಕಾರ ಪತ್ರವನ್ನು ಪಡೆಯುವುದು. And my lord, as I read out, and the next one, my lord, is by the Niravari Nigam. It forms a committee. And your lordships may kindly see ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಿತ 5ರ ಸರ್ಕಾರದ ಆದೇಶ ಭೂ ಸ್ವಾಧೀನ ಪರಿಹಾರ ಧನ ಬಿಲ್ಲುಗಳನ್ನು ನೇರವಾಗಿ ಫಲಾನುಭವಿಗಳಿಗೆ ಪಾವತಿಸಲು ಮುಖ್ಯ ಲೆಕ್ಕಾಧಿಕಾರಿ ಹೆಸರಿನಲ್ಲಿ PD ಖಾತೆಯನ್ನು ಪಡೆದು ಆದೇಶ ಷರತ್ತುಗಳೊಂದಿಗೆ ನೇರವಾಗಿ ಫಲಾನುಭವಿಗಳಿಗೆ ಪಾವತಿಸುವಲು ಈಗಾಗಲೇ ಆದೇಶಿಸಲಾಗಿದೆ. ಅದರಂತೆ ಉಲ್ಲೇಖಿತ ಪತ್ರ ಸೋ ಅಂಡ್ ಸೋ ನಿರ್ವಹಿಸಲು ಸೂಪರಿಂಟೆಂಡೆಂಟ್, ಡೆಪಾಸಿಟ್ ಸೂಪರಿಂಟೆಂಡೆಂಟ್, ಕೇಸ್ ವರ್ಕರ್ ರೋಲ್ ಗಳನ್ನು ನಿರ್ವಹಿಸಲು ಡಿಜಿಟಲ್ ಕೀ ಮತ್ತು ಟ್ರೆಜರಿ ಪಡೆದು ಭೂ ಸ್ವಾಧೀನದ ಬಿಲ್ಲುಗಳನ್ನು ಪಾವತಿಸಲು ನೇರವಾಗಿ ಫಲಾನುಭವಿಗಳಿಗೆ ಪಾವತಿಸಿ ನಿರ್ವಹಿಸಲು ಸೂಚಿಸಲಾಗಿದೆ. ಅಲ್ಲದೆ ಸರ್ಕಾರ ಆದೇಶದಂತೆ PD ಖಾತೆ ದಿನಾಂಕ ಸೋ ಅಂಡ್ ಸೋ 150 ಕೋಟಿ ಅನುದಾನವನ್ನು ಸಹ ವರ್ಗಾಯಿಸಲಾಗಿದೆ. ಸದರಿ ವಿಷಯ ಕುರಿತು ತಮ್ಮ ಕಚೇರಿ ಪತ್ರದಲ್ಲಿ ಭೂ ಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆ ಪಾರದರ್ಶಕತೆ ಮತ್ತು ನ್ಯಾಯೋಚಿತ ಪರಿಹಾರ ಮತ್ತು ಪುನರ್ವ್ಯವಸ್ಥೆ ಅಧಿಸೂಚನೆಯ ಪ್ರಕಾರ ಸರ್ಕಾರವು ಹೊರಡಿಸಿರುವ ಆದೇಶ ವೈಯಕ್ತಿಕ ರೀತಿಯಾಗಿದೆ ಮತ್ತು ಭೂ ಸ್ವಾಧೀನ ಬಿಲ್ಲುಗಳು ವಿಶೇಷ ಸೋ ಅಂಡ್ ಸೋ ಪಾವತಿಸಲು ನಿರ್ವಹಿಸಲು ಸೂಕ್ತವೆಂದು ವರದಿಸಿದ್ದಾರೆ. ಆದರೆ ಭೂ ಸ್ವಾಧೀನದ ಬಿಲ್ಲುಗಳು ಮತ್ತು ಕೋರ್ಟ್ ಡೆಪಾಸಿಟ್ ಬಿಲ್ಲುಗಳು ಕಾಲಕ್ಕೆ ಪಾವತಿ ವಿಳಂಬವಾಗಿದ್ದು ಇದ್ದುದರಿಂದ ನಿಗಮಕ್ಕೆ ಅಪಾರ ನಷ್ಟವಾಗುತ್ತಿದ್ದು ಕಂಡುಬರುತ್ತದೆ. ಇನ್ನು ಮುಂದೆ ಖಜಾನೆಯಿಂದ ನೇರವಾಗಿ ಫಲಾನುಭವಿಗಳಿಗೆ ಪಾವತಿ ಮಾಡಲು ಸರ್ಕಾರ ಉಲ್ಲೇಖದ 4 ಮತ್ತು 5ರಲ್ಲಿ ಆದೇಶಿಸಲಾಗಿದೆ. ಈ ಆದೇಶದ ಕೂಡಲೇ ಅನುಷ್ಠಾನಕ್ಕೆ ತಂದು ನಿಗಮ ಆಗಿರುವ ನಷ್ಟವನ್ನು ತಡೆಯುವುದು. And ತಮ್ಮ ಕಚೇರಿ so and so my lord is all, they are all designated as chief accounts officer and my lord, now this arrangement my lord is only for Karnataka Neeravari Nigam.
Yes.
For Kaveri Neeravari Nigam and Vishweshwara Neeravari
They come
Nigam,
up with something for that. What's
is
your grievance with this?
my lord, under section 77 my lord of the act, it is the role my lord of the land acquisition officer. Payment, my lord, chapter 10. Payment of compensation or deposit of the same in authority. On making an award under section 30, the collector shall tender payment of compensation awarded to him to the persons interested entitled to thereto according to the award, and shall pay it to them by depositing the amount in their bank accounts unless prevented by some or other country. So this role, my lord, cannot be divested and given to, and your lordships may kindly turn to section 19.
19.
Yes, ma'am.
Yes.
My lord, this is regarding publication of a declaration. Your lordships may come to the second proviso, my lord. Provided also that the requiring body, the lordships get it, my lord, second proviso, that is the beneficiary, shall deposit the amount promptly so as to enable appropriate government to publish the declaration within a period of 12 months. So the role of the beneficiary, my lord, is to deposit the cost before the land acquisition officer, and the land acquisition officer, my lord, shall ensure that the land is acquired and compensation is duly paid. Now, there cannot be a classification, my lord, amongst beneficiaries. Only for Karnataka Neeravari Nigam, there cannot be a special, my lord, procedure.
If what could be your grievance? You are receiving the money. It is not that you are not receiving the money.
My lord, I would, my lord, say that in view of the provisions of this act, it has to come only from the special land acquisition officer.
But finally, it has to be paid by the beneficiary.
No, but that is why, my lord, I read out Annexure D, which it says the beneficiaries are going to be directly paid by the Neeravari Nigam.
Getting it faster, if at all.
No, if that is the only intention, my lord, then it is fine. But what happens is one more authority, my lord, one more check is introduced. It could be, my lord, lead to red tapeism and further satisfaction of accounts, and one more, my lord, level of, because this cannot happen without, my lord, the role of the special land acquisition officer. Thereafter, my lord, why should I again we go to the office of the Neeravari Nigam and then seek for compensation? Once the land acquisition officer, my lord, is satisfied,
and award is
I should not be delegated to, then, my lord, he may shirk his responsibility and say it is not my role. Whereas the statute says it is his role. And if I sue, my lord, if I am required to sue before the court of law, an authority, a non-statutory authority.
The timelines are not prescribed.
But your lordship, in the annexure C, that account number is mentioned. There is direction to open the account, your lordship, in that. If your lordship, the amount is not deposited to the petitioner herein, if there is a delay, I can understand if he has a grievance.
So what is the timeline? SLO has passed the award.
Yes.
Within how many days will you transfer it to their account? Without them approaching you, approaching KNL. Submission of Ms. Desai is SLO ಆಯ್ತು ಆಮೇಲೆ ನಾನು KNL ಅವರು ನೋಡ್ಕೊಳ್ಬೇಕು ಅಂತ.
But when your lordship
But
specifically
even his
mentioned regarding-
submission is that
So
account
you
is
have
open.
initiated one more level of corruption. Is a submission. Though not in the direct words, he is around this one is what is submission.
I took a little more time.
Because there is no time. SLO has passed the award. Within 1 week, will the amount be transferred?
But your lordship, annexure C, your lordship, it is not specifically mentioned to the petitioner herein. It is not communicated to the petitioner. Only sought for this, your lordship. If the amount, your lordship, as per the award, is not deposited immediately.
ನೀವು ಹೇಳಿ if ಬೇಡ ಅದು SLO their timelines prescribed.
Yes.
Because if you look at 19, it is only after the deposit is made. No declaration or subsection shall be made unless the requiring body deposits an amount in full or part as may be prescribed by the appropriate towards the cost of acquisition. Shall deposit the amount promptly so as to enable the appropriate government to publish the declaration within a period of 12 months from date so and so. Then the question of payment. So if the persons, the land losers' bank account details are available.
And in the present petition, your lordship, the petitioner is not the only land your lordship was not acquired. If other persons are satisfied with this circle, that is
It's not acquired.
that is,
He says, it is not only my land.
because it is, your lordship, it is a proceedings, your lordship, annexure C. It is not relating to the petitioner only.
What is your grievance here? Who are you?
My lord, my land is acquired. He says it is not only my land. There are other land losers also.
If they are satisfied with this proceedings, your lordship, only because of it cannot be.
My lord,
They can be.
This is, my lord, this is an excessive regulation, my lord, which is.
1 acre 8 cents of your land in 439 has been acquired.
Yes.
SLO award ಆಗಿದೆಯಾ?
ಇನ್ನ ಇಲ್ಲ.
Not an SLO award ಆಗಿಲ್ಲ. So from how many days within the SLO's award will you transfer? Subject to 64, subject to time limit ಕೊಟ್ಟಿಲ್ಲ ನೀವು KNL ಗೆ.
ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
If there is a time limit given, then he can come back to us and say, ಆ time limit ಅಲ್ಲಿ ಮಾಡಿಲ್ಲ ಅಂತ. ಇವಾಗ ಇಂಥ ಸಿಚುವೇಶನ್ ಅಲ್ಲಿ KNL can always say, we are doing, we are processing, we want this, we want that, we want everything.
That I have to seek instruction because notice not ordered.
Lord, it becomes a bureaucratic hurdle, my lord, once again, and excessive.
And AGA accepts notice for respond number 1 to 3. ಯಾರು KNL?
Yadavar Nigam. Yadavar Nigam. Chetan Manoli.
Shri Chetan Monoli accepts notice for respond number 4 to 5. The grievance of the petitioner is that though under the right to fair compensation so and so act, it is the special land acquisition officer which is required to make payment of compensation to the land loser within a particular time frame by virtue of the government order dated 27/9/24 at Annexure C and the order passed by the Karnataka Niravari Nigam Limited bracket KNL at 7/1/2025. The compensation would now be paid by KNL directly to the land loser. Thus, the submission of Shri Harsh Desai is that sovereign powers have been delegated to a company. In that view of the matter, learned AGA and Mr. Chetan Monoli are directed to obtain instruction, make their submission as to whether all the bank details, etc., of the land loser would be collected at the, at or before issuance of the final notification, and within what time frame the amounts would be transferred from KNNL to the land loser's bank account without further inquiry being made by the officers of KNNL, since the award has already been passed by the SLAO, and KNNL would not have any right or authority to cause any further inquiry apart from those under section 64. The apportionment ಯಾವುದು? 64 seeking for enhancement. Apportionment ಯಾವುದು? And 76 of the Act of 2013. And even if there's a reference made under section 64, the amount awarded would have to be paid to the land loser subject to the right to seek for enhancement. And only in case of apportionment under section 76, there being a dispute, the amount would have to be deposited in the concerned court. Released on 18th.
That is why I've raised the ground that it alters, my lord, all the corresponding provisions as well, where the role of the collector is.
As long as it's for efficiency and you will get it within 1 week of
But
the
if
award.
that is the only intention, my lord, it is good. But everything must be in furtherance, my lord, of this statute and not, my lord, cause something else.
It's SLO instructing them to pay. He'll be acting as a delegate of the SLO. But as long as timelines are prescribed and they stand to it, stick to it, it is fine.
But, my lord, it would lead to a discrimination, my lord, amongst beneficiaries. If there is some other APMC or something.
It's good for you, you're getting it faster.
If the other landowners are satisfied
Other question, my
with
lord,
this,
would be
As long, why do you want to go to SLO only?
other kind of beneficiary, then, my lord,
They may be testing it out. ನಾಳೆ ಇದು ಸಿಸ್ಟಮ್ ಸಕ್ಸಸ್ ಆದ್ರೆ ಬೇರೆಯವ್ರದ್ದು ಅದೇ ಮಾಡ್ತಾರೆ.
they might be satisfied with this proceedings or other.
subsequently, my lord, for Kaveri Jala Nigam and they have stuck to the special office, land acquisition office.
You are concerned with KNNL. ಅವ್ರದ್ದೇನಿಲ್ಲ.
This time, yes.
This time. So next time you may come and say, same KNNL ಇದಕ್ಕೆ implement ಮಾಡಿ ಅಂತ ಹೇಳ್ಬೋದು ನೀವು.
If
ಅದು
it is
ಬೇರೆ,
effective,
ಅದು-
my lord, if it is effective.
Here we'll have to only see that it is done in a time-bound manner and there is no further inquiry made by the KNNL. They have to just,
That's my only concern, my lord, as a land loser.
ಆಮೇಲೆ ಇಲ್ಲ ಅದು SLO ಮಾಡಿದ್ದಾರೆ ನಮ್ಗೆ ಇದು ಕೊಡಿ ಅದ್ ಕೊಡಿ ಅಂತ ಹೇಳ್ಕೊಂಡು ಕೂತ್ಕೊಳಕ್ ಆಗಲ್ಲ.
ಅದಲ್ಲ. Because when this is the proceedings, it is for the KNL. They
It's
have to-
only the disbursing authority.
ಹೌದು. Only disperse, because as per this only account to be opened ಅಂತ ಅಷ್ಟೇ.
SLO ಅವಾರ್ಡ್ ಆಯ್ತು 7 days ಅಲ್ಲಿ ಪೇಮೆಂಟ್ ಹೋಗ್ಬೇಕು. ಬ್ಯಾಂಕ್ ಡೀಟೇಲ್ಸ್ ತಗೊಳ್ಳಿ. ಅವಾರ್ಡ್ ಮುಂಚೆ ಎಲ್ಲ ತಗೊಳ್ಳಿ. ಅವಾರ್ಡ್ ಆದ್ಮೇಲೆ don't delegate anything to KNNL. Anything that is required to be done by SLO. Get all the details. As soon as the award is passed, transfer within 7 days. Apportionment dispute idre deposit in court. Enhancement idre whatever is awarded has to be transferred. If they succeed in enhancement, that will be awarded. If they don't succeed, adu dismiss agutte. But what is the time frame within which of the SLO award will the amount be transferred?
Instead of 18th, you know, some more days, you know, 20th,
Yes, 20th.
20th, 21 euros, 21 euros.
21.
Because you
ಅವ್ರು ಹೇಳ್ತಾರೆ, KNL
No,
ಹಿಂಗೆ
the
18
reason is that
20,
you lordship,
21 ಮಾಡ್ಕೊಂಡು ಹೋದ್ರೆ.
the reason is that on 17, 18, 19, some customers, some inconvenience ಅಂತ ಅಷ್ಟೇ ಇದೆ.
21st.
ಅದಕ್ಕೆ ಉಳಿದೈತೇನಿಲ್ಲ.
For preliminary.
For further hearing at 2:30 PM.
25 KS Patil.
My lord, this matter is This matter is memorandum of writ
ಕೇಳಿಸ್ತಾ
petition.
ಇಲ್ಲ.
My lord, this matter is memorandum of writ petition.
ಹ್ಮ್.
It's matter to issue writ of mandamus or any prohibited writ directing the respondent number 2 and 3 to consider re- representation dated 2/2/2021 and issuing Saguwadi cheat in favor of petitioner in respect of resurvey number 213 C measuring 4 acres 23 guntas each as recommended by the Committee on Regularization of Bagar Hukam Land bearing number LND CR of 15 of 2007 of 8 Annexure H to serve end of justice. My lord, it's notice no staying praying for issuing of Sagu cheat. My lord, one
ಹೇಳಿ.
ಒಂಟೆಲ್ಲಪ್ಪ ಅಂಡ್ ಹನುಮಪ್ಪ ಇವ್ರಿಬ್ರು ಬ್ರದರ್ಸ್ ರೀ. ಅವರು 20 ವರ್ಷಗಳಿಂದ ಈ ಪ್ರಾಪರ್ಟಿನ ಸಾಗುವಳಿ ಮಾಡ್ಕೊಂಡು ಬಂದಿದ್ದು. ಇದರಲ್ಲಿ ಇವರಿಗೆ ಸಾಗುವಳಿ ಚೀಟಿ ಬೇಕಾಗಿತ್ತು. ಆದ್ರೆ ತಹಸೀಲ್ದಾರಿಗೆ ಹತ್ರ ಹೋದ್ರೆ ಅವರು ಡಿಸಿ ಕಡೆಯಿಂದ ತಗೊಂಡ್ ಬನ್ನಿ ಅಂತ ಹೇಳ್ತಿತ್ತು. ಆಮೇಲೆ ಡಿಸಿ ಅವ್ರ ಕಡೆ ಹೋದ್ರೆ ತಹಸೀಲ್ದಾರ್ ಅವ್ರ ಕಡೆಯಿಂದ ತಗೊಂಡ್ ಬನ್ನಿ ಅಂತ ಹೇಳ್ತಿದ್ರು. ಸೊ ಇವ್ರಿಬ್ರು ಕೊಡ್ತಾನೆ ಇರಲಿಲ್ಲ ಸರ್. ನಮ್ದು ಮನವಿ ಅಂದ್ರೆ ಇವ್ರ ಕಡೆಯಿಂದ ನಮ್ಗೆ ಸಾಗುವಳಿ ಚೀಟಿ ಬೇಕಂತ ಹೇಳಿ ನಮ್ ಪ್ರೇಯರ್.
Recommendation has happened as per Annexure G, page 53.
But what happened, Your Lordship, the demand was made for payment in 2006. They are deposited 2020, Your Lordship. After depositing, they have filed this application in Annexure H, Your Lordship. In case 56, mechanism last para, Your Lordship.
Land available ಇದೆಯಾ? ಅವ್ರ possession ಲೇ ಇದೆ.
Let them consider, Your Lordship.
And AGA accepts notice for respond number 1 to 3. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that though a recommendation had been made by the Tahsildar in terms of Annexure G on 19/12/2006, the Sagul sheet has not been issued to the petitioner, and as such the petitioner has submitted, petitioners have submitted a representation on 2/2/2021 at Annexure H, which is also on 9/2/2, 19, representation dated 19/1/2021 on 2/2/2021 at Annexure H, which has also not been considered by respondents. Whenever any representation is submitted by a citizen, it is required for the concerned authorities to consider the same and pass necessary orders, either accepting or rejecting the representation within a reasonable period of time. In the present matter, the representation having been submitted on 2/2/2021 is yet to be considered by the respondents. In that view of the matter, I pass the following order. Writ petition law and mandamus is issued directing respond number 2 and 3 to consider the representation dated 2/2/20, dated 19 to, dated another. Dated 19/1/2021, submitted on 2/2/21 at Annexure H in accordance with law and pass necessary orders within 30 days from the date of receipt of a copy of this order.
Yes, sir.
26, C. Remat.
Portion of the petitioner's land is declared as a revenue village.
38A na?
Yes, my lord.
No notice.
Covered decision.
ಇದೆಲ್ಲ 38A ಹಿಂಗೆ ಆಗ್ತಾ ಇದೆ.
So many cases are coming in.
ಕೊಡಿ ಅದು. And AGA accepts notice for respond number 1 to 4. Gram Panchayat Kushtagi, Killarati.
Vijay Kumar is there. Vijay Kumar.
Vijay Kumar Bijigatti.
Vijay Kumar Balagiri Mat.
Balagiri Mat.
Please, sorry, sir.
Vijay Kumar Bijigatti over Balagiri Mat accepts notice for respond number 5. Petitioner is before this court seeking for the following reliefs. Same 107338. IA1 is allowed.
27, Mrutyunjay Hallikeri.
Los kindly pass over, my lords.
Pass over.
28,
Notice of Vika. During the pendency of the matter, respond number 2 is expired, hence IA1 of 25 has been filed. Issue notice on IA1 of 25 returnable by 21st April.
29, Mrutyunjay Hallikeri.
Notice of the R6.
Filed LR's application, my lords.
6B. Ibrahim, 6A and 6B.
Please, my lords.
During pendency of the above matter, respond number 6 expired on
6/12/2023.
in the month of February 23. Hence, IA 4, 5 and 6 of 23 were filed on
6/12/2023.
accepting the reasons stated in IA number 4 of 23, delay of
158 days.
is condoned by accepting the reasons stated in IA 5 of support of IA 5 of 23. Abatement in respect of respond number 6 is set aside by allowing IA 6 of 23. Persons named therein are brought on record as respond number 6A and 6B. Almele, during pendency of the matter, respond number 6 expired on. Since IA 4, 5 and 6 were filed, notice having been issued has been served on respond number 6A and notice issued to respond number 6B is returned with the endorsement refused. End service was held sufficient. Amendment of cause title.
So during course, my lords.
Counsel for the petitioner seeks fund is granted a week's time to come to file the to carry out the amendment and file amended cause title. Needful is not done by 17th. The petition would be liable to be dismissed for non-prosecution. Impleading application in either.
Plus, we will file objection to impleading
Shrikant
application.
Patil. Counsel for the petitioner seeks fund is granted a week's time to file his objections to IA 1 of 2019. Objections, if any, to be filed on or before 17th February, failing which it will be taken as not filed and matter proceeded.
Please, oblige.
Relist on 21st.
Please.
30, Srivatsa Hegde.
Lord, in 30.1 and 30.2, my lord, there are certain office objections, my lord.
Yes.
I pray for 2 days' time to comply with the office objections. Any date may be fixed for hearing, my lord.
My lord recalls, there was one more petition connected with these. An application which was made to the district judge under section 3 and 7 of that was disposed of, and this was to be heard, my lord. And that is the reason I have made that early hearing application.
We'll allow that. 30.1 and 30.2. 1 week's time is finally granted to comply with office objection. If office objection is not complied by 17th, the petition will be liable to be dismissed for non-prosecution. Relist on 20th.
In IA hearing or preliminary hearing?
Come there only, IA hearing. Final hearing was
31, SK Kayakmat. SK Kayakmat.
My lord.
Yes,
the present read petition has been filed by the petitioner made for mutation of the name in the records of right in pursuant to order passed by the Bhutan Yajna board, which has been granted to the petitioners in the year 2012, my lord. Since the petitioner giving several representatives for mutation name, they are not mutating name of the petition, my lord. On the contrary, my lord, recently, my lord, I have had an application. Now, very same land has been given to the Muraji Desai Minority Residential School, my lord, where they are making they have mutated the name of the Muraji Desai Minority Residential School, my
You'll
lord.
have to challenge that, Mr. Kaikmat. You'll have
My
to
lord.
make a party and you'll have to challenge it.
Yeah, I filed application, my lord. In the meantime, my lord, they are precipitating a matter. They are taking the position of the land, my lord. They should be restrained, my lord.
What has happened to their application, Mr. Kanur? Without their application being considered, how can you allot it to somebody else?
That IA copy is not.
That counsel for the petitioner undertakes to furnish IA 1 of 24 to the learned AGA by end of the day today. Learned AGA is directed to secure instruction, make a submission as regard the status of the representation of the petitioner. Since without consideration of the said representation, no allotment to any third party could be made. Relist on 18th February.
Much obliged.
32, G.I. Gachinma.
My lord, I appear on behalf of,
Yes.
my lord, this is the Ayurvedic Medical College, my lord.
Mr. Angadi, you are appearing. Mr.
Lord,
Bankar.
NCISM, my lord.
Where is Mr. Bankar? Mr. Kanvi, you are appearing for 1 to 4. You are appearing only for R1, na? Registry is correct. Is that correct? The appearance to MB Kanvi is that appearing for respond number 1 only. Bankar beka beda. Ive.
For NCISM, I appear.
Yes.
My lord, on the earlier, my lord, date of hearing, my lord, your lordship has directed me to verify, my lord, or get instructions on para number 7 of the impugned order, my lord. That is, my lord, 2012-2021.
Page?
My lord, page 26, my lord. 26 is the annexure E, my lord.
28.
Now petition.
Of the first 21, my lord, red petition number.
5326.
One 105236.
105326.
Yes.
Annexure E, my lord, page number 26. The relevant portion is at page number 28, my lord. Para number 7.
12 ಬೇಕು 35 teachers ಇದ್ದಾರೆ.
Please.
6 are not considered.
Please.
Even then they are 29.
Please, my lord. My lord, that was the, my lord, query raised by the other side. My lord, rule 8, my lord, of the rules.
Which rules?
My lord, it's a 60, my lord, students college, my lord. And rule 8, my lord, requirements of college. Teaching staff. My lord, there shall be a minimum 30 full-time teachers and 45 full-time teachers appointed on a regular basis for admission up to 60 students. My lord, if it is a 60 students, my lord, then 30, my lord, teachers will be required for 60 students, my lord. My lord, we'll concentrate only with this, my lord, because it is a 60 students college. And now, my lord, 30 teachers are required for this. My lord, now, my lord, the query raised by the my lord, NCSM is that shortcoming is that there is no faculty available in the department of Kaya Chikitsa as per RMS 2016 rules, my lord. My lord, next page, my lord. My lord, page number.
No faculty for?
My lord, no faculty for Kaya Chikitsa department. My lord, may I request your lordship to go through page number 56, my lord. Schedule 6. My lord, schedule 5 of the rules.
Page number?
My lord, page number 55, my lord. Schedule 5, my lord. There is a schedule, my lord.
Yes, schedule 5.
Please. My lord, in this, my lord, details of teaching staff in Ayurvedic college has been given, my lord. My lord, in 60 students college, my lord, there are 14 departments. My lord, for every one department, my lord, one higher faculty and one lower faculty, my lord, will be required, my lord. And my lord, it is my lord, it is discussed that up to 60 students, one professor or a reader is required for one department, my lord. And it is called as, my lord, higher faculty, my lord. Next lecture, it's a lower faculty. My lord, in this, my lord, in the present case, there is no faculty available in the department of Kaya Chikitsa. And further, my lord, the shortcoming is the college is not fulfilling the criteria of minimum 12 higher faculty. My lord, they say that there are only 20. My lord, they have given a 35 students list. Sorry, my lord, teachers list, out of which 6 teachers, my lord, are their candidature has been rejected due to certain, my lord, problem. But in this, my lord, it is not that, my lord, in every department, my lord, it is required. But my lord, for every department, there shall be a higher faculty, my lord. For every department, one higher faculty and one lower faculty. Either it may be a professor or a reader. In this, my lord, that is why, my lord, the shortcoming number 2, it is written as college is not fulfilling the criteria of minimum 12 higher faculty in 11 departments.
ಇವಾಗ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ ಅವ್ರಿಗೆ?
My lord, they are saying number of, my lord, teachers that according to our instructions, my lord, 27 ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ in toto. My lord, as of now, my lord, this is the instructions, my lord, till morning I have received.
How many they have as higher faculty? How much lower faculty doesn't sound good, but lower faculty is totally 30 ಇರಬೇಕು.
ಹೌದು.
So minimum
15 ಇರಬೇಕು. ಅದು higher faculty 15 and lower faculty 15, my lord.
minimum ಎಲ್ಲಿದೆ? Where is that clause?
Minimum is 30, my lord. Minimum is 30 as per the rules.
ಇಲ್ಲಿ minimum 12 ಅಂತ ಇದ್ದೀರಾ ಅದಕ್ಕೆ.
ಅಲ್ಲ, ಅಂದ್ರೆ 12 ಡಿಪಾರ್ಟ್ಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ಸರ್, ದಿ ಕಾಲೇಜ್ ಇಸ್ ನಾಟ್ ಫುಲ್ಫಿಲಿಂಗ್ ದ ಕ್ರೈಟೇರಿಯಾ ಆಫ್ ಮಿನಿಮಮ್ 12 ಹೈಯರ್ ಫ್ಯಾಕಲ್ಟಿ ಇನ್ 11 ಡಿಪಾರ್ಟ್ಮೆಂಟ್. My lord, there are 14 departments, my lord. There are totally 14 departments in 60 college students, my lord. So in this, my lord, they are not fulfilling the criteria in 11 departments in a higher faculty area.
For Chikitsa, you need one professor and one reader.
Please, my lord. That is why, my lord, they have mentioned that.
For the others, it is or.
Please. And my lord, may I request your lordship, my lord, 10, my lord, serial number 10 of schedule 5.
We have seen. It is 1-1.
1-1.
No.
ಇಬ್ರು ಇರ್ಬೇಕು. ಸೊ my lord, ಇದರಲ್ಲಿ ಯಾರು ಇಲ್ಲ ಅಂತ ಇದೆ.
ಇಬ್ರು ಇಲ್ಲ.
ಇಲ್ಲ. So that was the, my lord.
Lower faculty ಇದಾರಾ?
Lower faculty ಇದಾರೆ ಅಂತ.
So there is no dispute about lower faculty.
No, my lord.
Higher faculty ಅಲ್ಲಿ
ಇಲ್ಲ ಅಂತ.
2 of them are not there.
Not there. Completely.
ಇವಾಗ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
Lord, according to
ನಿಮ್ಮ ಪ್ರಕಾರ
27 ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಸರ್.
ಹೈಯರ್ ಫ್ಯಾಕಲ್ಟಿ ಎಷ್ಟು?
In every department, my lord.
Total higher faculty. There's 15 lower faculty are there.
ಹೌದು. 15, 30. But according to them, my lord, 10, they are saying that 11 or 10 are there, my lord.
So too short.
Please.
Yes, Mr. Kannur.
Yes, my lord, if your lordships were to turn to page 25, my lord, that is page 25, my lord. That is in our reply with regard to Kaya Chikitsa. Our institute is having one lower faculty, that's assistant professor, lecturer, cadre, presently working in the department, college, newly appointed, so and so, naming Dr. Gargi RB, was unable to apply for fresh teachers code due to technical software issue, which was not considered in the CCM software, part 1 of visitation. Kindly consider the staff as LF in the department of which is fulfill the requirement of lower faculty in the department. Then if your lordships were to come to the impugned order, my lord, Annexure E, my lord.
Page?
Annexure E, page 28.
Which page in Annexure E you want?
28.
My lord, here also, my lord, if your lordship sees the tabular form in page 28, what has happened is this, my lord. Page 28, my lord's got.
Yes.
My lord, here, apart from what has been mentioned, if your lordship sees the tabular form, that is note, college submitted list of 35 teachers in the list of teaching faculty in so and so, out of which 6 teachers are not considered due to the following reasons. In this, my lord, serial number 1, serial number 4 and 5. My lord, what has been mentioned on the remarks column is not considered eligible as teacher has neither updated his OTM's profile nor having the new unique teacher code. My lord, there has been an issue. So it is not as though, my lord, the teachers are not there. The code has not been uploaded and that has not been done, that unique teacher's code.
Why haven't you done it?
No, my lord, that the teachers, my lord, they had to do it, my lord. So they are there. And apart from that, my lord, with regard to serial number 2, 3 and 6, my lord, they are saying that not considered eligible as provision allied is not applicable on teachers having PG qualification. My lord, for this, there is at Annexure F, my lord, it has been done in 1989 itself, that those who have joined, my lord, that is if your lordships were to turn to Mr. Gurdev Gachinmat, my lord, will give that letter dated 3691 letter. If your lordship sees this, my lord, in inviting your attention to the subject mentioned above, I'm directed to inform you that the question regarding promotion of Ayurvedic teachers appointed before 1789 in Ayurvedic was considered by the council. The council was of opinion that the Central Council of Indian Medicine minimum standard of education were enforced from 1789. The amended regulation provide the postgraduate qualification as essential qualification for the new recruitments made after 1789. Therefore, these regulations will not affect the promotion of the teachers appointed before 1789, and the post graduation would not be essential for those teachers in the cases of promotion in the light of so and so. So, my lord,
So who was
these,
appointed prior to 1789 in these list?
my lord,
What document have you produced to show that?
2316. That's document.
and may I just bring it to your lordship's notice, my lord? What has happened is, my lord, from 92, my lord, we are running. My lord, till 2021, my lord, we have had the permission every year. From
If you're running
2021
from 92, you are not appointed them in 89. So your argument there will go, Mr.
No, no, no. My lord, what I'm saying is, if they had it before that, what I'm submitting is this, my lord. Permissions, my lord, we have got. Only this in between 2 years we have not got. Now again, 23, 24 and 24, 25, we have the permissions as of now. So for the present year and the previous year, we have the permissions. Earlier, we had the permission, my lord, which we have produced at Annexure D, C and D. It's only on these particular things. And the same rules, my lord, which my learned friend read. My lord, there, if your lordships want to see rule 3, my lord, if your lordship turns to page 55, where, my lord, he showed schedule 5.
Rule 3.
Yes, my lord. In that schedule, page 55, my lord, that schedule 5, which he showed about the professors and lecturers. In that, if
Yes.
your lordships comes to Roman 3, the deficiency for up to 60 intake capacity shall not exceed more than 10% of total requirement with availability of minimum one teacher each of 14 departments. The total number of higher faculty shall not be less than 12 professor or readers distributed in minimum 11 departments. The relaxation is for seeking conditional permission to undertake admission for particular academic session. For example, the college having up to 60 may capacity shall have minimum 27 total faculties, out of which minimum 12 professors or readers covering not less than 11. So, my lord, even this also, my lord, there's a relaxation that are up till 30.
Yes, show us 12 professors or readers.
Yes.
Over 11 departments.
Yes, my lord, we have all these, my lord. Now, if your lordship
Who are
sees...
they? What are their names? What are the documents for that? We have one theory, then we can't accept it on that basis. They are saying no, you are saying yes.
No,
Where are the
what they have said,
documents?
my lord, as your lordships had pointed out last time, they themselves say, my lord, submitted a list of 35. So 35 we have submitted. And this 6, if your lordship sees in this, my lord, 3, my lord, technically, my lord, because it has not been uploaded, my lord, that is the only reason. So
Mr. Kannur, the rules have to be followed. This is an educational institution. If you don't follow the rules, then there's no point. See, if you are relying on Roman 3 to say that you are distributed in minimum 11 departments, show us the names and show us the qualification.
my lord, now, my lord, we can... my lord, now our the difficulty, my lord, now is, my lord, that earlier interim orders were, my lord, passed to take up the examination, results declared, and, my lord, supplementary exam we were permitted to take
Subject
up.
to result of the writ petition, Mr. Kannur.
Yes, my lord.
So if
Now,
your
my
writ
lord,
petition goes, all that goes.
no, all that will go. My lord, that we cannot claim equity, my lord. That is settled principle of law. I'm not on that. Now, my lord, with the fine, my lord, now February 14th is the last date, my lord, for them to take up the second year exam.
So that means you don't have these 12 professors or readers in
No,
level.
my lord, we do have, my lord. We can point out, my lord. We can point
it out.
My lord. Then, my lord, may I make one request, my lord? One request, my lord. My lord, I'm before your lordships tomorrow physically. If your lordship has it tomorrow, my lord, by then we will point out to your lordships, my lord.
We'll have it tomorrow, but no guarantee of it reaching.
My lord, no, my lord. Interim order,
There are
my lord.
already large number of matters posted.
My only thing was, my lord, I was supposed to come, my lord, but I couldn't make it, my lord, in the morning.
Please send the documents to Mr. Angadi so that he can get it verified.
Yes, my lord, our only concern is, my lord,
If you give it tomorrow to him in open court, then he will ask for time.
No, my lord, we'll give it today itself.
Yes. At the request of counsel for the petitioner, relist tomorrow.
Obliged.
Obliged.
ಇದು ತಗೊಳ್ಳಿ, ಇದು ಅದಲ್ಲ.
33, Nandish Patil.
33, my lords, I appear for response 2 and 3. Lord, we need some time to file objections on behalf of Housing Board.
Why do you need time? Nobody for the petitioner? None appears for the petitioner. Counsel for respondent seeks for? Yav respondent, Mr.
Response 2 and 3, my lords.
Counsel for respondent 2 and 3 seeks for and is granted. Yes,
2 weeks.
2 weeks time to file his objection. Objections, if any, to be filed on or before 21st February. If not filed by then, the objection will be taken as not filed, matter proceeded with. Relist on 24th. None appears for petitioner. Tegdaki.
34.
The losses are fixed on the 21st, my lord.
24th.
24th.
21st ಒಳಗೆ file ಮಾಡು.
Aye.
I appear for the fifth respondent, my lord.
Yes.
I appear for the fifth respondent in this matter, my lord.
Fifth respondent. Yes.
Yes, my lord.
Yes, who is for the petitioner?
He has to file appeal, your lordship, before the KIT under section 118, your lordship.
Yes, sir. There is a question regarding, my lord, maintainability of the present petition, my lord.
Para. Yes. Yes, without jurisdiction. Walpur is without jurisdiction. Hmm.
Exception to the rule of alternative remedy rights, where the petition has been filed for the enforcement of fundamental rights protected by part of the Constitution. There has been violation of principle of natural justice. In this case, they are not issued the notice. They are not taking the errors of the respondent. They have straightaway passed into the order. Where is the 10%?
Did you come and say that the person has expired? Was it brought to the notice that the person has expired? Where has it been brought to notice? 55. $52.
51 is the last slide. ಜಗತ್ತಿನ ಸಂಬಂಧಪಟ್ಟರಿಗೆ ಜಾರಿ ಮಾಡಿದ ದಯವಿಟ್ಟು ವರದಿ ಮಾಡಲು
Where is the impugned order? ಜಾರಿ ಮಾಡಿಸಲು ಕಂದಾಯ ನಿರೀಕ್ಷಕರು ಹಾಗೂ ತಹಸೀಲ್ದಾರರು ದೃಢೀಕರಿಸಿದ್ದು
In the year 1989,
89.
proceedings started on the year 2022.
Even prior to the proceedings. Then what is the point in filing an appeal, Mr. Kanu?
And very respondent by petitioner,
Hmm. Where is the suit?
Whatever grounds your lordship, he has to take your lordship by filing the.
If the person is expired prior to the initiation.
Yes, I am not disputing that aspect by virtue of the death certificate. But whatever grounds urged by him, Your Lordship, he had to make a separate application, Your Lordship, along with the LRs before the appellate of the KAT, Your Lordship, under section 118 of.
If he was the applicant, we have rejected.
Yes.
He is the respondent.
My lord, may I submit?
Where is the suit? Just one moment. 39. Ullas Salvador Rodriguez.
Rejected on my Lord, February 2020. Got a land on the on 20-11-52. Injection so reject all will grant.
Suit was filed in 2020. 95 of 2020, rejected in 22. And these proceedings were initiated on after 22-11-22. Suit. They withdrew the suit. Salvador Doming Rodriguez. Respond number 5.
Yes, my lord.
Yes, Mr. Chandrasekhar Gowda.
My lord, in my statement of objection, I have filed all my revenue documents and tax receipt, my lord. The
You
present
knew that respond number 6 before the tribunal expired.
Yes, yes, my lord. The
Did
present
you bring
petitioner
it
is
to
not
notice? Did you bring it to
the
the notice?
present. My lord, the present petitioner is not a claimant, landowner, nor a applicant before the tribunal, my lord. He is taking chance of his name mentioned in the order, my lord. He is nowhere connected to the present this property, my lord,
That is
which
on
was
merits.
allotted to me.
That is on merits. Did you bring it to the notice of the tribunal that respond number 6 is expired?
My lord, in that proceedings, I was also one of the respondent, my lord.
Did you bring it to the notice? You filed a suit.
My lord, suit. My lord,
You filed
suit filed against the Ullas Salvador Rodriguez, my lord.
that is the
He's
son of respond number 6.
no, my lord.
Grandson.
Son, no,
Grandson.
no, my lord. He is not a son of respondent 6, my lord. He is third party to my land, my lord. That
Yeah,
time before
respond number
granting.
6 is Vanti Com Parax. He is
Yes,
not
my
a
lord.
Salvador Rodriguez.
My lord, one second, my lord. The
Parax antidella.
The Mantikom Parask, the name of the sixth respondent, my lord. His
Yes.
name, her name was entered with respect to property number, my lord, third property, survey number 153, Issa number 7. We are the joint owners in that property, my lord. The other property is concerned, my lord, her survey number 155 and survey number 140 is, my lord, the present petitioners or the ancestors of petitioner, my lord, nowhere connected to this property, my lord. I have been cultivating the property, my lord, since 1934. The revenue records and the receipt also has been produced by
Just
this
one moment.
with the present petition.
Just one moment, Mr. Gowda. Your contention is Vanti Com Parax is expired. You have produced death certificate of Anton 53. 55. 55 is who? Monty Farax Rodriguez. Petitioner is son of Salvador Rodriguez. Where is Salvador Rodriguez? Is he a party? Salvador Doming Rodriguez is respond number 1. ಎಲ್ಲ ಇಬ್ಬರು ಜನ ಸಾಲ್ವಡೋರ್ ಇದ್ದಾರೆ.
ಜನ ಸಾಲ್ವದೋರ್ ಇದೆ. ಸಾಲ್ವದೋರ್ ಜುವಾನ್ ರೋಡ್ರಿಗೀಸ್, ಸಾಲ್ವದೋರ್ ಡೊಮಿಂಗ್ ರೋಡ್ರಿಗೀಸ್.
ಜೋಮ್ ರಾಡ್ರಿಗೀಸ್, ಡೊಮಿಂಗ್ ಮತ್ತೆ ಜವಾನ್ ರಾಡ್ರಿಗೀಸ್. Where are you? Salvo Products, Rodriguez. ನೀವೆಲ್ಲಿದ್ದೀರಾ? ಉಲ್ಲಾಸ್ ಎಲ್ಲಿದ್ದಾನೆ? Ullas S. Rodriguez. Now, Ullas S. Rodriguez is the son of Salvador Farax Rodriguez.
No, my lord. Ullas Rodriguez is grandson of sixth respondent, Mantikom Parask.
Ullas S. Rodriguez, as per your family tree, he is coming under Salvador Parax Rodriguez. Vanti but ಇಲ್ಲೊಂದು ಇನ್ನೊಬ್ಬರು ವಾಂತಿ ಇದ್ದಾರೆ ಅಂಡರ್ ಸಾಲ್ವಡೋರ್. This you will have to say. There is a fact finding to be done. On the face of it, we cannot make out.
Even in the note after cost title, you also may kindly see. After the cost title made by him in the present petition.
And other interested persons also not made parties.
This is the note by him
Yes,
after the cost title.
How can you say this? Other interested persons
So
are
in the
also
present
not made
petition, he
parties.
is making submission that you will also against that person. But in the present petition himself, he is not making the parties.
My lord, he is pressing only that property only, my lord, because it is.
Whether so-and-so was dead, whether you are claiming under him, all those things, because the names are so different, you will have to lead. You can't say that on an oral submission.
My lord, may I make one submission?
No, we are rejecting this. No need to make any submission. The submission of the counsel for the petitioner is that the principles of national justice have been violated in as much as the legal heirs of respond number 6 before the land tribunal had not been brought on record. The petitioner is the grandson of respond number 6, that is Vanti, wife of Parax Rodriguez. The perusal of the family tree produced along with the above writ petition indicates several family members having not been brought on record in the present writ petition. And the note below the cause title indicates that respond number 2 to 11 had expired and other interested persons are also not made parties. The aspect of whether the petitioner is a legal representative of Vanti Parax Rodriguez and or that our legal representatives had not been brought on record would require an inquiry to be conducted and cannot be so done in a writ petition. The petitioner having an alternative efficacious remedy in terms of appeal under section 118 of the Karnataka Land Revenue Act.
Land Reforms Act.
Land Reforms Act, where such an inquiry could be held the petition stands disposed, reserving liberty to the petitioner to file such appeal, where these issues would have to be considered if necessary by evidence being led. Pending application stands disposed.
55, Rodda Veer Shetty.
For respond. On the last occasion, on 4th, my lords were pleased to pass an order taking on record the memo filed by the government advocate to the effect that his form number 57
Yes, Mr. Rodda Veer Shetty.
he is, my lord, having the benefit of an interim order.
ಇವ್ರು ಯಾಕೆ ಬರಲ್ಲ ಇವರು ಎಲ್ಲ ಅಡ್ಜನ್ ಮಾಡ್ತಾ ಇದ್ರು. Today also there is no appearance on part of the petitioner. It appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution. Pending IA is also.
Please.
36, Amit Deshpande.
Yes.
Lord, the petitioner filed this, my lord, writ petition challenging Annexure G, my lord. My lord, in this case, my lord, the petitioner submitted a representation to the Tahsildar, my lord, to formation the road from survey number 37 to 38, my lord. On request of my lord, the
prayer is to provide a cart road.
To provide a cart road, my lord, from
And AGA accepts notice for respond number 1 to 3. Notice ಆಗಿದೆ.
notice. Last time, my lord.
Yes, cart track ಇದೆಯಾ?
I have not received any instruction. ಯಾವುದು ದಾರಿ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಅಲ್ಲಿ.
ನಿಮ್ಮ as per village map ಇದೆಯಾ?
I will to get instructions, your lordship. I have not received any instructions.
And AGA seeks for and is granted a week's time to secure instruction, make his submission as to whether there is any cart track situated in survey number 38/1 of Kudulu Sangama village. Released on 18th.
Please.
Counsel for the petitioner submit that he has complied with the office objection registry to verify and put up.
37, Taltili.
Writ petition. Lordship was pleased to permit not them to only plying of vehicle is permitted. Now, my lord, what they did, my lord, they have, my lord, they laid down a road, my lord, by the unloading the, my lord, the mud through tipper and then transported them, my lord, the sugarcane. This three photographs, please.
If you have done that,
My lords, I am not saying. It
you
was,
send your clients to jail from here.
my lords, I am not saying. That is, my lords, that was done in the land of a government where they read, there was a, my lords, gutter. In that gutter, my lords, my party has filled mud.
No, my lord, in my land, my lord.
Lords, even if my lords may pass these photos, I am not saying.
I also filed complaint. They have issued a acknowledgement by the, my lord, the police station. And therefore I have.
Road ಎಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ?
Please, my lord.
Where have they made a road?
Please, my lord.
Where road ಎಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ?
Lordship, they dumped them, my lord, the tipper, my lord, through tipper. Mud have been dumped, my lord. Photograph shows, my lord. The police, my lord, I have filed complaint with the police. Only, my lord, flying of vehicle is permitted. They are trying to, my lord, lay down road. In spite of that, my lord, the police also, my lord, took us to the custody of the, my lord, taken custody. Till 10:30, my lord, we have made to sit in the police station. Present petition respondents and their sons, my lord.
Lords, may I pass these photos? I am not saying. Mud is dug. Only
Not
where.
saying, Allah, this is not the way it is done, Mr. Lee.
Lordship on that, they
Lords,
also
I am,
orally,
if
my lord,
my lords
directed.
should permit, my lords, let my lords not disputing the fact. Mud is digged where there was a, my lords.
How do you put, did you ask permission from us?
My party has not.
Then how did you do it?
That is, my lords, sir.
Without.
Without.
Asked to do it without making any change. That
Lords,
was a
it is, my
specific
lords, my
direction.
submission, that is true, my lords, that is only my request, my lords, that is.
The submission of learned counsel for respondent 1 to 3 is that the respondents have sought to create a road on the property of the respondent.
Lords, one submission.
In that view of the matter, the petitioner is restrained from making use of any part of the land of respondent number 3 respondents for transport of sugarcane or otherwise. A complaint having been filed by
Lords, both the parties have filed a complaint.
respondent number 1 to 3 the jurisdictional police shall take suitable action against the petitioner on the same. And if any mud is being dumped into the land of respondent number 1 to 3, the police authorities to take suitable action against the petitioners.
Please, one submission.
The petitioners are restrained from making use of the land of the respondents for any purpose, including transport. The jurisdictional police authority shall ensure that the above order is implemented in its letter and spirit.
Lords, one submission. Lords, I'm not saying. Lords, here, my lords, even if my party has done, lords, I'm ready to redo that. I'm only my request, my lords.
Not concerned with your redoing.
Lords, this is.
If you're violating the order which has been passed, we won't give you any this one.
Lords, one submission. Even if my lords, now the sugarcane has fallen in the entire land, lords.
Let your sugarcane rot there.
Lords, my request. Lords, I'm not saying, lords, only my grievance if my lords should permit. May I pass these photos? I'm not saying.
25 is allowed, the interim order is vacated.
Lords, one submission. Lords, since my lords, I'm unable to transport the sugarcane.
We prevailed upon him to give you that permission.
Lordships, I'm not saying.
And we have told you clearly you won't cause any damage.
Lords, even if my lords should permit, may I pass these photos? According to them, only no damage is caused, my lords. Lords, any date may be fixed. By that time, report could be recalled, my lords. That is
2026.
Lords, one submission. I'm unable to send a
8th April.
Lords, one submission. I'm unable to send only. If that is so, my lords, they take action.
We prevailed upon him. You
Lords, that is, I'm
went
not
against the order.
one submission. Anything can't be done.
The client thinks otherwise, let him think so.
Arup Deshpande.
It is a petition pertaining to Music College of Hubballi. Has been handed over to the Music University. And now the Music University has also not made any arrangements for continuation of study of the students, my lordship. The institution.
Petitioners are the students.
Yes, my lordship. And this entire institution is established to educate the students in Gurukula system of education. And now the institution is handed over to the Music University. And Music University has not made any arrangements.
Yes.
I represent the university.
What are you doing?
That is by the government order based on the government notification stating that that is not feasible. The students are not there, and that is the reason why the government issued the notification and it has been handed over.
Now, what have you done? What have you done after it was handed over to you?
Handed over, we have taken it and they have filed the writ petition and they have opened the state.
What are you proposing to do?
As per the government decision, we will continue. If the government comes with
You are the university.
just initially the DC is the respondent number 5 is the caretaker of that Gurukula. And initially it was taken care by them. And for the reason that it is not feasible, the students are not taking admission. Only one student is in the Gurukula. And for that reason,
21 ಜನ ಇದ್ದಾರೆ ಇಲ್ಲಿ.
that is what the government.
18 ಜನ ಇದ್ದಾರೆ. 18 students before us.
They have taken the admission, formal admission they have been taken.
Yes.
And but they are not
Attend-
actual
attendance.
present ಇಲ್ಲ. Actually admission ತಗೋದು ಹೋಗೋದು. That's
Attend-
the reason. And it is not-
No, my lordship. That is
Why
that,
would
that
they
is
want
not
to
the
come
case.
to court if they have not taken admission?
ಅಲ್ಲ ಅಟೆಂಡೆನ್ಸ್ ಇರ್ಬೇಕಾದ್ರೆ ಬರೀ ಅಡ್ಮಿಷನ್
ನೀವು ಅಟೆಂಡೆನ್ಸ್ ಕಂಡಕ್ಟ್ ಮಾಡಿದೀರಾ? ಏನ್ ಮಾಡಿದೀರಾ ಅಂತ? ಅವ್ರು ಏನು ಮಾಡಿಲ್ಲ ಅಂತ ಇದ್ದಾರೆ.
Annexure J-ದಲ್ಲಿ that is mentioned.
Give us your attendance book.
That-
Attendance book ಕೊಡಿ. Attendance register.
My lords, we have earlier it was under the respondent number 5. They were taking it was under the DC Dharwad.
It was handed over to you on 28 to 24. Where is the attendance register from 29 to 24?
I'll submit the memo of the objections along with the relevant documents.
And who is respondent number?
Respondent number 5 is working president and deputy commissioner Dharwad is working
Number
president.
5 ಯಾರಿಲ್ಲ, 4 ಅಷ್ಟೇ ಇರೋದು.
4, my lordship.
Respondent number 4.
He's been served.
Page annexure J, page
The
number.
deputy commissioner deputy commissioner is the working
Deputy
president.
commissioner.
And AGA accepts notice for respondent number 4 also.
And kindly see annexure E, my lordship, for a moment.
Maintain ಮಾಡಿದೀರಾ, Mr. Kannur?
That I have to file objections, Your Lordship, to the petition also.
Have you maintained attendance register?
That, at present, Your Lordship, I have no instructions.
All the admission cards have been given. End of course is 31/3/26. ನೀವು ಏನು ಮಾಡಲ್ಲ, ಅವರು ಏನು ಮಾಡಲ್ಲ ಅಂದ್ರೆ ಸ್ಟೂಡೆಂಟ್ಸ್ ಏನ್ ಮಾಡ್ಬೇಕು?
Annexure J it is mentioned. Annexure J ದಲ್ಲಿ.
Page
77. Type copy is available at page number 77. ವಿದ್ಯಾರ್ಥಿಗಳು ಅನಧಿಕೃತವಾಗಿ ವಾಸವಾಗಿದ್ದು ಹಾಗೂ ಎಲ್ಲ ವಿದ್ಯಾರ್ಥಿಗಳು ಹಾಜರಾತಿ ಶೇಕಡ 40ಕ್ಕಿಂತ ಕಡಿಮೆ ಇರುವುದನ್ನು ಗಮನಿಸಿ. ವಿದ್ಯಾರ್ಥಿನಿಲ ವಾಸಿಸುವ ವಿದ್ಯಾರ್ಥಿಗಳು ಈ ಕೂಡಲೇ ವಿದ್ಯಾರ್ಥಿನಿಲಿಂದ ತೆರಳು ಮಾಡಲು ಈ ಮೂಲಕ ಆದೇಶಿಸಿದೆ. That was challenge and that is they have obtained this.
They are staying in the hostel.
Only this order, this circular is issued after the taking over of the institution. And the government, either the government or the music university has not made any arrangements for the students. And now they have issued this.
What arrangements do you want?
Pardon?
What arrangements do you want? ಏನು arrangement ಬೇಕು?
ಅಲ್ಲ, ಈ ಸ್ಟೂಡೆಂಟ್ಸ್ kindly see annexure E, my lordship, for a moment. And this is not an institution of formal education to give the degrees, my lordship. It is established to propagate and to educate the students in Gurukula system of education. And here, this is one Tiluvalike Patra issued to one of the students in page number 43, my lordship. ಇಲ್ಲಿ 3ನೇ ಪ್ಯಾರಾದಲ್ಲಿ ಅವರು ಹೇಳ್ತಾರೆ, ಗುರುಕುಲದಲ್ಲಿ ಸದರಿ ಸಂಗೀತಾಭ್ಯಾಸವು 15/2/2023 ಪ್ರಾರಂಭವಾಗಿ ಮುಂದಿನ 4 ವರ್ಷಗಳ ಕಾಲ ಈ ಕೆಳಕಂಡ ನಿಯಮಗಳನ್ವಯ ನಡೆಯುತ್ತದೆ. ಸಂಗೀತ ಗುರು ಶಿಷ್ಯ ಪರಂಪರೆಯಲ್ಲಿ ಸಂಗೀತಾಭ್ಯಾಸವನ್ನು ಮಾಡತಕ್ಕದ್ದು. ಅಂಡ್ ಒನ್ ಫೈನ್ ಡೇ ದೇ ಕ್ಲೋಸ್ ದ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್. ಅಂಡ್ ಈ 4 ವರ್ಷ ಅವರು ವಿದ್ಯಾಭ್ಯಾಸ ಮಾಡುವಂತಹದ್ದಕ್ಕೆ either the government or the university has to make some arrangements for the continuation of education. And kindly see next page, my lordship, point number 17.
Now this is a private trust or a public trust?
Pardon, my lordship?
This is a trust, is a public
trust? It is
trust?
Trust established by the government. And in annexure A and B, it is seen that the government has proposed to establish institution in the presidentship of a deputy commissioner. Government has sanctioned the money. Government has sanctioned the land. ಇಲ್ಲಿ 4 ವರ್ಷ ಅವ್ರಿಗೆ ಶಿಕ್ಷಣ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿ ಒಂದ್ ದಿವಸ ಬಂದ್ ಮಾಡಿಬಿಟ್ರು. And in next page, my lordship, page number 43 for a moment.
Yes.
ಇಲ್ಲಿ ಪಾಯಿಂಟ್ ನಂಬರ್ 17, ಕಂಡೀಷನ್ ನಂಬರ್ 17. ತಾವು ಗುರುಕುಲದಲ್ಲಿಯೇ ಪೂರ್ಣ ಪ್ರಮಾಣದಲ್ಲಿದ್ದು ಗುರು ಶಿಷ್ಯ ಪರಂಪರೆ ಅಡಿಯಲ್ಲಿ ಸಂಗೀತಾಭ್ಯಾಸವನ್ನು ಪೂರ್ಣಗೊಳಿಸಬೇಕಾಗಿದ್ದರಿಂದ ಪದೇ ಪದೇ ರಜೆಯ ಮೇಲೆ ಹೋಗುವುದು, ಸಂಗೀತಾಭ್ಯಾಸಕ್ಕೆ ಗೈರು ಹಾಜರುವುದು ಕಂಡು ಬಂದರೆ ತಮ್ಮನ್ನು ಗುರುಕುಲದಿಂದ ನಿಯಮಾನುಸಾರ ಬಿಡುಗಡೆ ಮಾಡಲಾಗುವುದು. ದಿಸ್ ಇಸ್ ಒನ್ ಆಫ್ ದ ಕಂಡೀಷನ್ಸ್. ಅಂಡ್ ನೆಕ್ಸ್ಟ್ ಮೈ ಲordship, ಪಾಯಿಂಟ್ ನಂಬರ್ 20, ಕಂಡೀಷನ್ ನಂಬರ್ 21. ಗುರುಕುಲದಲ್ಲಿ ಸಂಗೀತಾಭ್ಯಾಸಕ್ಕೆ ಪ್ರವೇಶ ಹೊಂದಿ ಮಧ್ಯದಲ್ಲಿಯೇ ಸಂಗೀತಾಭ್ಯಾಸವನ್ನು ನಿಲ್ಲಿಸಿ ಗುರುಕುಲವನ್ನು ತಾವಾಗಿಯೇ ತ್ಯಜಿಸಿದಲ್ಲಿ ಸರ್ಕಾರದಿಂದ ತಮಗೆ ಮಾಡಲಾದ ಒಟ್ಟು ವೆಚ್ಚವನ್ನು ಮರಳಿಸುವ ಬಗ್ಗೆ 20 ರೂಪಾಯಿ ಬಾಂಡ್ ಪೇಪರ್ ನಲ್ಲಿ ಮುಚ್ಚಳಿಕೆ ಪತ್ರವನ್ನು ನೀಡುವುದು. ಸ್ಟೂಡೆಂಟ್ಸ್ ಈ ರೀತಿ ಕಂಡೀಷನ್ ಹಾಕ್ತಾರೆ. ಅಂಡ್ ದೇ ಕ್ಲೋಸ್ ದ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ವಿಥೌಟ್ ಮೇಕಿಂಗ್ ಎನಿ ಅರೇಂಜ್ಮೆಂಟ್ ಫಾರ್ ಕಂಟಿನ್ಯೂಷನ್ ಆಫ್ ದೇರ್ ಸ್ಟಡೀಸ್ ಫಾರ್ 4 years. It is legitimate expectation of the students that they will get education for 4 years. And now it has been handed over to the music university. And these students who took admission in this institution, some of them have completed their master degree in music. And now they have taken admission in this institution. Their expectation is they will learn the music in the Guru Shishya Parampara. And renowned musicians of our nation, they are teaching there. And some of the ex-students, they have giving stage programs and they are budding artists. And the whole purpose is to propagate and to educate.
How can a
I
deputy
will,
commissioner run such a?
I will file my objections along with the attendance, Your Lordship, everything.
But how can the deputy commissioner run such an institution?
I will file my objections.
Because
Your Lord-
what
I will put in writing, Your Lordship, what is the attendance made only after admission if they remain absent, Your Lordship.
So file your qualification of the deputy commissioner as to how you can run this institution. Is he going to be the guru here?
Because, Your Lordship, in the pay number 70, that, Your Lordship,
File all your documents as to who are the gurus who have been appointed, what is the payment that is made to them, which are the classes they have taken, when they have taken, and how many students have attended.
yes.
Not student attendance.
No, because the order is passed, Your Lordship, because of the scarcity of the students, out of 31, only 31 students were admitted.
Students or scarcity of teachers.
No, because 31 students were only admitted, Your Lordship, in that institution, and Your Lordship, in the pay number 70 mechanism, Your Lordship.
Page number?
70. It is the of the impugned order in excess G. Last paragraph, Your Lordship.
Yes.
ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆ ಕೇವಲ 31 ವಿದ್ಯಾ ಬಲವುಳ್ಳ ಡಾಕ್ಟರ್ ಗಂಗೂಬಾಯಿ ಹಾನಗಲ್ ಗುರುಕುಲ ಟ್ರಸ್ಟ್ ಉಣ್ಕಲ್ ಹುಬ್ಬಳ್ಳಿ ಸಂಸ್ಥೆಯ ವತಿಯಿಂದ ಹಿಂದೂಸ್ತಾನಿ ಸಂಗೀತ ಕೇಂದ್ರ ನಡೆಸಲಾಗುತ್ತಿದ್ದು, ಪ್ರಸಕ್ತ ಕೇವಲ 31 ವಿದ್ಯಾರ್ಥಿಗಳು ಅಭ್ಯಸಿಸುತ್ತಿರುವುದರಿಂದ ಸದರಿ ಸಂಸ್ಥೆ ನಿರ್ವಹಣೆಗೆ ವಾರ್ಷಿಕ 213 ಲಕ್ಷಗಳ ವೆಚ್ಚವಾಗುತ್ತಿದ್ದು,
ಎಷ್ಟು ಜನ ಬೇಕು ನಿಮ್ಗೆ ಸ್ಟೂಡೆಂಟ್ಸ್?
because
you say the minimum students will be so and so.
they are not collecting any fee, Your Lordship, that is also.
How many students? So what does it matter to you? Minimum 31 or 500? Where you said the minimum students will have to be so many. Admission ಮಾಡಿ identity card ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದೆ. But Your Lordship, if they regularly attending, Your Lordship, only after admission, Your Lordship.
31 ಜನ ಇದ್ದೀರಾ?
ಅಲ್ಲ.
ನಮ್ 100 ಜನ ಬೇಕು ಅಂತ ಹೇಳಿದ್ರಾ ನೀವು?
ಅಲ್ಲ, ಅಷ್ಟು 30 ಜನ ಎಲ್ಲಲ್ಲಿ?
ನಿಮ್ಗೆ ಎಷ್ಟು ಜನ ಬೇಕು ಮಿನಿಮಮ್?
For that, Your Lordship, I will file my.
You said that.
I will file my objections, Your Lordship.
We'll give you a week's time to file it.
Yes. 2 weeks time, Your
All
Lordship.
these things.
Yes.
Not
2 weeks time, Your Lordship. 2 weeks time, Your Lordship.
No, 2 weeks time. Learn AGA and for respond number.
Respondent number 3.
3. Seek for and are given 1 week's time finally to file their objections. Along with their objections, they are directed to place on record the total number of teachers, lecturers, gurus engaged by the respondents to teach the students at the respond number 3 institution, which is now being handed over to
Respondent number.
at the respond number 3 institution.
Respondent number 3 is university, my lordship.
Music University.
Institution run by respondent number 4 trust.
At the institution run by the respond number 4 trust. The remuneration paid to them, the details of their attendance at the respond number 4 trust, the attendance register of the students, including those of the petitioners, the exams and details of the exams and or classes conducted by respond number 3 and 4. 3 and 4.
Please. Let them.
Let them also file
the affidavit stating that they have taken the parallel admission. Illi admission madisi, they have taken somewhere other, in other colleges, they have taken the admission.
Petitioners would also have to place on record an affidavit that they are full-time students of respond number 4.
And have not taken anywhere
And
admission.
have not taken admission anywhere else. And have given their full time.
Employed anywhere work.
Full time to respond number 4. For their studies at the respond number 4 trust. And further that they have not taken any employment elsewhere since residential accommodation is being made available by respond number 4 to the students. Released on 19th February.
Interim order may be.
Interim order earlier granted is extended till next date,
20th, your lordship.
20th February.
Much of.
39, Chetan Limbikai.
Lord, I seek leave of the court to appear. This is the case, my lord, wherein homeopathic college, last date, your lordships has asked my colleague to, my lord, verify with regarding the judgment of Vedanta Institute. Your lordships kindly recollect, my lord, this is the first stage when COVID was under progress. My lord, physical inspection was not done. And an order was issued, my lord, in appeal also it was confirmed. You lordships were pleased to, my lord, entertain the petition by this direction, my lord. This is the first, after this, my lord,
Yes.
your lordships, it is in respect of granting of 50 seats additional. Only on issue para number 9, my lord, your lordships, regards alleged furnishing of additional documents. In that, the said documents have been supplied and were furnished. Virtual hearing was completed, but before the order was passed. It is not clear from the order of the commission as to whether those additional documents would satisfy the requirement of the applicable law or not. More so when the earlier observation was that there was shortage of only 3 faculties members. Certio, so and so this direction was issued. My lord, in appeal, they says that it is the 3 deficiency, the teachers, my lord, the teaching staffs. In appeal, it says there is a 7 deficiency. Your lordships, after going through this order has been passed. My lord, thereafter, that documents which we have submitted, my lord, for the purpose of academic year 2021 has not been taken note of. Subsequently, my lord, they says that we had all the evidence.
What are the documents that you have furnished?
My lord, the faculty, my lord, a list of faculties, my lord.
Where is that?
My lord, that they have rectified. They says in the next year it is there, my lord. May I request, my lord, page number 24.
They are concerned for the year
2021.
2021.
Yes.
For 2021, what have you furnished?
My lord, these all teachers were existing prior to that, my lord. There is no physical inspection by the
To us, where they have been employed, you made payment of their salaries, their attendance, their biometric attendance, they're taking classes. What have they done?
that we have produced, but in this petition I have not produced
Place
it. I
it
will
on
produce
record.
it, my lord. There is no. Subsequently, your lordships
You have
kindly
paid
note.
salaries for them
I-
for that year.
Pardon, madam.
Best thing is, ನೀವು salary ಕೊಟ್ಟಿದ್ದೀರೋ ಇಲ್ವಾ ಅಂತ.
ಇಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಇಲ್ಲ.
ಅಲ್ಲ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ತಾವೇ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ರ ಅದೆಲ್ಲ ಆ WP ಹಾಕಿದ್ದೆ. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ನಂಬರ್ 32. ಪೇಜ್ ನಂಬರ್ 32.
Supreme Court judgment, now we cannot entertain that. Supreme Court has come down very hard on all the
ಅದರಲ್ಲಿ 300% 3 ಬೆಟ್ ಇತ್ತು ಅದರಲ್ಲಿ. ನಮ್ದ್ರಲ್ಲಿ ಡೆಫಿಷಿಯನ್ಸಿ ಏನಿಲ್ಲ. ನಾವು ಈಗ ದೇ ಸೇಸ್ ದಟ್ my lord, out of 22.
Mr. Desai, you want to interpret the Supreme Court judgment?
No, I will not.
Then you pass your own orders.
No, I'm saying that, my lord.
Give it to your clients.
No.
We are bound by the Supreme Court.
Yes,
order.
I board on.
Not placing any record which we asked Mr. Limbikai to present. We are drawing adverse inference today and dismissing your petition.
We have produced, my lord. That is
What
why
do you
your
want
lordships were there. Order is page number 32. Subsequently, your lordships permitted us to take note. Now, my lord, the issue is, I will produce, my lord. I will produce along with all the memo.
He had appeared, now you are substituting him. And you are trying to argue something different.
No.
Don't do this.
No,
We'll encourage any argument to be advanced by anybody. Don't try these kind of things.
I seek apology, my lord. I am not overreaching, my lord.
Try doing these things.
I still, my lord, I confirm, my lord, my stand with that.
Sit over. If you don't produce by afternoon, we are dismissing it. We have told Ms. Limbikai last time on. Pass over.
You lords have it on tomorrow, my lord.
No.
Tomorrow, my lord, as days.
I
will file.
We will not allow you to address argument, only you will have to address argument. We are allowing you to address. He had already argued this matter.
Since I have appeared in all these matters, my lord,
We are not concerned whether you appeared or not. Last time it was Chetan who had appeared.
I will.
Produce the documents, we'll consider it. If you don't produce, we won't consider.
Tomorrow, my lord.
Not tomorrow.
May I request it tomorrow?
40, GI Chinmat.
I have to bring it, my lord, from the institution.
You bring it.
ಸಂಕೇಶ್ವರದಿಂದ ಇದೆ. ನಾಳೆಗೆ ಫಸ್ಟ್
ಸಂಕೇಶ್ವರದಿಂದ ಇವಾಗ ಬಂದ್ರೆ ಕಾರಲ್ಲಿ ಬರುತ್ತೆ. If they are so interested.
Lords, the petitioner is the
Owner of land bearing survey number 76, my lords.
Interim prayer ಏನಿಲ್ಲ.
Interim prayer.
And AGA accepts notice for respond number
All
1 to
respondents.
6. Counsel for the petition to furnish 2 sets of papers along with documents to the learned AGA who seeks for and is granted 10 days time to obtain instruction, make a submission, released on 21st.
Only prayer is to issue the separate record of rights, my lords. Land, National Highway Authority, my lords, has acquired.
Let him check. ಆಮೇಲೆ ಅವ್ರು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಂಡೆ how is the order passed ಅಂತ ಅವ್ರ ಮೇಲೆ ಬರುತ್ತೆ. Let him
Any short date next week?
21st.
21st, please.
41 CS sector, Trupti Sadekar.
We have taken paper publication, my lords.
Are 6C, 5C, B and C. Sorry,
Sanjeevini Baswant Gaddi, Ashwini Gopal Hawal, Lata Gaddi.
Order sheet. During the pendency of the matter, respond number 4, 5 and 6 had expired. Notice having been issued could not be served on some of the legal representatives, hence IA 1 of 25 was filed for subservice by way of paper publication. In furtherance thereof, a memo of the newspaper publication Tarun Bharat Belgavi edition has been produced. Respond number 5C, 6B and 6C were called out. Neither they are present in person nor anyone answers for them. As such, service of notice on respond number 5C, 6B and 6C is held sufficient. Registry is directed to print their respective names with the endorsement served by paper publication in the cause list. Respond number 5 having expired on
28/8/2019, my lords.
28/8/2019, IA 4, 5 and 6 were filed on
22/2024.
20th February 24. Accepting the reasons stated in support of IA 4 of 2024, the delay of
772 days.
772 days is condoned, subject to payment of cost of rupees 2,000 to the
We have filed the NOC wakalat in this matter, my lords.
ಅದಕ್ಕೆ
Earlier counsel.
1,000 to the advocates clerks benevolent fund. Accepting the reasons stated in support of 5 of 24, the abatement in respect of respond number 5 is set aside by allowing IA 6 of 2024, the person named therein are brought on record as respond number 5A to
C, my lords.
5A to C.
5C.
Counsel for the petitioner to carry out necessary amendment, file amended cause title. During the pendency of the above matter, respond number 6 expired on
21/9/2020, my lord.
hence IA 7 to 9 of 2024 had been filed. Notices have been issued, has been served. Accepting the reasons stated in support of IA 7 of 24, the delay of
572 days.
572 days is condoned subject to payment of 1,000 rupees. By allowing IA 8 of 2024, abatement in respect of respond number 6 is set aside by allowing IA 9 of 2024. The person there named therein are brought on record as respond number 6A to 6E. Counsel for the petitioner to carry out necessary amendment, file amended cause title. Relist on 24th February.
Obliged.
42 HM Dharigond.
Petitioner. First occasion, your lordship, direct the my lord, the second
Direct to the KD.
respondent to produce the my lord, the preliminary and final notification.
Or she sought for 2 days, my lords. That is Santosh KIDV, Santosh Malikwat.
ಎಲ್ಲಿ ಅವರು?
He is engaged in the court number 7. That is.
Pass
ಅದು
it. Yes,
notice-
Mr. Atti.
Final notification ಹಾಜರ್ ಮಾಡ್ಲಿಕ್ಕೆ 2 days ಅಂತ ಕೇಳಿದ.
I produce it by 2 days. I produce it.
ಲಿಸ್ಟ್ ಮಾಡಿದ ಏನಕ್ಕೆ ಪ್ರೊಡಕ್ಷನ್ಗೆ ಮತ್ತೆ 2 days ಅಂದ್ರೆ
Actually, they have to challenge their notification, but they have challenged the notice. I will produce it.
where have you taken possession? You are issued possession
We have issued a 28/6 notice in this matter.
That is challenge, my lord, the.
That is challenge.
27/7/2009.
Yes.
ಆದ್ಮೇಲೆ ಏನ್ ಮಾಡಿಲ್ಲ.
This order granted an interim order. They have filed
Preliminary
an
notification
application.
ಯಾವಾಗ?
2010 madam. Preliminary notification is 2006 and 7.
ಅಲ್ಲಲ್ಲ 19 1995 my lord. ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರಲ್ಲ.
ಇಲ್ಲ. ತಾಯಿಲೆ? 1996.
96.
Where is the notification? Where is the notice issued to them? 28-2 notice ಎಲ್ಲ ಎಲ್ಲಿದೆ?
I have filed a statement of objection.
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ. ಮಾಡಿದ್ದೀರಾ?
The statement of objection my lord, the produced my lord, the award only my lord.
ಇಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ ಕರ್ವಿ ಅವ್ರದ್ದು ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ.
Curvy my lord, the during pendency of the writ petition my lord, the directive my lord, the first respondent.
ಅತ್ತಿ ಅವ್ರದ್ದು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲಿ, KDB ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲಿ.
have produced the award copy.
ಏನಿಲ್ಲ, ಅವಾರ್ಡ್ ಕಾಪಿನೂ ಇಲ್ಲ.
Page 6 when I like Dharwad.
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ.
Along with vacating application my lord, absence by
ಒಂದಿದೆ.
application.
ಟ್ವೆಂಟಿ-ಏಟ್ ಟು ಎಲ್ಲಿ? Shri P.N. Natty, learned counsel for respond number 1, once again seeks for a short accommodation to produce the preliminary notification, final notification, preliminary notification of subsection 1 of section 28, the notice issued under subsection 2 of section 28, the order passed under subsection 3 of section 28, and the final notification of subsection 4 of section 28 of the KIAD Act. Relist on 18th. If the said documents are not produced, adverse inference would have to be drawn and the matter proceeded with.
I'll produce. Sorry.
43, Gurudev Bachinmat.
Carry out the amendment, pass over.
My lordship, 2 days accommodation, my lordship.
Carry out the amendment. Amendment ಮಾಡಕ್ಕೆ
Please.
pass over.
44, Sunil Desai.
It's the deficit amount today morning we have paid, your lordship, and the notice to
Petitioner submit the deficit court fee has been, process fee has been paid today morning, registry to verify. If needful has been done, issue notice to respond number 1 to
1 to 5 the government's, your lordship.
ಕೊಡಿ ಅದು. One to four, five.
By government.
And AGA accepts notice for respond number 1 to 5. ಇನ್ನೇನೆ process fee ಏನೇ ಕೊಟ್ರೆ waste. Learned counsel for the petitioner furnished 2 sets of the petition along with annexures on the said response. Yes, Ms. Sankti, ನಿಮ್ದು objections ಹಾಕಿದ್ದೀರಾ? 7, 9 and 10. Objections ಹಾಕಿದ್ದೀರಾ? ಬೇಕಾ ಬೇಡವಾ objections? ಯಾವಾಗ ಫೈಲ್ ಮಾಡ್ತೀರಾ? Shri B.S. Sankti, learned counsel for respondent number 7 to 10, seeks for and is granted 2 weeks time finally to file a statement of objection. Objections, if any, by 28th February, relist on 3rd March.
Great.
45, Nandish Patil.
Lord, this is the same matter, my lord, which was listed last week, where your lordships had directed them to find out whether regularization is permissible.
So maybe regularization was that regularization penalty, penal clause.
ಅಲ್ಲ ಆಗತ್ತಾ ನೋಡಿದ್ದೀರಾ? ಆಗತ್ತಾ? ರೆಗ್ಯುಲರೈಸ್ ಆಗತ್ತಾ ಅದು ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್?
It is ultimately left to the market committee has to, that is rule 20. Rules. Penal fee. the allotment of site, shop, godown, or shop come godown on lease come sale basis violates any of these rules or the terms of the agreement, the market committee may.
So we'll
cancel the
quash annexure G and H and direct you to consider application for regularization.
Declaration on cost or what's that?
As per the applicable rules. ಮತ್ತೆ ಅವ್ರು ಬರ್ತಾರೆ ಅಷ್ಟು ಜಾಸ್ತಿ ಆಯ್ತು ಅಂತ.
Applicable rules ಅಂತಂದ್ರೆ ಮತ್ತೆ bylaw ಕೆಳಗೆ if it is a deviation is more than 5%, 500 rupees, that's.
ಅದೇನಿದೆಯೋ ನೋಡಿ. Because we can't go through that. You examine their construction and impose whatever penalty is required to be imposed. If it can be imposed. If it cannot be imposed, demolish.
My lord, in fact, my lord, I had taken instructions insofar as the construction is concerned, my lord. It's very negligible for the reason being, my lord, the go down is permitted, my lord, 20 feet at the back portion.
Nandish, it
Only
is not
front portion, my
negligible
lord,
question.
office is constructed.
Negligible question, Allah. If it is in accordance with law, they will do it.
Please.
If it's not, they will demolish.
Please.
Petitioner is before this court seeking for the following reliefs. The allegation made against the petitioner is that the petitioner had only obtained permission for construction of a ground floor as a godown, but however, the petitioner has put up a first floor office without permission from the respond number 2. And it is in that background that the impugned order dated 10/1/2020, 19/2/2020, and 23/2/2019 at annexure G, H, and E respectively had been passed, directing the demolition of the unauthorized portion.
Lord, one more reason is, my lord, that we had not taken completion certificate.
ಪ್ಲಾನೇ ಇಲ್ಲ ಅಂದ್ರೆ ಕಂಪ್ಲೀಷನ್ ಎಲ್ಲಿ ಬರುತ್ತೆ ನಿಮ್ಗೆ? ಫಸ್ಟ್ ಪ್ಲಾನ್ ತಗೊಳ್ಳಿ, ಆಮೇಲೆ ಕಂಪ್ಲೀಷನ್. Having heard both the councils and having gone through the papers, it is seen that it's only an additional construction which had been put up by the petitioner. The said construction can also be a said construction in terms of Rule 20 of the Yav rules.
So Karnataka allotment of property in market yard rules 2004.
So and so can also be regularized by the petitioner submitting one more application for plan sanction of the additionally constructed area. Of course, by the respond number 2 levying such penalty and charges as are permissible under law. In that view of the matter, when the construction could be regularized, and the considered opinion that there would be no purpose served by demolition thereof. As such, I pass the following order. Writ petition is partly allowed. Certiorari is issued, so and so, so and so, so and so is quashed. A mandamus, the submission of learned counsel for the petitioner that the application for a modified plan sanction will be submitted within 10 days from now. The respond number 2 is directed to consider the said plan, application for modification of plan sanction within a period of 30 days thereafter and pass necessary orders in accordance with law. Until then, the respondents are restrained from demolishing any portion of the property. In the event of the regularization not being capable of being done and or the plan seeking for modification not being in accordance with the building bylaws applicable, the respondents would be free to initiate fresh proceedings for demolition of the portion of the building which cannot be so regularized.
Lord, the connected matter is of the adjacent property, Lord. The common order may be passed. 182 and 183 site numbers.
Same
order. Everything else is same.
Same order, separate order.
Obliged.
46, Madan Mohan Kannur.
6 weeks time to take steps. The respond number 1 is ready, your lordships. Applications are ready, your lordships.
Time is granted to the counsel for the petitioner to file necessary application to bring the legal representative of deceased respond number 1 on record. If needful is not done by 21st, formal orders of dismissal of the petition and so far as respond number 1 is concerned, as abated would have to be passed. Relist on 3rd March.
Please.
47, dear Lord Khan.
2 weeks time, my lord.
Same 2 weeks time
Please.
by 21st, 3rd.
48, SN Bankar.
I pray for times. Next time I'll argue the matters. Because
Stay ಇದೆ Mr. Bankar, time ಕೆಳಕ್ಕಾಗಲ್ಲ.
the other two suits I have already produced, my lord. They have already disposed of. The second wife, she has no locus standi. She is not a legally wedded wife. Like,
Argument
it
ಮಾಡ್ಬಿಡಿ.
has been held, my lord.
ರೆಡಿನಾ ಆರ್ಗ್ಯುಮೆಂಟ್ಗೆ?
Next week.
2016 suit has been stayed, my lord, since my lord, 2020.
Subsequently, they have filed another suit. In that
ಇಲ್ಲ
suit,
ಗೊತ್ತಿದೆ, ಒಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬಿಟ್ರೆ ವಿಲ್ ಡೀಲ್ ವಿತ್ ಯು ಮೇ ಸಕ್ಸೀಡ್ ಆರ್ ಯು ಮೇ ಲೂಸ್, ವಿ ಡೋಂಟ್ ನೋ.
next week, Martha.
At the request of counsel for the petitioner, finally released on 18th February, it is made clear that no further adjournment would be granted. If arguments are not advanced, the petition would be liable to be dismissed for non-prosecution.
Please, ma'am.
Interim order earlier granted is extended till next year.
49, dear Lord Khan.
Lord, objection at serial number 3 is already complied, my lord. Court fee, deficit court fee is already paid on 20th
Counsel for the
September
petitioner
2020.
submit that he has complied with office objection serial number 3.
As far as the other objection is concerned, my lord, I have produced the certified copies of the photographs which have been taken by the very local body, my lord. The office has directed
Counsel
me
for
to
the
produce.
petitioner submit that what has been produced at annexure J1 to J6 are the photographs submitted by the respondent authorities and he does not have the originals thereof.
There is
As
a-
such, accepting his submission, office objection at serial number 27-1 is overruled. Yes.
A matter wherein, my lord, a resolution came to be passed by the Gram Panchayat, wherein my name was entered in the year 2014.
Instructions ಇದೆಯಾ? ಯಾವಾಗ? At the request of counsel for
Lords, I appear for the
6.
respondent in
Really?
serial number 51, my lords.
This is not 51, Mr. Counsel.
Yeah.
Respondent number 6 released on 20th.
Please.
50, Venkatesh Harvey.
We'll have it on Friday, my lords. Regarding the complaints, we are already complied in an order ಮಾಡಿದ್ರು. We appear by the general secretary, the principal secretary, and produce all the document. In respect of that, I have produced the document also. And we'll have it on Friday, my lords.
For the petition
Friday.
released on 14th.
Please, 14, please. Interim order ಇದೆ, ಅದು continue.
Interim order earlier
ಇದೆ,
granted
ಇದೆ.
is extended.
51, Vijay Kumar Varatti.
My lords, I appear for the respondent, my lords, in this matter.
Yes.
Petitioner, my lord, petitioner has sought for a mandamus to consider the representation annexure E. My lord, annexure E, he is seeking for restoration of the land which was acquired. But the purpose for which it was, the acquisition proceedings were initiated in the year 1987 for the purpose of hydroelectricity project, Kali River hydroelectricity project. But my lord, he has received a compensation. But until today, my lord, the purpose for which it was acquired, that has not been, my lord, utilized for.
So you want back the possession, you will give back the compensation along with interest.
It is,
Yes.
it is 17,000.
We have filed our objections, my lords. The land that was acquired forms part of the area, my lords, where the backwater is stored. So in the event of there being floods or any such situation, my lords, then this land acts as a catchment area. Therefore, my lords, now to say that it is not being utilized for the said purpose is not tenable, my lords.
Now the objects, please.
It is required for submergence when the land, it's full anta idare. Capacity is 147 TMC.
Not, sir. They submit that, my lord, it forms a backwater of a Kali River hydro project. But as per the instructions I have obtained from my client, the said dam was ought to be, the acquisitions were initiated for the purpose of construction of a dam to one Moolangi Falls. There is a Moolangi Falls. The said, my lord, after acquisition, my lord, it was objected by many environmentalists. So, my lord, that project was dropped. And even now in objection, they state that, my lord, it forms a backwater. Until today, the backwater has not come, and even, my lord, as per my instruction, 12A, which is adjacent to this land, it has been converted to NA.
If they were to say that they don't need it, then we could have directed them. When they say they need it and the acquisition is completed, we can't direct them.
And now, my lord, on
Compensation ನೀವು ತಗೊಂಡಾಗಿದೆ.
ತಗೊಂಡಿದ್ದಾರೆ, I admit.
12, it is the acquired, the land in dispute is 12B, my lord. In respect, they say that it is required for storing of backwater, but has to regarding 12A, which is adjacent to that, my lord. That land has been converted to NA.
If you are in possession, you continue doing your agriculture activities.
I have only sought for mandamus. That
Mandamus kuda. There's no vested right. Vested right is there we can give. There's no vested right for you to seek for that. Petitioner is before this court seeking for the following reliefs. The petitioner's land in survey number 12A and 12B.
12B, only 12B.
12B had been acquired for the purpose of establishing the Kali River Hydro Project in the year 1987, and compensation in regard thereto had been paid by the respondent number 5 to the petitioner's father. The petitioner is before this court now alleging land of the petitioner has not been used and has continued to be in possession of the petitioner, and as such a representation has been submitted by the petitioner for giving up the said land, restoration of the said land, on the petitioner returning the compensation amount, while representation dated 12/2/2024 at Annexure E has not been considered. And in that it's in that background that the aforesaid reliefs are sought for. Now, counsel for respondent number 5 to 7 submit that the land of the petitioner forms part of the area where the, what have you said exactly?
In para 3 it is.
Lands of the petitioner forms part of the backwaters of the river and acts as a buffer when the water in the dam reaches close to its capacity. The powerhouse having been established, generators being operational, the capacity, if the dam is in capacity, then the land of the petitioner also being submerged, there's no question of the return of the land to the petitioner as claimed for. The petitioner having received the compensation long ago, the land being required for the beneficiary, it cannot be handed over. In view of the said submission, there would be no vested right in favor of the petitioner seeking for the mandamus as sought for.
My lord.
In that view of the matter, the petition stands dismissed.
Also, the Assistant Commissioner of Karwar has responded to the query. My lords. I have attached the document.
Anyway, he doesn't have any right to.
Right.
Bill number?
Bill number 7.
7. 7 at the request of counsel for the petitioner, relist on
Next week.
20th.
Serial number 57, my lords.
57.
Weeks accommodation may kindly be granted, my lords.
At the request of counsel for the petitioner, 10 days time is granted to comply with the office objection. If office objection not complied by 20th, relist on 24th for dismissal.
Respondent, my lord's copy has been served today. 2 weeks time to file with instructions.
Who is for the petition? Inform madidira?
Pooja Savdatti.
Will inform better. Have you informed?
Number 100, my lord.
Century. Last time you had scored 99, now you are scoring
And
70.
then final hearing, just short, on the short accommodation.
Inform madidira?
I am for the petitioner.
At the request of counsel for the petitioner, relist on 17th.
ಇಲ್ಲಿ ಸರ್ ಕರೆದಿಯಾ ಅಲ್ಲೇ ಸರ್ ನಿಮ್ಮ ಎದುರುಗಡೆ ಅನ್ಕೊಳ್ಳಿ ಕಂಟಿನ್ಯೂ ಮಾಡಿ ಸರ್
Sir, 60 at the date.
Sir, then
230, no? Okay.
Dharwad bench matter, cell number 52, KL party.
Petitioner is before this court seeking for the following leave. A memo dated 31/1/25 has been filed, signed by the petitioner and the counsel for the petitioner, which reads as under. Accepting the said memo and the submission of counsel for the petitioner, petition dismissed as withdrawn.
Please.
53, Jagdish party.
This, my lord, I'll file application during the course of the day.
Application,
Please.
non-filing of amendment application. Counsel for
Application
the
is ready, my
petitioner
lord.
seeks for and is granted 2 days' time to file the amendment application. Released on 14th.
Obliged.
54, VM Shilwant.
Office has raised an objection to effect that typed copy of annexure A, my lords. Lords, I have given a submission that it's a legible copy. Annexure is a registered relinquishment deed.
A peril of annexure A indicates that the same is legible. Hence, office objection at sale number 17 is overruled. Yes.
Lords, it's a short matter. Lords, respondent number 3 and 4 are the owners of the land bearing survey number 134/1/4, my lords. My lords, and they have relinquished the property in favor of petitioner, my lords, to the extent of 11 acres, 27 guntas and 20 acres. And J form was also communicated to respondents, my lords. In spite of that, they have now not mutated my name. And the revenue inspector, my lords, have raised the objection and stated that the Akar Bandi and Perni is not matching. On the basis of that, he has referred to Tashildar. Tashildar has ordered my lords to delete the mutation entry, my lords. And the same was confirmed by assistant commissioner as well as deputy commissioner. As such, I am before this court, my lords.
The Akarband and Pani are not matching.
Please.
Why are they not matching?
Lords, my contention is they are matching, my lords, as there is a registered relinquishment deed. Even the respondent number 3 and 4 are not disputing it, my lords.
ಇಲ್ಲಿ ಅವ್ರ ಇಂಟ್ರೆಸ್ಟೇ ಇವಾಗ ಕ್ವಶನ್ ಅಲ್ಲಿ ಇರೋದು. Where is the Akarband?
Lords, Akar Bandi I have not produced. Akar Bandi and Perni. I'll produce it, my lords.
Learned AGA accepts notice for respondent number 1 to 3, 4 and 5.
4 and 5 take notice, my lords.
Issue emergent notice to respondent number 4 and 5. Counsel for the petitioner is also permitted to take out and summons to respondent number 4
Lords,
and
have also sought for interim order, my lords.
Released on 25th February.
Not to enter the name only, that, my lords.
ಇನ್ಯಾರ ಹೆಸರು ಮಾಡಬೇಕು? ನಿಮ್ 3 ಜನದ
Handedly they are doing.
There's no interim order. Accepting reason stated IA 1 of 25 dispensation of Annexure C.
55, DLR Khan.
Not a case wherein the properties which were already parted
No
by.
counsel submission, 28 and 29. Office objection.
ಅಲ್ಲ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ ಆಲ್ರೆಡಿ 28-29 ಕೋರ್ಟ್ ಫೀ ಮತ್ತೆ ಇದಿತ್ತು ಅದು ನೆಸೆಸರಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದನ್ನು ಕರೆಕ್ಷನ್ ಮಾಡಿದ್ದೀನಿ ವಿತ್ ಪರ್ಮಿಷನ್ ಆಫ್ ದ ಕೋರ್ಟ್ ಆನ್ ದ ಪ್ರೀವಿಯಸ್ ಒಕೇಶನ್ 2 ಡೇಟ್ ಹಿಂದೆ ಡಿಫೆಂಡೆಂಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಆಗಿತ್ತು ಡಿಫೆಂಡೆಂಟ್ ಅಂತ
ಎಲ್ಲಪ್ಪ 28-29. Rank of parties. Counsel for the petition submitted that he has complied with office objection at CL number 28 and 29. Registry to verify. Yes.
As per the direction of this court, I was directed to disclose the number of properties already parted with by the plaintiff number 1. And this honorable court in earlier, while sitting as a division bench, has already held that those properties already parted will not be available for the plaintiff for partition. Memo is already filed and copy is already served well in time, my lord.
Yes.
My lord, I heard. In 1954, partition has taken place, my lord.
Hmm. Yes.
Accordingly, three persons have been allotted properties, four persons, my lord. Fakir Reddy, Yella Reddy, Tiraka Reddy, and Govinda Reddy.
Hmm.
Thereafter, my lord, after as per the will, his property is to be distributed among three persons, his son and two grandsons, my lord. After death of Yella Reddy, my lord, his property is to be distributed as per section 8 by way of succession to Tiraka Reddy, Govinda Reddy, and Sri Padmavati. It is not coming on the fourth, my lord. These are the properties which has been allotted to as per the will of Fakir Reddy. After death of Fakir Reddy, Yella Reddy has got these properties. Yella Reddy's properties has been allotted to all three persons. It is not coming, my lord. That's why these property, what is his contention, my lord? These properties we cannot, FDP proceedings, court cannot hold an inquiry on this point.
So you dealt with all the properties, ಅಲ್ಲ ಇಲ್ಲಿ?
ಅದು ಯಾರ್ಯಾರಿಗೆ ಏನ್ ಬರ್ತಿತ್ತೋ ಹೋಗ್ಲಿ.
Heard, reserved. We'll have to go through each one and.
One submission, my lord, regarding the amended plaint that has been produced by the plaintiff at page number 3 for a moment, my lord, wherein the plaintiff has himself disclosed that those properties are not the suit properties. Till then, it has been added as a property in the amended plaint. Page number 3, my lord. There is a tab, my lord, schedule D.
Three of your memo na.
ಇಲ್ಲ ಅವ್ರದ್ದು ಅಮೆಂಡೆಡ್ ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ನಾನು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೇನೆ ಲಾಸ್ಟ್ ಡೇಟಿಗೆ. ಅಮೆಂಡೆಡ್ ಪ್ಲೇಂಟ್ ಒಂದು ಕಾಪಿ ಫರ್ನಿಶ್ ಮಾಡಿದ್ದಾರೆ. ದಟ್ ರೆಫರ್ಸ್ ಟು ಆಕ್ಚುಲಿ ಅದು ಪೇಜ್ ನಂಬರ್ 8 or 9 ಆಗುತ್ತೆ. ಎಟ್ ಶೆಡ್ಯೂಲ್ ಎ, ಆಫ್ಟರ್ ಶೆಡ್ಯೂಲ್ ಎ, ಮೈ ಲಾರ್ಡ್.
ಇನ್ನೊಂದು ಮೆಮೊ ಇದೆ ನೋಡಿ.
ಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡ್ರಿ, ಅಮೆಂಡೆಡ್ ಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅವ್ರದ್ದು ಸಪರೇಟ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಮೈ ಲಾರ್ಡ್. ನಮ್ದು ಅಮೆಂಡೆಡ್
ಅದರಲ್ಲಿ ಇದೆ.
Yes, page 3.
ಶೆಡ್ಯೂಲ್ಸ್ ಶೆಡ್ಯೂಲ್
ಎಫ್ ಕಾಣಿಸ್ತೈತೆ. ಎಫ್ ಶೆಡ್ಯೂಲ್ ಎಫ್,
ಶೆಡ್ಯೂಲ್ ಡಿ ಅಂತ ಬರುತ್ತೆ ಸ್ವಾಮಿ.
ಎಫ್
ಇದೆ.
ಶೆಡ್ಯೂಲ್ ಸಿ, ಆಫ್ಟರ್ ದಟ್ ಇಂಟರ್ನಲ್ ಪೇಜ್ ನಂಬರ್ 3 ಒಂದು ಹಾಕಿದ್ದಾರೆ. ಶೆಡ್ಯೂಲ್ ಡಿ, ಗೋವಿಂದ ರೆಡ್ಡಿಸ್ ಪ್ರಾಪರ್ಟಿ, ಶೆಡ್ಯೂಲ್ ಡಿ. ಅದರಲ್ಲಿ ಟು ದ ರೈಟ್ ಸೈಡ್ ಕಾಲಮ್, ಮೈ ಲಾರ್ಡ್. ಪೇಜಿನೇಷನ್ ಡಬಲ್ ಆಗಿದೆ ಸ್ವಾಮಿ ಅದರಲ್ಲಿ. ಆಫ್ಟರ್ ಆಕ್ಚುಲಿ ಅದು 12 ಆಗ್ಬೇಕಾಗಿತ್ತು.
Schedule is annexure A.
ಅದ್ರ ನಂತರ ಆಫ್ಟರ್ ದಟ್ ಪೇಜ್ ನಂಬರ್ 3 ಅಂತ ಮೇಲಿದೆ ಶೆಡ್ಯೂಲ್ ಡಿ.
Yes.
ಟು ದ ರೈಟ್ ಸೈಡ್ serial number 1 and 2, 84, 49. Not a suit property, not a suit property.
Yes.
The plaintiff wants to reopen the case in spite of the order, suffering an order from the division bench, my lord. And now wants to reopen the case by saying that those are the things which are required to be inquired into by the.
Yes.
Neither these were the properties in the suit, my lord. Now, is it permissible for the plaintiff to incorporate those properties which were not the part and parcel of the entire suit schedule properties?
My lord, annexure ಎಫ್ ಅವರವರೇ ಹೇಳಿದ್ದು, ಅದು ನಂಬರ್ಸ್ ಎಲ್ಲ ಚೇಂಜ್ ಆಗಿದ್ದಿದೆ. ನಾವು ಹೇಳಿದ್ದೀವಿ ಯಾವ್ದಾದ್ರು ನಾಟ್ ಸೂಟ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ ವಿ ಆಲ್ಸೋ ಸ್ಟೇಟೆಡ್. annexure ಎಫ್ ವಿಚ್ ಇಸ್ annexure ಇ, ಮೈ ಲಾರ್ಡ್, ಅವ್ರು ತಾವು annexure ಎಫ್ ಒಳಗೆ ಹೇಳ್ತಾರೆ ದೀಸ್ ಆರ್ ದ ಪ್ರಾಪರ್ಟೀಸ್ ಆಫ್ ಯಲ್ಲಾ ರೆಡ್ಡಿ. We say that these are not the suit properties in the year 1954. We do not know, my lord, subsequently Yella Reddy has acquired that suit property or not. ಅವರೇ ತಮ್ಮ ಮೆಮೊ ಒಳಗೆ ಹೇಳ್ತಾರೆ these are the properties which is Yella Reddy annexure F in their memo. Para number 8, my lord. Nine, 8 and 9.
ನಿಮ್ಗೆ ಹೇಳಿದೆ ಆಸ್ ಪರ್ ದ ಜಜ್ಮೆಂಟ್ ಮಾಡಿ ಅಂದ್ರೆ ನೀವು ಇಬ್ರು ಆಸ್ ಪರ್ ವಾಟ್ ಯು ವಾಂಟ್ ಯುವರ್ ಫೈಲ್ ವಿಲ್ ಗೋ ಥ್ರೂ ದಿ ಜಜ್ಮೆಂಟ್ ಅಂಡ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್.
Please, my lord.
These memos, we won't be referring to these memos because your memos, both the memos are what you want to file.
ಅಲ್ಲ
This is not as per the judgment.
ಅಲ್ಲ ಅದು ಜಜ್ಮೆಂಟ್ ಕಾಪಿ ಇದೆ ಇಲ್ರಿ
Mr. Ladkan, it is not as per the judgment.
ಅಲ್ಲ ಅದು ಕಾಪಿ ಇರ್ಲಿಲ್ಲ ಜಜ್ಮೆಂಟ್ ಕಾಪಿ ಪ್ರೊವೈಡ್ ಮಾಡಕ್ ಕೇಳ್ತಿದ್ದೀನಿ
Judgment copy ನಮ್ಮ ಹತ್ರ ಇದೆ.
RF ಇದು
RFA judgment copy ಇದೆ.
ಪ್ಲೀಸ್ ಮೇಡಮ್ ಪ್ಲೀಸ್.
ನಿಮ್ಗೆ ಅದ್ರ ಪ್ರಕಾರ ಮೆಮೊ ಹಾಕು ಅಂತ ಹೇಳಿದ್ವಿ ಇಬ್ಬರಿಗೂ.
ಅಲ್ಲ ಅದರಲ್ಲಿ ವಿ ಹ್ಯಾವ್ ಡಿಸ್ಕ್ಲೋಸ್ ದ ಪ್ಯಾರಾ ಇನ್ ವಿಚ್ ಇಟ್ ಇಸ್ ಬಿನ್ ರೆಫರ್ ಟು ಬೈ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇಡಮ್. ಪ್ಲೀಸ್ ಮೇಡಮ್.
ರಿಸರ್ವ್.
ಪ್ಲೀಸ್.
ನಾವು ಹೇಳಿದ್ದು 19 ತಿರುಕರೆಡ್ಡಿಗೆ ಫಕೀರೆಡ್ಡಿಗೆ ಯಾವ್ದು ಬಂತು ತಿರುಕರೆಡ್ಡಿಗೆ ಯಾವ್ದು ಬಂತು.
This litigation will not end.
ಪ್ಲೀಸ್ ಮೇಡಮ್.
56
ನೀವು ಇದ್ರಿಗೆ
ಮೆಮೊ ನೀವು ಡ್ರಾಫ್ಟ್ ಮಾಡಿದ್ದ ನಿಮ್ ಕೌಂಟರ್ ಪಾರ್ಟ್ ಡ್ರಾಫ್ಟ್ ಮಾಡಿರೋದ
ಅಷ್ಟೇ ಆಗಿದೆ.
ಎರಡು ಕೌಂಟರ್ ಪಾರ್ಟ್ ಕಳ್ಸಿದಾರೆ ನೀವು. ನಿಮಗ್ ಕೇಳಿದ್ರೆ ಅವ್ರಿಗೆ ಹೇಳಿದ್ರಿ ಅವ್ರಿಗೆ they want to perpetuate the litigation. They will not allow this matter to settle or come to a close. And the litigants also are getting the way the memos, we are not
They
saying
are all
anything.
family members, my lord, they have to maintain some relations, that's all. That's in fact, my lord.
Unfortunately, you have filed it. If we say anything, it will be against both of you.
Yes, yes.
But we know it is not drafted by both of you. Alva, ಹಿಂದೇನು ಡ್ರಾಫ್ಟ್ ಇಲ್ಲ ಅದರಲ್ಲಿ.
ಪ್ಲೀಸ್
ನೀವು ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ, ನೀವು ಒಂದ್ ಸ್ವಲ್ಪ ನೋಡ್ಬಿಟ್ಟು ಫೈಲ್ ಮಾಡಬೇಕು. ಅದನ್ನು ನೀವು ಮಾಡಲ್ಲ ಅಂತೀರ. You are under their.
ಇಲ್ಲ.
They may be your counterpart lawyers, but you should tell them. Now what observation will make will as if it will be as what you have filed. That counterpart lawyer has not signed anything. So it will look as if it is, our observation will be against Mr. Ladkan and Mr. Vivek Mehta.
Please.
They will be sitting there and having a nice laugh. But now it will reflect your name what to do. Reserved.
Please, bro.
56 Pooja Saudatti.
What is this objection, madam?
It's intake of 100 students for admission, my lord. 15th is the last date.
43(8)(a). ಎಲ್ಲಿದೆಯಪ್ಪ 43(8)(a)? 43(8)(a) ಎಲ್ಲ ಕ್ಲರಿಕಲ್ ವರ್ಕ್ ಆಗುತ್ತೆ. Yes, what is this?
My lord, it is of the admission, my lord. There was a rectification of the order sought for from the respondent, my lord.
50 students have been sanctioned.
Yes, my lord.
Where
Whereas
is it
100 students have to be admitted.
Where is that order?
My lord, page number 10, my lord, the NCT order. Whereas in the first paragraph, it says 50 unit, per unit 50 students, whereas in the third paragraph, they have clearly stated, now therefore in exercise of the powers vested under section 14 clause 3A of NCT Act 1993, the regional committee NCT hereby grants recognition to IBMR College of Education, so and so Vidyanagar Hubballi, for conducting B.Ed program of 2 years duration with an annual intake of 100 students from the academic sessions 2016-17 under clause 716 of NCT recognition regulations, my lord. Whereas they have already given a representation, my lord. It is at the page number 16 and 17, my lord, annexure F. In the month of December, my lord.
ಎರಡು ಯೂನಿಟ್ಗೆ 100 ವಿದ್ಯಾರ್ಥಿಗಳು ಅಂತ ಬರೆದಿದ್ದಾರಲ್ಲ page 17 ಅಲ್ಲಿ.
My lord, annexure E, page number 15, by the respondent, Sharat Tubad
Submission is.
The notification given as 50 students per semester, my lord.
ಪ್ರತಿ ಸೆಮೆಸ್ಟರ್ಗೆ. Yes.
Lord, today at 12 PM copy is served.
My lord, on 7th.
Today, my lord, copy is served at 12 PM.
My
Today.
lord, my lord, on 7th, this case was posted. The counsel was absent, my lord. He was on leave. And
Let counsel for respondent submit that he has received the copy of the petition today. He seeks for and is granted.
15th is the last day for admission, my lord. Tomorrow or day after
ನೀವು
tomorrow.
ಸರ್ವ್ ಮಾಡೋದು ಬೇಡವಾ?
My lord, I searched the colleague of the advocate also, he was not present during that.
I'll take instructions and make submission, my lord, tomorrow.
The order is
Tomorrow?
clear, page 10.
Other note.
It's 100.
My lord, just now I spoke to my lord the registrar. What is, my lord, informed to me is that for 2024 and 25, my lord, the college failed to, my lord, fulfill the minimum criteria. Your lordship may kindly see the order itself. Minimum, my lord, points that were required to be, my lord, fulfilled, my lord, by the college were 40. Whereas the assessment, my lord, the college could fulfill only 37.26, my lord, marks. So only for 2024-25, my lord, the affiliation, my lord, to the intake of, my lord, 50 has been, my lord, given due to, my lord, college failing to, my lord, meet the minimum requirements.
ಒಂದು ವರ್ಷ ಅವಧಿಗೆ ಮಾತ್ರ.
ಹೌದು. For this year, my lord, the college failed to meet assessment criteria. It has, my lord, below minimum, my lord, points which, my lord, college is required to, my lord, fulfill is 40. For 2024-25, my lord, when the college was assessed, my lord, on the parameters laid down, my lord, by the government, it could only, my lord, meet 37.26. ಅದಕ್ಕೆ only for this year, my lord, intake is restricted to 50. Again, I am told, my lord, their application is under consideration for, my lord, 100 seats for 25-26, likely to be.
ಇದು 24-25.
ಇದು ಬರೇ 24-25 ಗೆ ಅಷ್ಟೇ.
There is no such notification given to the petitioner, my lord, with regard to this, the change of the marks or the percentage.
Today is the last date for making payment of fees.
15th is the last date, my lord.
15th is the last
February
date
for admissions.
Fees, admission.
15th.
Let
Tomorrow, my lord.
Let counsel for response submit that he has received the petition copy today morning. He seeks for 2 days' time to obtain instruction, make his submission. We list on 12th.
Much obliged.
In the meanwhile, office objections to be complied with.
Much obliged.
57 Arjun, 58 Santosh Maligwat.
I appear for petition. The office has raised objection regarding typed copy of annexure B and E. They are legible, my lord. Seeking mandamus to expeditious disposal of the suit, my lord. Since last 3 years, my lord, the suit is pending for objections to the application. Petitioner is 70 years old, my lord. He has instituted a suit for eviction of the lessee. Petitioner is a lessor. Now, lease determined by efflux of time in the year 2015. Thereafter, he is neither paying the rent nor vacating. Now, therefore, a suit for eviction was filed by the present petitioner before the trial court. After he has led his evidence, my lord, on 3/8/2022, petitioner plaintiff filed several applications. Since last 3 years, my lord, defendant is avoiding the trial and seeking time for objections. Since last 3 years, same stage is going on.
You filed an application for recall.
No. Thereafter, on 3/8/2022, 3/8/2022, my lord, I filed 3 applications. One for further evidence, another for production of the lease deed. On those 3 applications, my lord, the defendant has been taking time after time for filing objections. Now the matter was posted up to 6/1/2025. He has not filed any objections. Each adjournment is, my lord, at least 2 months.
Order sheet.
Annexure, my lord. Annexure F is the order sheet, my lord. Internal page number 14. Order sheet 3/8/2022. 3/8/2022 is the application file. 3 applications were filed for further evidence of the plaintiff and production of several documents. ಅದಾದ್ಮೇಲೆ objections ಅಂತ ಹೋಗ್ತಾ ಇತ್ತು.
PW1 absent, PW1 absent, PW1 absent, PW1 absent.
ಇಲ್ಲ several times ಲೋಕ ಅದಾಲತಿಗೂ ರೆಫರ್ ಆಯ್ತು ಸ್ವಾಮಿ. ಅದಾದ್ಮೇಲೆ there was no
You absent ಇದಿರಲ್ಲ.
only on few occasions my lord I was absent.
5
but
occasions.
Yes.
ಅದು few.
Yes.
6, 7.
Yes.
8.
But this is my lord in fact the in charge court that was posted. The objections are not yet filed.
10 occasions you have been absent till
Yes.
now.
Yes. To the stage my lord for the objections he has not filed.
Then the transfer of cases have
Yes,
happened.
yes. In fact it is an in charge court. There is no court there. Each adjournment is 2 months. ಇದ್ ಮಾಡ್ತಾರೆ.
Then you have been absent.
My lord, the stage is for objections. Stage is for objections of the applications. 3 applications objections ಹಾಕಿಲ್ಲ.
ಅದಾದ್ಮೇಲೆ ನೀವೇ absent ಇದ್ದೀರಲ್ಲ.
Yes. Since it is a
4-1 it was posted.
Yes.
2-4 you are absent. 6-8 you are absent. 29-10 they are present.
Yes.
ಅಷ್ಟೇ.
Objections is not filed.
You are not present.
Yes, my lord. This is an in charge court, my lord. This is an in charge court.
So what you don't you
No,
won't
I'm
be
not saying.
present.
I'm not saying that. Yes.
You are present ಇಲ್ಲ.
The
And
stage.
you are asking for a direction.
Yes, it is. The stage was for objections of the defendants. I was not
required to be present.
No, I'm not saying that.
ಮತ್ತೆ?
I'm saying that, my lord, it is every adjournment.
Your submission to take the objection is not filed.
Yes, every adjournment, my lord, 2 months adjournment ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
You are not present on any of those dates.
Some of the occasions I was not present. I was
Order sheet ನೋಡಿ
Yes.
ಸರಿಯಾಗಿ. ನೀವು
Counsel-
ಹೇಳಿ.
Yes.
Objection taken as not filed ಮಾಡಿ ಅಂತ.
Some directions.
Can't give any
ಯಾಕಂದ್ರೆ
direction.
ಅವರು
ನೀವೇ present ಇಲ್ಲ ಅಂದ್ರೆ how can we give
2018 ಇಂದ 2018 suit is of the year
direction?
2018.
Before this court
May
seeking
pray
for
once.
the following reliefs.
One submission.
Notice to respondents is dispensed with the new of the order proposed to be passed. The grievance of the petitioner is that the applications filed by the petitioner on 3/8/2022 for recall of the order posting the matter for defendant evidence, permission to lead evidence of the plaintiff, and production of documents is pending without any orders being passed thereon. A perusal of the order sheet would indicate, and it's in that background that the above reliefs have been sought for. A perusal of the order sheet would indicate that the petitioner, as also his counsels, have been absent on several occasions.
On some of the occasions they were present.
All ಅಂತ ಹೇಳಿಲ್ಲ
Yes,
ಅದಕ್ಕೆ. On several occasions. And the matter had also been referred to Lok Adalat for settlement, which could not be so settled. And thereafter, there being a change in the internet arrangement, the case was transferred to another court. And subsequent thereto, the petitioner's counsel has remained absent. When the fault lies with the petitioner in not appearing in the matter and making his submission, no direction, no allegations could be made that the matter has been pending for a long time.
Please.
I do not find any
Lord,
reason to pass the orders which have been sought for. The petition stands dismissed.
One submission. 2018 in the suit pending. Some directions too. At least objections not filed ಅಂತಾರ.
We will observe that you are not appearing and the court should dismiss the suit.
Please.
ನೀವು 10 ದಿನ appear ಆಗಿಲ್ಲ.
Yes.
Over 2 years.
Yes.
And you want a direction to the court.
The stage was for objections. Please. Highly obliged.
59.
Objections.
Observe if the petitioner is not present on next date, dismiss ಮಾಡು ಅಂತ. ನೋಡಿ ಇವಾಗ್ಲೂ appear ಆಗಲ್ಲ ಅಂತ.
Appear ಆಗ್ತೀವಿ ಅದು ಬಿಟ್ಟು objections ಗೆ ಹೋಗ್ತಾ ಇದೆ ಸರ್.
Appear.
Please.
59 Mahabaleshwar Asinat.
I am for the
Annexure C.
petitioner, my lord. I am
One
the
nimsham,
owner
one
of a
nimsham.
site.
Just one moment. Accepting the submission of the counsel for the petitioner, office objection as regards Annexure C is overruled since it's a plan sanction. Yes.
So there is office objection regarding a map.
Yes, we have overruled it.
Which I do not rely, my lord.
Really?
And I am the owner of a site in Padugutti layout in Gangavati, and the size of the plot is 1575. And my lord, I am filing the statement given by the commissioner, that is respond number 2 in local paper. He says that almost all the buildings have been constructed in Padugutti layout except 2, and mine is one amongst them. My lord, I have purchased the plot in the year 1997.
Where is the plan sanction?
Pardon?
Plan sanction only.
Plan sanction. That's what the reason why I filed.
Ah.
So I have filed kindly annexure, page number 21 may kindly be perused, my lord.
21.
21. So this is the application which I have filed along with the map, estimation, expenses, etc. Totally, whatever the documents were required for the applying for the license to construct. But my lord, the application annexure D has been filed on 8/10/2024. But even after the lapse of 1.5 month, 90 days, the commissioner did not give the permission nor rejected my permission. So as it was already a plot wherein the foundation was laid in 1997, I have constructed up to RCC level. So what happened, my lord, when the building was with RCC, the officers of municipality respondent number 2 came and removed the centering materials and took away. Thereby direct we to stop the construction orally. But my submission is, as per section 187 of the Karnataka Municipalities Act, if the permission is not
Who is the
given,
standing counsel for CMC Gangavati?
Ganga, Mr. Saran Baswa.
DGA accepts notice.
May I make one
for
submission, Your
respect
Lordship?
number 1.
In para number 1, Your Lordship, he has stated that he has purchased the site, Your Lordship, in the year 1997. But Your Lordship, the grounds, Your Lordship, in para number 12, he is stated that he has constructed in the year 1993. He, according to him, he has purchased 97, but he has constructed in 1993. How it is possible?
Foundation ಹಾಕಿದ್ರು ಅದಾದ್ಮೇಲೆ ಇವ್ರು ಮಾಡಿದ್ರು.
ಅವರೇ ಹೇಳ್ತಾರೆ
He accepts notice for respond number 1. Shri Sharanbasava is directed to accept notice for respond number 2. Town Planning Authority, Gangavati. Who is the standing counsel?
I don't.
You find out ಮಾಡಬೇಕು.
Town planning. Town planning. I know Saran Baswa is the advocate for the.
We'll have to issue notice to respond number 3 and wait for it. Idarenappa, Town Planning Authority. Issue notice to respond number, emergent notice, returnable by 11th March.
60, Geetanjali Kamath.
Lord,
One submission, my lord.
Yes.
As I have been separated from the family, we have 4 brothers. I have no house. I have to go and stay there. So,
We'll have to hear them.
kindly the date may be given.
What is this?
Please,
11th
please,
March.
please, please.
Q, what is the page number, madam?
$39, Your Honor, 39. My lord, in this, my land was acquired under.
Still under office objection, first satisfy in that. Q is not legible, and you have said that Q is legible. One sheet
we will-
type ಮಾಡ್ಕೊಡಕ್ಕೆ ಏನಂತೆ?
By next date, we will file it.
Counsel for the petitioner seeks for and is granted weeks time to comply.
My
with
lord,
office objection.
miscreants
28.
are trying to encroach
18th February.
interim relief, my lord.
First you satisfy that.
Please, my lord.
2:30.
230 matter, 101, Ventesh Kharvi.
After recording office by the Adhyaksha, they have not notified the
No, office
declaration.
objection late, 43. Clerical work ಮಾಡಿಸ್ತಾ ಇದ್ದೀರಾ ನೀವು?
Clerical ಎಲ್ಲ 230 ಮೂವ್ ಮಾಡಿದೆ ಸರ್ ಅದು. ಅದಕ್ಕೆ ಫೈಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ಸಿಗ್ಲಿಲ್ಲ ಅದು.
There's so many
ಅಷ್ಟು
offices.
ಶುಕ್ರವಾರ ಇತ್ತದು. ಸೊ ಗವರ್ಮೆಂಟ್ ಡೈರೆಕ್ಷನ್ ಮಾಡಿದ್ವಿ.
TT ಪವರ್ ಸರ್ವ್ ಮಾಡಿದೀರಾ ಕಾಪಿ?
ಇಲ್ಲ ಅದರಲ್ಲಿ ಏನಾಗಿದೆ, we have not challenged the, my lords, proceedings, my lord. Pursuant to the proceedings, we have challenged the declaration, my lords. ಅವ್ರು ಹಾಕಿದ್ದು, the first we have challenged, my lords, that is notice issued by the assistant commissioners. That was disposed by this honorable court and dismissed my writ petition. On 7th, my lord, that is page number 35. ಅದಕ್ಕೆ ಹಾಕಿದ್ರು ಅವರು. Page number 35, this honorable court dismissed my writ petition on the ground of that it is come under 49(1).
Caveat petition filed. If you don't want to serve, we'll just adjourn it.
ಅಲ್ಲ ಇದರಲ್ಲಿ
Serve it, we'll take it up
no, my
after
lords, I have
service.
not challenged that, I have challenged pursuant to the notification, my lords.
Caveat petition ಇದೆ Mr. Karvi.
ಕರೆಕ್ಟ್, ಬಟ್ ಕೇವಿಟ್ ಹಾಕಿದ್ದು ಇದ್ರಲ್ಲಿ ಇಲ್ಲ, ಈ ಆರ್ಡರ್ಗೆ ಅಲ್ಲ ಅವರು.
ನೀವ್ ಹೇಳ್ಬೇಕಾ ಅವ್ರು ಹೇಳ್ಬೇಕಾ? ಹೇಳಿ ಬೇಕಾದ್ರೆ we'll issue
That
court
is,
notice.
yeah, better, but what I have given, my lords, earlier also, they have filed the caveat on 7/1, my lords. That was disposed by this honorable courts. 7/1 ನೋಡಿ, 7/1ಕ್ಕೆ ಅವರು ಕೇವಿಟ್ ಹಾಕಿದ್ದಾರೆ, 7/1 ಕೇಸ್ ಮುಗ್ದಿದೆ. ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ನಾನು ರಿಟ್ ಪಿಟಿಷನ್ ಮಾಡಿದ್ದೀನಿ.
ಎಲ್ಲಿ caveat petition ಕೊಡಿ.
7/1 ಫೈಲ್ ಔಟ್.
ಇಲ್ಲೇ ಇದೆ. They are not restricted to any 7/1. If any petition is filed, ಅಷ್ಟೇ ಹೇಳಿರೋದು.
ಹೌದು, ಅದೇ ಅವ್ರು ಮಾಡಿದ್ದು ನೋಟಿಸ್ ನಾವೇನು
ನೀವು ಸರ್ವ್ ಮಾಡ್ತೀರೋ ಇಲ್ವೋ?
ಅಲ್ಲ, ಸರ್ವ್ ಮಾಡಿದ್ರೆ ಏನು ನೋಡಿದ್ವಿ. ಟುಮಾರೋ ಇಸ್ ದಿ ಮೈ ಲಾರ್ಡ್ಸ್.
Third, counsel for the petitioner submit that you does not wish to serve the caveat, hence issue court notice to the caveat.
But my lords, my lord, tomorrow is a case, otherwise I will serve the tomorrow morning 10:30, my lord.
That is what you are supposed to do.
Please, I will serve within evening hour, serve ಮಾಡ್ತೀನಿ.
Takes time to comply with the office objection and serve the caveat counsel, release tomorrow.
My lord, sir, my request is kindly take it on 10:30 tomorrow. Election ನಾಳೆನೇ ಇದೆ. This what, my lords.
Caveator ಇದ್ದವಾಗ we can't pass any order. You don't want to serve.
But
ನೀವೇ caveator ಆಗಿಲ್ಲ ಆಮೇಲೆ ಏನು ಹೇಳ್ತಾರೆ?
but ಏನು subsequently inspectors ಅಂದಲ್ಲ, please kindly request, my lords, 10:30 my lord.
You had time for 3 days to serve.
ಅಲ್ಲ ಇದೆ, but
next.
My lord,
102
kindly.
ಪ್ರಕಾಶ್ ಜವಾಳ್ಕರ್.
Lord, the petitioner was running a English medium school from 1st standard to 8th standard. And thereafter it applied for 9th and 10th in Kannada medium. So that has been rejected.
In the same location.
Same location,
1 to
but
8
it is
English
having
ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
same location, but it is having sufficient infrastructure in order to see that it can accommodate even those particular Kannada medium also.
You are admitted to grant in aid?
1st to 8th is in English medium.
The grant in aid ಇದೆಯಾ?
No,
No
non-aided,
grant in aid.
non-aided.
Then why should you say no?
Tomorrow, your lordship. Tomorrow, day after tomorrow, your lordship.
Notice ಆಗಿದೆ.
ಆಗಿದೆ.
The
Take
AG
instruction.
seeks for 2 days time to make his submission as to why the request of the petitioner is yet to be accepted. Released on 13th at 2:30 PM.
Please.
Further hearing, 103 Mallikarjun Madanalli.
In this case, my lord, my lord, petitioner is, my lord, ready to, my lord, file affidavit in respect of, my lord, withdrawal of the allegation against the, my lord, fifth respondent, my lord. Now, my lord, as per I have discussed with the, my lord, parties, they are seeking, my lord, transfer, my lord. More than 15 teachers are, total 31 teachers are there, my lord. 20 teachers are ready for seeking transfer, my lord.
Out of petitioner school, respond
Please,
number 5.
management,
Or ಯಾವ education institution ಬೇಡ ಅಂತೀರಾ?
lord, any other institution, my lord, not, my lord, present fifth respondent, my lord.
ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ ಅಷ್ಟು
My lord,
teachers?
total 31 ಇದ್ದಾರೆ, ಅದರಲ್ಲಿ 5 ಜನ ರಿಟೈರ್ಡ್ ಆಗಿದ್ದಾರೆ. ಈಗ ಬಂದಿರೋದು 20 ಜನ, my lord. Now 20 teachers are ready, my lord, for seeking transfer, my lord. So discuss ಮಾಡಿದೀವಿ. 2 days time ಕೊಟ್ಟರೆ I will file affidavit, my lord.
20 ಜನ ಎಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ತೀರಾ? Betterment's client is a very bad employer. They don't want to be with you. ಯಾಕ್ರಿ?
ಅವರು ಹೋದ್ರೆ the school will be run very easily, my lords. We can run the school. Let them, if they want to go, let them go. The lordship has directed the Kalsur mode.
ಎಲ್ಲಿ ಅವರು?
Today is not.
ನಾಳೆ ಇದ್ದಾರಾ? ಎಲ್ಲಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ಬೋದು ಅಂತ ಚೆಕ್ ಮಾಡಿ. That counsel for the petitioner teachers submit that they will be withdrawing all the allegations made against the school, and further that there are no objection for their transfer to any other school not belonging to the respondent number 5 group of institutions. And AGA seeks fund is granted a week's time to obtain instruction, make a submission as to whether there are any vacancies in any of the schools where the petitions could be transferred to. Released on 20th February.
Please. Please.
These two. These two. Interim order earlier granted is extended.
Please.
List 2, serial number 1, Sadiq Budwala. Sadiq Budwala.
I appear for on behalf of petitioner, my lord. Matter is
Process fee. Counsel for the petitioner is granted 10 days time to make payment of process fee, furnish copies, as also to comply with the office objection. If needful is not done by 21st, relist on 25th for dismissal.
2, SR Hegde.
Notice ಹೋಗಿದೆಯಾ? R2
ಹೌದು ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು. ಇಲ್ಲ ಸರ್.
Terugunti appear ಆಗಿದ್ದಾರೆ. During the pendency of the above matter, respond number 2 expired on
14/12/2023.
14/12/2023, hence IA 1, 2 and 3 of 2024 have been filed on
11/3/2024.
accepting the reasons stated in support of IA 1 of 24, delay of 148 days is condoned. By allowing IA 2 of 24, the abatement in respect of respond number 2 is set aside. By allowing IA 3 of 2024, the person named therein are brought on record as respond number 2A to C. Really expired, hence IA 1, 2 and 3 have been filed. Notice having been ordered has been served and are represented.
3, Venkatesh Kharvi.
Already complained, my lord, there is no complaints ಅಂತ ಹೇಳಿ, there is no complaints, my lord.
Extension ಕೇಳಿದಿರಾ?
Extension, my lord.
ಹಾ, ಏನ್ extension?
The interim order, my lord, sir, pending.
Interim order merits ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡಿ interim ಆಮೇಲೆ ನೋಡಿ.
Can you tomorrow, my file misplace ಆಯ್ತು. Can you tomorrow, my lords?
The request of counsel for the petitioner relist on 17th.
Please.
Please.
4, Girish Adward.
Who is the impleading? MP Vivek Mehta.
Girish Adward.
None appears, relist on 24th. B group 5 to 13. 5 to 13, relist on 3rd March.
5 to 13, madam, 3rd March. List number 1, Passoor matter. 1, Sadiq Budwala.
Lord, I'm permitted to withdraw the request.
Huh?
I'm permitted to withdraw the request.
Permitted to withdraw na dismissal ಆದ್ಮೇಲೆ.
The order has been not. Order has been not at my lord.
That we can't. Order has already been dictated. The matter is being moved for being spoken to. Counsel for the petitioner seeks permission to withdraw the above petition. The order having been already dictated in open court, such withdrawal cannot be permitted now.
27, Mrutyunjay Helikeri.
Lord, the petitioner is calling in question passed under order 16 rule 6, my lords. Lord, it's a petitioner, my lord, is the plaintiff. He files a suit for declaration, possession and consequential injunction. It is his case, my lord, that he inherited it from his father, my lords. Now, the defendant number 1, my lord, is his cousin, aunt's son, my lords. My lord, grown up in the house, their house itself, my lords. So he, taking certain advantages, my lord, had created revenue entries in his name.
Sale deeds ಅಂತ ಹೇಳಿದಿರಾ?
Please, my lord.
Sale deeds are not binding ಅಂತ ಕೇಳಿದೀರಾ?
Andre, thereafter, my lord, creating the revenue, he has alienated to respond number 2 and 3. So based on the revenue entry, my lord, no title could be passed. So that, my lord, his defense is, my lord, at page 23, that, my lord, when my father purchased the property, some astrologer, my lord, said that it should be purchased in his name. So it was purchased in my father's name.
The name of his son-in-law.
Son-in-law?
His son-in-law.
Son-in-law, yes, my father was son-in-law, my lords.
Son-in-law ಅಂದ್ರೆ
ಅಂದ್ರೆ
daughter's
ನಾನು
husband ಆ?
ಇಲ್ಲ
ಅಳಿಯ
ಹಾಗೇನಿಲ್ಲ,
ಅಂತ.
ಅಳಿಯ ಅಂತ ಹೇಳಿ ಅಲ್ಲಿ ಹೋಗಿ he my lord moved to Koppal and he
Not
was there.
daughter's husband.
Not daughter's husband.
Transliteration.
Then, my lord, he filed some applications. My lord, my case is, my lord, that that revenue entry, my lord, everything that he created. Now he files an application, my lord, seeking a witness summons to the Tahsildar, my lord, for production of the application that was made for, my lord, making the revenue entry, and also, my lord, to the RTO to produce one rent deed, my lords. Now, my contention is, my lord, that they are not relevant. And assuming for a moment that they are there, they will not transfer the title.
Original application submitted by defendant number 1 and plaintiff number 2.
Where? No, my lords.
Annexure D alva 16 rule 6. Which is the
63.
impugned application.
My lord, page 63, my lords, application.
Original application submitted by defendant number 1 and plaintiff number 2. Item number 1.
There, my lord.
Plaintiff number 2 has signed it.
That's what, my lord, he claims, my lord. Now he wants the original document to be summoned. Now our case is, my lord, that will not, assuming for a moment, we have disputed it as one aspect, assuming for a moment that, my lord, even if that is there, that will not transfer the title.
The subject property is 137/1.
Yes.
If the defendant number 1 and plaintiff number 2 have jointly filed the application for transfer in the name of, you have consented, there's acquiescence.
No, my lord.
For that purpose, it would be required.
My lord, he says, my lord, that he will examine my signature, etc.
Once it is produced, it will be seen.
Yes.
If one, you have signed that here.
Yes,
Our signature is there. If only defendant number 1 had filed, what you are saying is right.
Yes, yes, my lord.
But when he is saying that you have signed,
yes,
can't be. It has to be produced. Third, petitioner is before this court seeking for the following reliefs. Petitioner is plaintiff number 2 in OS number 58 of 2020. He filed seeking for declaration of ownership, declaration that certain sale deeds are not binding on the plaintiff, and consequently injunction restraining the defense from interfering with the peaceful possession of the plaintiffs. The above petition has been filed only by plaintiff number 2. Plaintiff number 1 not being available has been arraigned as respondent number 4. Notice to respondents is dispensed with in view of the proposed order to be passed. In the said suit, defendant number 1 filed an application under order 16 rule 6 of the Code of Civil Procedure read with 16 rule 6 read with section 151 of the Code of Civil Procedure for issuance of summons to the regional Tahsildar Koppal for production of 2 documents. One of them being an application submitted by defendant number 1 and plaintiff number 2 jointly pertaining to the land in question, as also the original namune issued by the Tahsildar in respect of said land in persons of the said application. Another application was filed seeking for summoning certain documents from the Regional Transport Officer Koppal, being the monthly, one of them being the rent agreement submitted by plaintiff number 2 to Regional Transport Officer for the month dated 10th April 2012, and the other being a similar agreement dated 7th May 2012. The trial court having allowed both the applications, the petitioner is before this court. seeking for the aforesaid relief. The submission of Sri Mrityunjay as Alikeri learned counsel for the petitioner is that those documents are not relevant for the purpose of adjudicating the list between the parties, inasmuch as the contention of the petitioner plaintiff is that revenue entries have been falsely created, in pursuance of which sale deeds have been falsely executed, and as such the revenue entries would not create any right in favor of defendant number 1. Having perused the applications, it is seen that the application submitted to the Tahsildar was both by defendant number 1 and plaintiff number 2. Whether in fact plaintiff number 2 has signed the said document, signed and submitted said document or not, would have to be ascertained after the documents are produced. At this stage, it cannot be said that the documents are not relevant for the adjudication of disputes, inasmuch as they relate to the subject property and have been stated to have been submitted by plaintiff number 2 also. No grounds therefore having been made out, petition stands dismissed at the stage of admission, reserving liberty to the petitioner to agitate all defenses in respect of those documents as and when produced.
Grateful, my lord.
39, Chetan Limbikay.
Apology, my lords. Second is serial number 4, my lords. I was held up in other legs of this court. Kindly, there is interim order is there, my lord.
Second list serial number 4 interim order extended.
Please, grateful, my lord.
Second list ella interim order irada. 30?
39. 39, Chetan Limbikay.
Paso.
43, Gurudev Gachirmat.
Need for done, my lord.
Counsel for the petitioner has carried out amendment. Amended cause title
Yes, my lord, filed, my lord.
and filed amended cause title. Yes.
My lord, writ petition as against the order passed by the land reform appellant authority
You are
is not.
ready?
Yes, sir.
Ready to address arguments.
Yes, sir. One submission is there, my lord. It is not maintainable, my lord.
Our argument ಆದ್ಮೇಲೆ ನಿಮ್ದು.
Okay.
ಏನಪ್ಪ?
No, my lord.
ನೀವು ರೆಡಿ argument ಗೆ?
Next week, my lord.
ಎಲ್ಲಿ senior?
Next week, my lord.
At the request of registry is directed to delete the name of Sri A.A. Mulwadimat as that appearing for the petitioner. At the request of the counsel for the petitioner, relist on 17th.
Hopeless, man. 18th.
ನೀವೇನು ಎಲ್ಲಾರ ಓಕೆ relist on 19th.
Time permission.
39, Chetan Limbikay.
Let's kindly
Yes.
pass on, let's.
Pass over ಮಾಡಿ.
ಅಲ್ಲ documents are.
ತಗೊಂಬನ್ನಿ.
Please.
B group matter. 61, VM Shilwan.
You will taken day tomorrow, your lordship. File not received.
ಕಲ್ಸೂರ್ ಮಡ್ದ ನಿಮ್ದ.
ಅವ್ರದ್ದು ಅದು ಬಟ್ ಫೈಲು ಸಿಗ್ತಾ ಇಲ್ಲ.
Age last
ಫೈಲ್
time,
ಪುಟಪ್ ಮಾಡಿಲ್ಲ ಅದಕ್ಕೆ. ಫೈಲ್ ಪುಟಪ್ ಮಾಡಿಲ್ಲ.
last time twice taken time on the ground that
ಫೈಲೇ ಕೊಟ್ಬಿಡಿ.
Day of tomorrow, your lordship.
acquisition is lapsed. 98 is acquisition. No position is not taken.
Relist on 13th. It is made clear that no further.
Last time they made a submission, AAG going to argue the matter. Therefore it was.
ಹೌದಾ?
ಹೌದು.
ಹಾಗಾದ್ರೆ AG ಹತ್ರ ಇರ್ಬೇಕು.
AAG wanted to argue the matter.
ಗಂಗಾಧರ್ ಕೇಳಿ ಅವ್ರ ಹತ್ರ ಇರತ್ತೆ.
Day after tomorrow.
2012 matter.
62, Suraj Palloli.
ಫೈಲ್ ಮಾಡಿಲ್ವಾ?
No, they're supposed to be listed on 14th, my lord.
14. The 10-2 ಇದೆ. Date.
Will file.
10-2 is the date given. Date is given as 10-2. Released on 14-2. ಹೌದು ರೆಡಿ ಆಗ್ತೀರಾ ತಾನೆ?
63, DLR Khan.
U Patil was appearing on behalf of railways. Now I was told that Mr. Mrutyunjay Hallikeri is appearing.
Final ಇದೆಯಾ ಇವಾಗ ರೈಲ್ವೇಸ್ಗೆ ಇಲ್ಲ
ಅಲ್ಲ
Union of
ರೈಲ್ವೇಸ್ಗೆ
India.
ಫಾರ್ ರೈಲ್ವೇಸ್
ಇವಾಗ ಪ್ಯಾನಲ್ ಇಲ್ವಲ್ಲ ರೈಲ್ವೇಸ್ಗೆ
ಅಲ್ಲ ಇವರು
ಹಳ್ಳಿಕೇರಿ ಅವರು ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್
ಅಲ್ಲ ವೆಂಕಟೇಶ್ ಕಾರ್ವಿ ಅವ್ರು ಕೇಳಿದೆ ಹೂ ಇಸ್ ಟೇಕಿಂಗ್ ಕೇರ್ ಆಫ್ ರೈಲ್ವೇಸ್ ಅಂತ ಹೇಳಿ.
ಹಳ್ಳಿಕೇರಿ ಇಸ್ ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್.
ಅವರೇ ಹೇಳಿದ್ದು ಮೃತ್ಯುಂಜಯ ಹಳ್ಳಿಕೇರಿ ಅವ್ರ ಹೆಸರು.
ಅವ್ರ ಸ್ಟ್ಯಾಂಡಿಂಗ್
ಇಲ್ಲ ನನಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇಲ್ಲ ಸ್ವಾಮಿ. ಐ ಆಮ್ ಮೇಕಿಂಗ್ ಸಬ್ಮಿಷನ್ ಆಫ್ಟರ್ ಅಸರ್ಟೈನಿಂಗ್ ವಿತ್ ಮಿಸ್ಟರ್ ವೆಂಕಟೇಶ್
ಇದ್ರಲ್ಲ ಇವಾಗ ಹಳ್ಳಿಕೇರಿ.
Railway matters are handed over to Union of India. Now they are appearing. All the railway matters are handed over to the Union of India. Now they are appearing.
ಅಲ್ಲ ಈಸ್ ಮೃತ್ಯುಂಜಯ ಹಳ್ಳಿಕೇರಿ ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್
For Union of India.
ಇದಾರಾ?
ಇದಾರಾ?
ಅವರು registry is there in the name of Shri Mrutyunjay Hallikeri. Is that appearing for respond number
4? 4, my lord. General Manager Rail Vikas Nigam Limited, South Western Railways, Hubli. The land was acquired for double gauge lane of
62.1. Hallikeri as that appearing for respond number 4 and delete the name of Shri Ajay U Patil as that appearing for respond number 4. Counsel for the petitioner to furnish 2 sets of the petition on Mr. Mrutyunjay Hallikeri. Released on 3rd March.
Short accommodation.
In our instruction.
ಅಲ್ಲ ಅವರಿಗೆ ಯಾಕಂದ್ರೆ
24th
I have produced all the records that were to be in support of their case also I have produced.
Our instructions were 24th. Either 62 ಅಲ್ಲಿ ಸಂಗ್ರಾಮ್
Cell number 62, Sangram Kulkarni.
ಆಯ್ತು ಬಿಡಿ 14th ಬನ್ನಿ.
64, Vidyavati Pattur Shettar.
For petitioner, my lord.
Yes.
This is the land is acquired under the scheme, my lord, for improvement board in the year 1986. And they have deposited the amount before the civil court. Without the consent of the party, there is no dispute between the party. Under section 30, they have deposited the amount, my lord. Even the parties are not aware of deposit of the amount. One thing, my lord. Till date, my lord, the land is not utilized by the respondent. It is vacant land, my lord. Therefore, my lord, I will make a synopsis with the judgment of the Supreme Court, my lord. If the land is not utilized in time, my lord, it will be revert back to the owner.
It is not utilized, it is meant for my lord.
It is not utilized, my lord. This is the photograph. Please, my lord, please.
It is earmarked for park and playground, my lords. I have produced the layout plan also. Kindly see, my lords, the notification, my lords, is dated 1989, preliminary notification. Award is passed on 10/3/1992. There was a civil dispute, my lords, amongst the families. Suit for declaration was filed. Therefore, my lords, the compensation was deposited, my lords, before the court below, before the trial court. And my lords, the special land acquisition officer makes a categorical observation that since there is a dispute between the family members, the amount is deposited.
Number ಎಲ್ಲಿದೆ?
My lords, that
Page. ಬೇಗ ಹೇಳಬೇಕು.
my lords, kindly see, my lords, page 17 of my statement of objections.
Yes. Survey number?
17, my lords, page 17. That is the award in which there is an observation in respect of 108/3C, measuring 2 acres 13 guntas.
3C.
ಈ ಜಮೀನು ಎಲ್ ನಾಗೇಂದ್ರ ರಾವ್ ಹೆಸರಲ್ಲಿ ದಾಖಲಿದ್ದು ಈತನ ಸೊಸೆ ಶಾಂತಾಬಾಯಿ ಮತ್ತು ಮಕ್ಕಳಾದ ವೆಂಕೋಬ್ರಾವ್, ರಘುನಾಥರಾವ್ ಮತ್ತು ಸೋನ್ಸೋ ಅವರ ಭೂಸ್ವಾಧೀನಕ್ಕೆ ಕೈಬಿಡಲು ಹೇಳಿದ್ದು ತಮ್ಮ ಹಕ್ಕು ಮತ್ತು ಪಿನ್ಸ್ ಕುರಿತು ಹೇಳಿರುವುದಿಲ್ಲ. ಈ ಜಮೀನು ಬೆಲೆಯನ್ನು 15,300 ರೂಪಾಯಿ ನಿರ್ಧರಿಸಿ ಜಮೀನು ಹಕ್ಕಿನ ಬಗ್ಗೆ ವಿವಾದವಿರುವುದರಿಂದ ಸಿವಿಲ್ ಠೇವಣಿಯಲ್ಲಿ 32 ಅಡಿಯಲ್ಲಿ ಠೇವಣಿ ಇಡಲು ಆದೇಶಿಸಿದೆ. So 15,300 rupees milots then milots was deposited.
It's not for apportionment, this is for enhancement.
This is the award that has been passed by the land acquisition officer.
ಅನ್ನು ಬಗ್ಗೆ ವಿವಾದವು ಇರುತ್ತದೆ ಎಂದು
Yes.
ಅಂದ್ರೆ ಎಲ್ಲಿ ಸೂಟ್ ಎಲ್ಲಿ?
Milord suit
ಇದು ಲೋಕರೆ ವೆಂಕೋಬ ರಾವ್, ರಘುನಾಥ್ ರಾವ್, ನಾಗೇಂದ್ರ ರಾವ್ children. Yes. Where is the suit reference?
Milord suit milods one more writ petition is there milods. Suit was one for a declaration, milods. I will kindly see, milods, in second writ petition. Milods, they are all related. They are all related to each other.
Second writ petition survey
see
number
notes.
is different from my
Survey
survey
number is
number, my
different.
lord. It is no way connected with me.
Kindly see, milods, this is a family genealogy. There are two writ petitions.
Pampapati, Shobha, Jaya, Vijaya.
Milods, paragraph 3, it is submitted that late L. Muni Rao had two sons, namely Ragendra Rao and Pampapati Rao. They both lived together as joint family prior to the family partition. The eldest brother Nagendra Rao had filed a suit seeking for relief of declaration of title and permanent injunction in respect of the schedule mentioned in the property bearing OS number 220/1990 on 12/7/1990 on the file of the principal municipal court Hospete. The said suit came to be decreed declaring that the parental uncle of the petitioners, that is Nagendra Rao, as owner of the scheduled property. The copy of the judgment, milods, is produced as Annexure C. Moreover, milods, the possession is taken.
Survey number 79.
Milods, my specific case is that after issuance of the preliminary notification, final notification is issued, award is passed, amount is deposited, possession is taken, layout is formed, and after formation of the layout, this particular land, milods, has been earmarked for park and playground. Now, milods,
That
after
will come to first, your deposit, is it proper? Is there a suit? The suit and your deposit, there's no problem. But without a suit, if you deposit without notice to them, then there's a problem.
Yes.
Suit iddu, if this is the suit relating to both the properties.
Both the properties.
No, this is the survey number 108/3A. Suit is, my lord. In page number 5 of their writ petition, in first paragraph, it is there, my lord.
Their properties 108/2C. So they
3C.
both emerge out
No,
of
it is
survey number
different land,
108.
It is different. Your lordship kindly, I'm sorry.
And they have filed their respective objections also, my lords.
Is this suit is relating to 108/3A?
Yes, my lords.
Alva?
Oh, 108/3. 108, my lords, it emerges from both.
220/90 relates to 10/3A measuring 2 acres 12 guntas.
Yes, my lords.
And 108/3B measuring 2 acres 13 guntas.
3C, my lord. That is in the award, my lord, page number 17. My learned friend already read with their objection, my lord, in the statement of objection. Page number 17, your lordship kindly peruse.
ಫಸ್ಟ್ ಈ ಸೂಟ್ ಏನು ಅಂತ.
ಅದೇ ಸೂಟ್ ಅಲ್ಲಿ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿದ್ದಾರೆ ಅವಾರ್ಡ್ ಅಲ್ಲಿ. It is explained in the award itself, my lord. Page number 17 ಅಲ್ಲಿ.
ಅವ್ರ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಆಮೇಲೆ ನೋಡೋಣ ಮೇಡಮ್. ಫಸ್ಟ್ ಸೂಟ್
ಅಲ್ಲಿ ಸೂಟ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಷ್ಟೇ ಹೇಳಿರೋದು. ಸೊ ದಿಸ್ ಸೂಟ್ ಇಸ್ ರಿಲೇಟಿಂಗ್ ಟು ವಾಟ್?
ಜಮೀನಿನ ಹಕ್ಕು ವಿವಾದಾಸ್ಪದವಿದ್ದು.
ಪ್ರಾಪರ್ಟಿ ಸ್ಟಾರ್ಟೆಡ್ as 79. 79 came to be renumbered. Finally, 31 it started as. '31 to 79 to 105, then 124, then 108. So, idರಲ್ಲಿ ಯಾವುದು? What is the survey number in this?
In first matter, my lord, my case is survey number 108.
3C.
3C.
2 acres, 13 guntas.
Yes, my lord.
And the other matter it is?
108, 3A, extent is 1 acre. Separate award is passed.
It's not audible, sir.
ನಿಮಗೆ ಕೇಳಿಸ್ತಾ ಇದೆ ಮೇಡಮ್?
Yes, sir. ಕೇಳಿಸ್ತಾ ಇದೆ.
WP 109589 of 2017. The submission of Ms. Vidyavati Kottushettar, learned counsel for the petitioner, is that the compensation amounts have not been paid to the petitioner, and the land has also not been put to use, and as such, under section 24 of the Right to Zones Acquisition Act 2013, the land is to revert to the petitioner. Shri Gurudev Gachanmat would however contend that the compensation amounts have been deposited in a suit which is said to be pending between the family members of the petitioners, there being a dispute as regard the title and apportionment. His further submission is that the land has been put to use as a land in survey number 108/3C has been put to use as open
Open space park and playground.
This
open
is,
space
this is
park
the
and
position.
playground. He seeks for and is granted a week's time to place on record the details of the suit where the deposit has been made, along with the plaint and if a decree is passed, as also to place on record the plan sanction.
Sanction plan is placed. Already on record.
Page?
That's annexure R3 or annexure R2 layout plan. Use 55 acres of land lots which has been acquired by.
Where is the survey number, Mark? Where is the survey number? Mark Padilla.
This is the portion, ma'am. This portion. Open space. School, high school, playground, open air theatre, electric substation. That is the survey number 1083C.
So if land reverts back towards this entire layout will not have the benefit of this.
Where is this survey number? ಅವ್ರು ಹೇಳ್ತಾರೆ survey number mark ಮಾಡಿಲ್ಲ ಇದರಲ್ಲಿ.
This is survey number.
As
108/3B mark here.
open spaces and playground, and has been used for the purpose of construction of a high school, playground, open air theatre and electric substation. He is directed to place photographs evidencing such construction.
It is reserved. It is reserved.
ಆಮೇಲೆ ಏನ್ ಮಾಡಿದ್ದೀರಾ?
Nothing.
Well, we have to have clarify.
This is the
They are
position.
claiming they are in possession. They are claiming they are in possession.
No, this is a approved layout plan.
Photo ನೋಡಿ ಇಲ್ಲಿಂದಾನೆ ಕಾಣಿಸುತ್ತೆ.
Because it's a vacant land, they can stay not always there, they are in possession.
Only symbolic possession will not be.
16 to notification I have produced.
Symbolic possession.
It all depends on that suit now for you. It all depends on the suit.
Let the government advocate also be directed to it because ultimately.
Learned
special
AGA
administration officer is the.
is also directed to secure records as to the manner of deposit made and the reason for deposit made by the SLO. WP 110071 of 2019.
There may not,
Senior is held up in that court.
Learned Gurudev, Shri Gurudev Gachanmat, learned counsel for the petitioner, submit that the amount of compensation has been deposited in the suit due to the pendency of the suit in OS number 220 of 1990 in respect of survey number 108/3 capital A. The counsel for the petitioner seeks for a short accommodation to obtain instruction, make his submission. Released on 19th February.
Great.
65, Ravi Hegde.
May I request for 21st?
21st.
Your Lordship, kindly see the order sheet, my lord, how many.
21st.
Please.
It's made clear that if necessary documents are not produced, adverse inference would be drawn and matter proceeded with.
Please.
ಆಮೇಲೆ ಇನ್ನೇನ್ ಟೈಮ್ ಇಲ್ಲ. Yes.
Short matter, my lord. The challenge to the award is to the extent of, my lord, the denial of entire back wages.
ಎಲ್ಲಪ್ಪ ಈ ರೆಸ್ಪಾಂಡ್ ಯಾರು
As
ಕೌನ್ಸಿಲ್
well as continuity of service and other consequential benefits.
ಕೌನ್ಸಿಲ್ ಯಾರು ಅವರು?
They are served, my lord, long back.
Anybody appears for them here?
No. The finding of the
A.M. Patil had appeared before the labor court.
ಇಲ್ಲಿ ಬರಲ್ಲ sir.
Yes, ಹೇಳಿ.
Finding of the labor court is, my lord, clear. The termination is illegal, and as such, my lord, he is entitled for reinstatement. He has been reinstated pursuant to the award and then retired. Then, my lord, the reasoning of the learned judge, my lord, in denying the back wages and continuity of service and other consequential benefits, no proper reasonings are forthcoming, apart from the fact that, my lord, the management has never examined any person before the labor court, let alone the, my lord, the gainful employment. Under such circumstances, my lord, the denial of back wages and other benefits or full back wages, my lord, the entire back wages portion has been denied. Entire. Page number 38, my lord, 37 end portion, my lord, is the reasonings. Operative portion is, my lord, 38 last paragraph. The claimant is not entitled for any back wages, continuity of service and any other consequential benefits. And the finding is, my lord, he has been working from 1990 till the legal termination.
They did not lead any evidence, sir.
Please, my lord.
They did not lead any evidence.
They did not lead any evidence. I have produced, my lord, several documents to show that I was employed. And even provident fund slips and other things. Except filing the counter statement, my lord, nothing has been done by them. Even then, my lord, the learned judge rejects everything for me except reinstatement.
Considering the fact that respondent management is not profit deriving institute.
Probably.
That is the reason.
No, it is his own, at least, my lord, there could have been some evidence. It is a
65. The petitioner workman is before this court seeking for the following reliefs. The respondent management, though served, has chosen to be unrepresented. The workman was appointed as a clerk in the primary school of the employer in the year 1990 and subsequently was transferred to the high school in the year 2003-04. When his services were terminated, on 1/4/2014. (2014 or 4?
14, my lord.
ಇಲ್ಲ 4 ಅನ್ಸುತ್ತೆ.
Page 38 also, the same is reflected by in the award. 1/4/2014.
If they 2014 andre, then there could not have been a 6-year delay in 2010.
Maybe so.
ಎಲ್ಲ ಕಡೆ 14 ಅಂತ ಬರ್ದಿದ್ದಾರೆ, but 2010 he had approached the conciliation officer.
Yes, yes.
Mistake ಇದೆ ಅಲ್ಲ. KD number 2015. Conciliation 2010. Can't be 2014 at all. Claim petition wrong ಇದೆ.
Delayed, by mistake, ಯಾವ್ದೋ cut and paste ಆಗಿದೆ. Even before the conciliation proceedings, my lord, where he has made a request for reference, the date is mentioned as 1/4/14. 1/4/14. Conciliation proceedings allo same date is mentioned.
ಬಂದಿದೆಯಾ?
Yes.
Exhibit ನೋಡೋಣ.
That is exhibit W3. ನಂತರ certified copy ಇದೆ ನೋಡಬಹುದು.
Salary slip for the month of September ಮಾತ್ರ ಇದೆಯಪ್ಪ.
ಕೆಲವು ಇರೋದು ಹಾಕಿದ್ದೇನೆ, because they have disputed my very employment itself.
If you were in 2014, then salary slip of 2014 would have been produced instead of 10 years ago. There's some mistake here.
2004 salary slip ಅದು. W4 is 2004 salary slip.
Legal notice is 6/5/2015.
Yes.
W6 provident fund slip of 2010-11.
Yes. Even legal notice also, my lord, the termination is stated 1/4/2014.
Registry is that secure the trial court records.
ಇಲ್ಲ, ನನ್ನ ಹತ್ರ ಇದೆ, certified copy ಇದೆ. I will place it.
Reference to the conciliation officer ಇಲ್ಲಿ.
ಹೌದು.
W.
Even legal notice and reply both are same date. ಅದು ಡಿಲೇ ಬಹುಶಃ ಯಾವುದೋ ಪಿಟಿಷನ್ ಇಂದು ರಿಪ್ಲೈ ಅಲ್ಲೂ ಹಾಗೆ ಇದೆ, ಲೀಗಲ್ ನೋಟಿಸ್ ಅಲ್ಲೂ ಹಾಗೆ ಇದೆ, ಕನ್ಸಿಲಿಯೇಷನ್ ಪಿಟಿಷನ್ ಅಲ್ಲೂ ಹಾಗೆ
ಎಲ್ಲ ಕಡೆ ಅದೇ ಇದೆ. His services was terminated on 1/4/2014. The petitioner approached the Labour Court under Section 2(a) read with Section 12 of the Industrial Disputes Act. For referring the matter of conciliation and advised to the management to take back the petitioner into service with full back wages and continuity of service. The Labour Court, vide its judgment dated 19th August 2017 in KID number 42 of 2015, partly allowed the claim petition set aside the order of termination dated 1/4/2014 and directed the respondent management to reinstate the claimant workman into service within 2 months from the date of publication of the award, but however held that the claimant is not entitled for any back wages, continuity of service, and any consequential benefits. It is challenging the same. The petitioner is before this court. Sri Ravi Egdel and counsel for the petitioner would submit that all the issues have been held in favor of the workmen. The Labour Court having come to a categorical conclusion that the termination of services effected by the respondent management on 1/4/2014 is without any cause and not legal, the Labour Court ought not to have denied the back wages and continuity of service as also consequent benefits to the petitioner. He submits that there is absolutely no reason whatsoever which has been considered by the Labour Court while denying the said reliefs. The Labour Court having come to a conclusion that the termination of services was illegal, the Labour Court ought to have awarded all the above. Not having done so has resulted infirmity in the award, which is required to be corrected by this court. As afore observed, though the respondent employer has been served, there is no representation. Having gone through the entire order in KID number 42 of 2015, it is seen that there is absolutely no reason given by the Labour Court for denial of the back wages and continuity of services and other consequent benefits, except to at para 20 say that, inverted commas, considering the fact that the respondent management is not a profit deriving institution, comma, there is no any order for back wages and continuity of service and all other consequent benefit as sought for by the claimant, inverted commas close. It is not understood. K.S. Patil has filed Wakalatnama.
Absolutely.
It is not understood as to on what basis the Labour Court has come to such a conclusion, more so when the employer has not led any evidence. The only evidence which has been led is by the claimant workman, and no evidence has been led by the employer. In that view of the matter, the finding of the Labour Court as regards the management not being a profit deriving institution is not sustainable. In that view of the matter, I pass the following order. Writ petition is allowed. The finding of the Labour Court insofar as the denial of back wages, continuity of service and consequent benefits is set aside. The respondent employer would be liable to make payment of all back wages with continuity of service and consequent benefits within a period of 2 months from the date of receipt of a copy of this order. Inna ಖುಷಿ ಅಲ್ಲ, ಇದು ಪೆಂಡಿಂಗ್ ಇರುತ್ತೆ. ಇದನ್ನ ಟೈಪ್ ಮಾಡಿ ಸಪರೇಟ್ ಆಗಿಡಿ. It is seen from the record that Shri K.S. Patil has filed Wakalatnama for the respondent. Registry is direct print the name of Shri K.S. Patil and relist on 18th February.
Please.
'66, Prithvi K.S.
Last date of hearing, my lords. Lordship has directed AGA to my lords verify the records. I verified, my lords. Award was passed on, my lords, 13/1/95 after 4161. What my client's, my lords, mistake has been done is, my lords, after my lords 61. After 61, my lords, mutation has been changed, my lords. After death of original owner, my lords, his wife name came to be entered in the mutation. My clients, my lords, on the basis of mutation entry have purchased, obtained sale deed. Thereafter, my lords, deputy commissioner has passed, my lords, conversion order. Our name, my lords, has been changed, my lords, record of rights pursuant to annexure K. Thereafter, in the year 2018-19, my lords, the entry of my lords, government has been entered on the basis of award. But award was passed on in that the mistake, my lords, my clients.
ಏನ್ ಮಾಡೋದು ಪೃಥ್ವಿ?
Our my lords, they have to, my lords, if they have entered their name in the record of rights, my lords, we would have
verified, gave it
that in the my lords,
ಟೈಟಲ್ ಡ್ಯೂ ಡಿಲಿಜೆನ್ಸ್ ಮಾಡೋದು ಅದಕ್ಕೆ ಅಲ್ಲ.
at least my lords, liberty to recover damages from the owner, my lords.
ಅಷ್ಟೇ. And how did you make the entry after acquisition?
Well, Lordship, you cannot question present case, Lordship, because when you have purchased the property, Your Lordship, after the award is passed, amount is deposited, you have no, because the owner herself had lost her right.
ಇದೆಲ್ಲೋ ಎಂಟ್ರಿ ಮಾಡ್ಬೇಕು ನೀವು. ಅವರು ಸೇಲ್ ಮಾಡ್ಬಿಡ್ತಾರೆ, ಇವ್ರಿಗೆ ಮೋಸ ಆಗೋಗುತ್ತೆ. ಎಲ್ಲೋ ಎಂಟ್ರಿ ಬರ್ಬೇಕಲ್ಲ, ನಿಮ್ಮ ಅಕ್ವಿಸಿಷನ್ ನೋಟಿಫಿಕೇಶನ್ ಎಂಟ್ರಿ ಮಾಡಲ್ಲ ನೀವು RTC ಅಲ್ಲಿ.
Lordship, they have purchased, Your Lordship, copy of the record of rights for his bias, Your Lordship.
18.
Anyway, we directed that in another matter. This is an old one. Going forward, we have directed all the preliminary notification, final notification award to be updated in the RTC.
95 award na 2018-19 entry ಮಾಡಿದ್ದಾರೆ. Please.
You can go against only your landowner. Petitioner is before this court seeking for the following reliefs. The petitioner claims to be the purchaser of the land in question from the wife of the original owner. Subsequent to such purchase, the name of the petitioner was entered into in the revenue records. When the petitioner applied for converting the land for non-agriculture purposes, the respondent authorities contended that the land.
No, that was also issued in their 2013 conversion order also issued. 2000
Conversion order ಆಯ್ತಾ?
ಆಯ್ತು my lords.
ಏನ್ರಿ ಇದು? The conversion was also granted.
Conversion in the year 2013.
In the year
13, 17/12/2013.
Subsequently, the respondent authorities, without issuing any notice, caused the deletion of the name of the petitioner from the revenue entries, from the revenue records. The petitioner filed an appeal in terms of subsection 2 of section 136 of the Karnataka Land Revenue Act, which came to be rejected by respondent number 3. It is challenging the same and the notification on the ground that the land had been acquired by issuance of notification of subsection 1 of section 4 of the Land Acquisition Act on 4/2/93, followed by a final notification of subsection 1 of section 6 dated 6/9/1993. It is challenging the said acquisition notifications that the petitioner is before this court seeking for the aforesaid reliefs. The submission of Shri Prithvi K.S., learned counsel for the petitioner. The petitioner is a bona fide purchaser for value, having purchased the land after verification of the title documents standing in the name of his vendors. Subsequent thereto, the petitioner's name also having been entered into the revenue records and conversion also having been granted, the petitioner was enjoying the land as a true and lawful owner thereof. And in that background, the revenue entries made in the name of the petitioner could not have been unilaterally deleted on the basis of a alleged acquisition. And hence he submits that the relief sought for are required to be granted. it is not in dispute that the lands of the subject lands were acquired, the preliminary notification in respect of subject lands were issued on 4/2/93, and final notification came to be issued on 6/9/1993. Though the revenue records were still continued to be in the name of the original owner, and on the expiry of the original owner came to be mutated in the name of his wife, who sold the property in question to the petitioner. On 31/8/2012, the fact remains that the acquisition was completed as far back as on 6/9/1993, and the award was passed on
13/1/95.
13/1/95. And even though you purchased the land, that be so, the petitioner has purchased a land which is already acquired, and any action taken pursuant thereto would not anyhow to the benefit of the petitioner. If at all the petitioner has any grievance, the same can only be against the original landowners, reserving liberty to the petitioner to agitate any such grievance against the original landowner. If permitted under law, the petition stands dismissed.
Please.
67, government.
Mr. Nada.
PM Nada.
Next, queue is the order, Your Lordship.
The counsel for the learned AGA is present for the petitioner, none appears for the respondent. Relist on 24th.
68, Member Patil.
I want to file my rejoinder.
Counsel for the petitioner seeks for and is granted 2 weeks' time to file his rejoinder. Rejoinder, if any, to be filed by 25th, relist on 3rd.
Please, obliged.
69, Ganapati Bhatt.
For petition, Lordship, in this case, state filed objections, but copy is not furnished on me, my lord.
Learned AGA undertakes to furnish the statement of objection filed. And learned AGA has furnished a copy of the statement of objection filed to the counsel for the petitioner, who seeks for and is granted 2 weeks' time to go through the same.
18th, ma'am. 18th. Next day.
A week's time to go through the same and make his submission. Relist on 18th.
Much of it.
70, PG Mogali.
IPO for petition. Or the petitions of the plaintiffs in the suit, my lord. Application was filed seeking for amendment of plaint.
You are the plaintiff suit for?
Suit for declaration that they have become the owners by way of adverse possession. And also permanent injunction. Also sought declaration that the seal deed executed by the case FC, even of the different one, are null and void. Not during the pendency of the suit. During the pendency of the suit, the petitioners were plaintiffs were dispossessed. Therefore, in order to seek additional prayer for possession, application was made. Page 35 may kindly be seen the argument made in the application. Page 35, para 2B, my lord. It is submitted that defendant colluding with each other illegally trespassed in the month of January 2022 on the suit property bearing number so and so, municipal number so and so illegally, and broke the lock and opened the premise and took away the valuable belongings number so and so and municipal number so and suit property and leased to the third parties and getting huge rent, though they are not legally entitled to enjoy the rent. Therefore, the trespassing is subsequently made by the defendant one, and as such, the plaintiff are legally entitled to get the actual possession of the suit property. Therefore, the plaintiff pray that the suit property may kindly be ordered to vacate and give actual possession of the defendants to the plaintiff in the interest of justice. Lord, during the pendency of suit, they were dispossessed. Therefore, Lord, by way of amendment, want to seek possession. The trial court rejects the application, holding that in the year number 2, which was allowed for amendment of plaint in the year 2016, you should have sought for that prayer in the year number 2 itself. Since you have not sought that relief in the year number 2, which was filed in the 2016, you are not entitled for that relief. Page 50, my lord, the observation made by the trial court. It is subsequent to, my lord, allowing the I number 2.
Mr. Bogli, you filed a suit for
Declaration
declaration on the basis of adverse possession.
Yes, ma'am.
ಇವಾಗ ಎಲ್ಲ ಅಡ್ವರ್ಸ್ ಪೊಸಿಷನ್ ರೆಫರೆನ್ಸ್ ಡಿಲೀಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ. And your simple prayer at the end of the day is to grant you possession.
Yes, ma'am. Because in the month of January 2022.
That may be so.
Yes.
If you take away the contention of adverse possession, can the contention of possession and a prayer for possession be maintainable?
Not the, we are sought for.
ಒಳ್ಳೇದಾಯ್ತು ರಿಜೆಕ್ಟ್ ಆಗಿದ್ದು.
ಅಲ್ಲ, subsequently, not, they have been dispossessed.
In fact, they should be saying allow it. We have no objection to allow the application ಅಂತ ಹೇಳ್ಬಿಟ್ಟಿದ್ರೆ ಆಗೋಗಿರೋದು. ನಿಮ್ ಸೂಟೇ ಹೋಗೋದು.
So they want
Unless
to.
you succeed on adverse possession, then consequently pending of the suit, section 6 relief of possession ಅದು ಕೇಳಬಹುದು.
Yes.
But ನೀವು adverse possession you are giving up.
Because we sought for, not only that, we sought for declaration that the seal deed executed by the KSFC is null and void. Consequently, if it is
ನಿಮಗೆ
declared that,
ಹೇಳಿದ್ರೆ they will suffer, ಅವ್ರಿಗೆ ಹೇಳಿದ್ರೆ ನೀವು ಸಫರ್ ಮಾಡ್ತೀರಾ ಇದ್ರಲ್ಲಿ ಯೋಚನೆ ಮಾಡಿ. Whether you want to press this writ petition.
beg your lords,
ಯೋಚನೆ ಮಾಡಿ whether you want to press this writ petition.
but kindly have it to next week, Lord.
Think about it. In fact, they should be saying allow the application. At the request of counsel for the petitioner released on 19th.
Interim order.
Interim earlier granted is extended till next week. ಇದರ
230 mood matter. Boranna, BP.
ಇರ್ಲಿ ಬಿಡಿ. Continue.
71, Mallikarjun Swamy.
For the response.
This writ petition is by the judgment debtor. Was permitted to come on record minutes under 22 rule 99. Let's suit was for partition and declaration. Declaration to the effect that the plaintiff's that is respond number 1 and 1 to 3 herein are the absolute owners of RS number 10 bar 1 and 10 bar 6A and half share in RS number 143 bar 1C and 147 bar 2. The other half belonged to one Basawa, who was defendant number 1 in the suit. Now during the pendency of the suit, she had executed a will in favor of one of the defendant therein. That will came to be cancelled by her, and another will was executed in favor of the present petitioner. Yes,
petitioner.
Present petitioner. Now, since she died during the pendency of the suit, the will which was executed in favor of the defendant therein, having been cancelled, her death made the entire suit to be declared in view of the fact that she did not have other heirs. Plaintiffs being the only heirs, they were declared as absolute owners of the entire suit property. They put this decree for execution.
Because this will was not placed on record.
Not placed on record. Now we have filed a separate suit for declaration based on that will, subsequent will which was executed by her. Due to the pendency of that suit, this decree was sought to be executed to take possession of the remaining half share which belonged to Basawa. We moved an application under 21 rule 99 that IA has been allowed by the court holding that the rights of the persons who are sought to come on record have to be adjudicated. After passing an order allowing us to come on record, now the court has passed an order to ordering possession with the police help. That order is called in question. Now at one stage, 2199 is allowed. And on the very next, after
the order on 21.
you'll also still get the order at page number 97. It starts order on I number 9, order I number 5. Covered ಬಂದ್ಬಿಟ್ರೆ ಡಿಸ್ಪೋಸಲ್ ಆಗಿ ತಗೋಡ್ ಅಂತ ಅವ್ರಿಂದ ಅಲೋ ಮಾಡತ್ತಾರ ನಾವು ಇದು ಮಾಡಿದ್ವಿ
being spoken to. ಇದು ಬೇರೆ. ಬಿಟ್ಟು 16. And 13, 16, 17, 25, 26, 27, 34, 35, 55, 5.1, 52.
You filed under 21 rule 99.
Yes.
That could have been filed only after disposition.
That was,
Other than judgment disposed of by the holder of a decree.
that should have been a 97.
Third party objector application.
Hmm.
In your
Application.
Well, that's what I-
97 is when only the decree holder can file.
52 well, that's
That is interpreted by the Supreme Court and said, any other.
Huh. So you filed under 99 as if contending
And
you have
that
been
has to
dispossessed
be,
and
that has to be read as, because read with 151 is there. The quoting of the provision is wrong. Yes.
The bailiff ಹೋಗಿದ್ರು ಅವಾಗ್ಲೂನು. But bailiff has not succeeded.
My only submission is now, rightly or wrongly, this application is allowed and they have accepted this order. When I am permitted to come on record and to agitate my rights under the will. If the entire property is, decree is, executed.
Hmm.
The earlier suit has reached finality up to apex court notes. Now, the judgment debtor's son-in-law or he happens to be son-in-law. He has come on record stating that there is another will cancelling the earlier will made in favor of judgment debtor. If this goes on, the dispute continues in eternity. Now he has filed separate suit. He has to state before that present suit, not in this execution proceedings. He has to establish his right on the basis of will in that suit.
well, that's-
Only on the basis of the application being, interpleader application being allowed. That doesn't give him right to lots conduct a mini trial in respect of the will claimed to be executed in his favor.
You filed the suit knowing fully well of the execution proceedings.
So this, that is in 2019. I cannot say, suit was filed in 2019. Yes.
You knew that EP was pending.
The plaint doesn't.
Where is that plaint?
There is no reference to the execution in the plaint. Cause of action is said to be only
We
in
are
a
aware of the suit, the appeal.
suit, and they have disclosed it in the plaint. Suit and appeal, they have disclosed it in the plaint. It's, if my application was not,
Challenge those judgments.
no, the decree is granted only for the reason that Basava had died intestate. Their claim was for harsh.
Yes, but should you not challenge it?
No, blood, sir. In the absence of Basava, they are given. Otherwise, the plaintiff itself was claiming half share in respect of these two property.
Correct.
Yes.
That giving should you not challenge. In the absence of any other legal representative of Basava, the allotment of share should you not challenge. You only said declaration of half share.
Half share, yes.
So that allotment is not under challenge in any proceeding.
It is only because by virtue of the death, yes.
ಯಾವುದೇ ಇರ್ಬೋದು Mr. Remit. But so
Yes, yes,
long as
I
the
understand.
allotment
The
continues
technical
to be
glitch will,
there,
yes. But a suit is,
it is bound to fail.
That's why, let's, even if the suit were to fail for that reason, now this execution being arising out of the same judgment in which they are claiming the entire property.
The only thing under 101 which can be decided is the claim.
Yes.
In an application filed under
Yes,
97 or 99.
Yes.
97 now being held to be both JDR or
As well as, yes.
anybody claiming under the JDR.
Yes.
Will come under that.
Please.
Now, what is to be, if we say, okay, the suit Allah 101 in the same proceeding it has to be decided.
Yes.
There is nothing to be decided because what you only asked for is a declaration that you are entitled to half share without challenging the allotment made to the plaintiffs in OS number 15.
Yes.
OS number 15 of 96.
Yes.
Confirmed in RA 17.
90, yes.
And subsequently
that was in essence, the court doesn't say that they have become the owners by virtue of the, because the subsequent act of the death of defendant number 1 there. If the executing court were to go into the issue of will, then it will necessarily say that decree is valid to the extent of half share.
For that purpose, you'll have to challenge what judgments have been passed earlier. In
Yes, yes, yes. I got at the first moment only.
Only
yes.
say
No, I got it at the first moment.
So there's nothing to be decided in your OS 48 of 2019.
Yes, that
for holding back
order
the
was
police help.
yes. If order on IA number 3 was challenged, probably I was nowhere. Since that is already allowed.
Even if it is allowed, there's nothing to be
I
decided.
got your lordship's point. I will make an application.
You decide, get your suit in OS 48 of 2019 decided, then proceed against them. That's the only thing that you can do now.
When, as your lordships expressed already, that was coming in. No, no, that was already there.
You chose not to.
No,
for whatever reason. Sorry. Petitioner is before this court seeking for the following reliefs. Initially, a suit in OS number 15 of 1996 had been filed, which came to be decreed on 26th May 2008, wherein the plaintiffs were treated as the legal representative of defendant number 1, Basava, since there was no other person claiming to be the legal representative.
And also will executed in favor of defendant number 2 loss was held to be not true.
Aದೇನು ಮಾಡಿಲ್ಲ, ಅದು ಕ್ಯಾನ್ಸಲ್ ಆಗೋಯ್ತು.
Not
it is held that will is not true.
Will is not true.
And on account of the will said to have been executed by defendant number 1 in favor of defendant number 2 therein was not proved. And as such, the plaintiffs were declared to be the exclusive owners of the properties described in the schedule to the suit and entitled to the possession of the same. The said judgment decree challenged in RA number 17 of 2008 came to be confirmed, and is further stated that the Honorable Apex Court has also dismissed the special leave petition filed. It is thereafter that the petitioner had filed a suit in OS number 48 of 2019 seeking for declaration of half share in the plain schedule property therein on account of a will said to have been executed by the aforesaid Basava in his favor dated 28/1/2004. In the meanwhile, execution proceedings have been filed in EP number 42 of 2015. The petitioner filed an application order 21 rule 99 in IA number 5, which came to be allowed. Subsequently, on an application, the earlier application filed by the decree holder under section 151 for police protection in IA number 3 also came to be allowed, directing the jurisdiction police to assist the bailiff in execution of the warrant. It is challenging this order on IA number 3 that the petitioner is before this court. Sri Mallikarjun Swamy Remat, learned counsel for the petitioner, would submit that the petitioner having been brought on record in pursuance of the orders passed on IA number 5 and order 21 rule 99 to ascertain the rights of the parties and to avoid multiplicity of proceedings, the executing court ought not to have allowed IA number 3 and directed the police to assist the bailiff in securing possession. If possession is taken from the petitioner, the entire proceedings, entire purpose of allowing the application order 21 rule 99 would be negated. Sri Bhima Knorr, learned counsel for respondent, submits that what has been challenged is only the application, only the direction to the police authorities to provide police protection to the bailiff. The petitioner has not established any title in any proceedings. Even the suit filed in OS number 47 of 2018
48 of 2019.
48 of 2019 is still pending consideration, and until the rights are decided in the said suit, the question of the petitioner agitating any right in the execution proceedings would not arise. Heard so and so peruse papers. On an application under order 29 rule 97 or 99 being allowed, in terms of rule 101 of order 21, all questions including relating to right, title or interest in the property arising between the properties are required to be decided and determined by the court dealing with the application and not by a separate suit. In the present case, however, a suit had been filed before an application in order 21 rule 97 to 21 rule 99 was filed and allowed. In the said suit which has been filed by the petitioner, the said suit filed by the petitioner is still awaiting adjudication, and there is no relief which has been granted in favor of the petitioner. That being the case, without the petitioner succeeding in that suit, the question of the petitioner coming in the way of execution of the decree in EP number 42 of 2015 would not arise. Be that as it may, even the relief which has been sought for in OS number 48 of 2019 is for a declaration that the plaintiff is entitled to half share of the suit schedule A property in terms of the will dated 28/1/2004 for a partition to be effected of the suit properties and the plaintiff to be put in separate possession by effecting equitable partition by metes and bounds. In the said suit, the petitioner has not challenged the decree passed in OS number 15 of 1996.
That no, otherwise it will not, actually non-suit me.
ನೀವು ಅದನ್ನ ಇವಾಗ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ.
We'll give the possession.
That finding would virtually non-suit me. In my writ petition.
It won't non-suit. You have to challenge it. And if successful,
So your lordship's finding would certainly have a bearing on the trial suit. No, that will be independently done.
We have to deal with
No,
that.
in my writ petition, it may not.
Unless you withdraw this, we'll have to deal with that.
Tomorrow, I'll
If you withdraw it, we don't need to say anything.
No, argument is easy. Now withdrawal is very dangerous. I'll just secure the signature. That's all.
Okay. We'll dictate it. You tell us tomorrow.
Please.
The decree in OS number 15 of 1996 has not been challenged, nor is the allotment of, nor is the declaration that the plaintiffs in the said suit are the absolute owners being entitled for possession of the same challenge. Furthermore, the said decree has been confirmed in RA number
Let's,
17 of 2008. And the special leave petition has been dismissed by the Honorable Apex Court. All these facts being to the knowledge of the petitioner, the same not having been challenged, as on date, there is nothing in particular which is required to be adjudicated in terms of Rule 101 of Order 21 of the Code of Civil Procedure. In that view of the matter, I do not find any infirmity in the order passed by the trial court on executing court on IA number 3, directing police help for the bailiff to implement the decree passed in OS number 15 of 1996. Hence, the petition stands dismissed. Either separate or get called. At the request of counsel for the petitioner, relist tomorrow.
please.
Withdraw matter, we want to.
Yes.
72, Nandish Patil.
Lord, the petitioners, my lord, are
Yes,
defendant
Mr.
number
Nagaraj
1 and 2.
Kalluri. Nagaraj Kalluri. Ready?
Ready.
Yes.
Lord, petitioners, my lord, are defendant number 1 and 2. My lord, and the respondent, my lord, is the plaintiff. My lord, it's a suit for possession, my lord, and also arrears of rent and means profit, my lord. My lord, the case of the plaintiff is that, my lord, he is, my lord, the owner, my lord, of site number 86, my lord, which is, my lord, in between 85 and 87, which are owned by the defendants, my lord. My lord, the further case of plaintiff is that site number 86 was leased to the defendants, my lord, and there was a breach of the agreement, and thus, my lord, the suit for possession is filed, seeking for, my lord, delivery of possession after a notice of termination, my lord. My lord, the written statement, my lord, we contended, my lord, that there is no landlord and tenant relationship. In fact, my lord, there is an agreement of sale for 35,000, and the entire amount has been, my lord, given to the plaintiff, my lord.
Yes.
My lord, we filed an IA, my lord, under order 15 rule 6, my lord, seeking, my lord, for summoning of the bank manager.
16 rule 6.
Please.
Yes.
My lord, seeking for the summoning of the bank manager, my lord, along with the 4 checks. My lord, my IA, my lord, is at my lord, page 32, please, my lord, annexure D.
Why do you need the checks?
My lord, by those checks, my lord, we have deposited the entire sale consideration in their favor. That is my contention in the written
Bank
statement.
account statement is sufficient.
Lord, in fact, my lord, we had approached the bank also directly. The court has rejected on the ground, my lord, that I have not approached the bank.
Your bank statement,
Please,
indicating whether you are paid, is there.
my lord, but certain signatures and all that will be essential.
First, nim bank statement signature yardappa. Nim bank account
My
nim
lord,
signature.
in the written statement, if your lordship kindly see, my lord, the relevant portion based on which the application is filed, page 23, my lord.
Yes.
Permit me to read para 4, my lord, page 22. My lord, as submitted above, it is true that the plaintiff, with an intention to facilitate the defendant educational institution, agreed to sell the same for valuable consideration of rupees 35,000 and executed an acknowledgement for the receipt of the said consideration of rupees 30,000 and last installment of rupees 5,000 under check bearing number so and so. And he further endorsed that nothing is left to be paid towards the consideration amount of the sale of the suit property. He further endorsed that his name is appearing in the property extract as a minor, and his father was the minor guardian, and he has attained the majority. And after deleting the name of his minor guardian, he will execute the regular registered sale deed as and when called by the defendant society. To that effect, the defendant has passed an acknowledgement on 9/12/2003 addressing to the administrative officer of the defendant institution. He has also enforced on the back page of the said acknowledgement with regard to the amount he has received from 16/8/2003 up to 9/12/2003. He has endorsed that he has received rupees 10,000 on 16/8/2003 by check
Where
bearing
is he
numbers.
endorsed?
Sorry, my lord.
Where is he endorsed?
My lord, that endorsement, my lord, I am told is on the acknowledgement, my lord.
So acknowledgement you have to produce.
My lord, we are producing that, my lord, but
Endorsement
the
won't be on the
checks, my
check.
lord, but the checks, my lord, would be relevant for, my lord, establishing, my lord.
What will it establish?
My lord, transfers have been made, my lord, and they are
But transfer
disputing
can
that.
be reflected by your own bank account. It's your bank account.
Please.
You can produce your bank account.
Lord, we are producing that also, my Lord. Along with that, we wanted to produce the checks also. Your Lordship may kindly see the endorsement issued by the bank, my Lord. Page 46. We have approached the bank also, my
This is
Lord.
of the year 2003. Bank is required to keep something only for 7 years. After 7 years, it is destroyed. Now it cannot even be produced. National Bank produced Madila, then you want to take advantage of it.
The bank is saying that as it's a confidential document, we cannot produce it.
They won't have it at all. Merely the acknowledgement.
My Lord, Annexure H, my Lord, page 46. We have approached the bank, my Lord. It issues an endorsement.
Trade Cooperative Society.
ಸದರಿ ದಾಖಲೆಗಳು ಗೌಪ್ಯತೆಯಿಂದ ಕೂಡಿರುವುದರಿಂದ ಬ್ಯಾಂಕಿನ ಕಾಯ್ದೆಯಡಿ ಪ್ರಕಾರ ಕೊಡಲಿಕ್ಕೆ ಬರುವುದಿಲ್ಲ.
ನಿಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಕೌಂಟ್ ಕೊಡಕ್ಕಾಗತ್ತಾನೆ?
ಅದು ಕೊಟ್ಟರೆ
ಅದು ಪ್ರೊಡ್ಯೂಸ್
that we would have produced.
whether it has been made to his bank account. Sorry. Petitioner is before this court seeking for the following reliefs. Respondent had filed a suit in OS number 91 of 2012 seeking for possession of the suit scored property as also for arrears of rent and mean profits. In the said suit, defendant had filed a written statement along with a counterclaim contending that the plaintiff had executed an agreement of sale in favor of, had agreed to sell the property in favor of the defendant, in furtherance of which several amounts had been paid. The petitioner, the defendant also filed an application on Order 16, Rule 6 of the Code of Civil Procedure for direction to, for issuance of witness summons to the bank concerned, the bank of the petitioner, to produce the checks issued by the petitioner to the respondent. The said application having been opposed came to be dismissed. Challenging the said order, the petitioner is before this court. The contention of Sri Nandish Patil, learned counsel for the petitioner, is that there being a dispute raised by the respondent as regard the receipt of the monies, it is required for the checks to be summoned to enable the petitioner to mark the said checks to substantiate the claim of specific performance raised by the petitioner and negate the contention of the respondent. Having heard learned counsel for the petitioner and having perused the papers, I am of the considered opinion, firstly, that the claim of specific performance would have to be established by the petitioner on his own in terms of the applicable laws. If the petitioner has made payment of any monies from its bank account, it is for the petitioners to produce the said bank account to establish such payment. The mere production of the checks allegedly issued by the petitioner on the bank account of the petitioner available with the bankers of the petitioner will not anyhow to the benefit of the petitioner unless the said amounts have been credited into the account of the respondent, which can well be established by the petitioner producing the bank statement stroke bank passbook to evidence such payment. Reserving such liberty, no grounds having been made, reserving the above liberty, the petition stands disposed.
Please.
233 matter, Boranna BP.
Yes.
Petitioner in this case, my lord.
No confidence.
No confidence.
In ground.
ಆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿರೋದು 27/1 ಮಾಡ್ತಾರೆ ಸರ್, ಗ್ರಾಮ ಪಂಚಾಯತಿ PDO ಮಾಡ್ತಾರೆ. 24th AC ಮಾಡ್ತಾರೆ, 27th PDO ಮಾಡ್ತಾರೆ ಸರ್.
ಹೇಳಿ ಸರ್ ಸರಿಯಾಗಿ.
27th 1 PDO ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ ನಮಗೆ.
27/12 PDO.
ಆ PDO.
ಪೇಜ್ ನಂಬರ್?
ಪೇಜ್ ನಂಬರ್ 15 ಮೈನ್, Annexure A.
PDO ಅಲ್ಲಪ್ಪ ಇದು. Sahayaka Ayuktharu, this is.
ಸಹಾಯಕ
Then seal ಇದೆ ಅಲ್ಲ Mr. Kunal? PDO seal. ತೋರ್ಸಿ ಅವ್ರು.
ಇದೆ.
Page 15.
Next is by the Assistant Commissioner. It is issued by the Assistant Commissioner.
ಬಟ್ ಕೆಳಗೆ ಸೀಲ್ ಏನಕ್ಕಿದೆ? ಒರಿಜಿನಲ್ ಸೀಲ್ ಇದೆ.
Original. 27.
It is signed by Assistant Commissioner.
ಕೆಳಗಡೆ.
ಕೆಳಗಡೆ.
PDO ಅಂತಿದೆ. PDO ಅಂತಿದೆ.
You'll have to state. And AGA accepts notice for respond number 1 and 2. Moroba Gram Panchayat yaru?
Maraba Gram Panchayat. Maraba Gram Panchayat.
Yaru? Standing councillor.
Iremat, sir.
Grounds may be taken, Your Lordship. Ground number 1. Is stated by himself that input notice issued by second respondent, Assistant Commissioner. Ground number 1, 9. They are not saying that it is a PDO.
ಆ ಗ್ರೌಂಡ್ ಏನು ರೇಸ್ ಮಾಡಿಲ್ಲ ನೀವು? 49(2) ಬಗ್ಗೆ ಹೇಳಿದ್ದೀರಾ. 49(2) is no longer in the statute book.
Yes, my lord.
There is no requirement. And AGA accepts notice for respond number 1 to Moraba Yarappa. Moraba, Kudgi Taluk, Vijayanagara district.
Shivraj Iremat. Shivraj Iremat.
Shivraj Iremat for respond number 3. Notice to respond number 4 to 13 is dispensed with in view of the proposed order to be passed. The petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that there being allegations made against the petitioner Upadhyaksha of the Moraba Gram Panchayat. No notice had been issued to the petitioner to explain the allegations, and as such, the notice issued by the first respondent Assistant Commissioner fixing
Second respondent.
12/2/2025 for a meeting to consider the no confidence motion is bad in law. The entire grounds which have been raised in the above petition are relating to subsection 2 of section 49 of so and so, which has been excluded from the statute book with effect from 31/3/2010. Post the deletion of subsection 2 of section 49, there would be no requirement for any allegations to be made against the Adhyaksha or Upadhyaksha, and a notice for no confidence can be moved with or without allegations, and the requirement of subsection 2 of section 49 is not required to be followed. In that view of the matter, no grounds being made out, the petition stands dismissed.
Vittal Teli.
And for respondent, kindly have an next week, candidate.
It's very short point, Manoj. This is arbitration award. Notes in the execution is impounded, 10 times penalty.
Still there. Papa junior yak is mad. 73 at the request of counsel for respond released on 20th.
Notes interim order may be.
It's made clear that no further adjournment would be granted. Interim order is granted earlier, is extended till next date.
74, Girish Remat.
For the additional loss. Filed application for consider the representation annexure E loss to pay the arrears of scholarship that has not paid today, my lords. Respondent number 2 has to pay, my lords. He has served the notice, but he has not appeared.
Petitioner is before this court seeking for the following relief. The petitioner claims to be studying in Bachelor of Engineering degree. She having taken up admission in Vishwanath Rao Deshpande Institute of Technology. The petitioner belonging to
3B.
Huh?
3B. Caste certificate other production, my lords, at annexure C, your lords.
Page?
C, page 13, your lords.
Belonging to category 3B had made an application for grant of scholarship. Why the online application dated?
Dated, your lordship, 24/10/2019, your lords.
24/10/2019. The said application not having been considered.
It is not only your lordship scholarship or correction of the form your lordship wants. It is not only correction. It
But also correction is also.
In correction.
In
A verification report.
ಅದರಲ್ಲಿ ಬರೆದಿದ್ದ ಎನೆಕ್ಸರ್ ಎನೆಕ್ಸರ್ ಇದಲ್ಲಿ
Annexure E.
E, your lords.
ನಾನು 2017-18 ಸಾರಿ BA ವ್ಯಾಸಂಗ ಮಾಡುತ್ತಿದ್ದು ನಾನು ವಿದ್ಯಾಸಿರಿ ಅರ್ಜಿಯಲ್ಲಿ ಕಾಲಮ್ ನಂಬರ್ 14ರಲ್ಲಿ ಕಲಿಯುತ್ತಿದ್ದ ಕೋರ್ಸ್ ತಪ್ಪಾಗಿದೆ. ನಾನು BE ಸಿವಿಲ್ ಕಾಲೇಜ್ ನನ್ನ ಅರ್ಜಿ ತನಕ ಸ್ವೀಕೃತವಾಗಿಲ್ಲ. ಆದರೆ ನಾನು ಸದರಿ SPM ಕಾಲೇಜ್ನಲ್ಲಿ BE ಸಿವಿಲ್ ಕಲಿಯುತ್ತಿದ್ದೇನೆ. ಆದ್ದರಿಂದ ತಾವು ದಯವಿಟ್ಟು ನನ್ನ ಮೊದಲ ಅರ್ಜಿಯನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡಿಕೊಡಬೇಕೆಂದು ಮತ್ತು 14 ನಂಬರ್ ಕಾಲಮ್ BE ಸಿವಿಲ್ ಅನ್ನು ನಮೂದಿಸಿ ವಿದ್ಯಾಸಿರಿ ಸ್ಕಾಲರ್ಶಿಪ್ ನಿರ್ವಹಿಸಿಕೊಡುವೆಂದು ತಮ್ಮಲ್ಲಿ ಕೇಳಬೇಕಂತ.
ಹೆಂಗಪ್ಪ ಮಾಡ್ತೀರಾ ಇದು?
Yeah.
You want to change the college, you want to change the.
My lords, they have early
application file ಮಾಡಿ.
Please.
Fresh application file ಮಾಡಿ.
Please.
Not being considered, a representation was submitted on 24/10/2019. However, in the perusal of the representation indicates that the petitioner has not submitted a reminder, but she has requested for certain corrections to be made in the application for scholarship. Such a request by way of a letter not being permissible and an application for rectification or modification being required to be made. I have the considered opinion that the earlier application filed suffering from defects, the representation for modification not being capable of consideration, the petitioner would have to file a separate application for modification if so permitted, or to file a fresh application for seeking for scholarship. In the event of either of them being done, the respondents are directed to consider the same and pass necessary orders within 30 days of such application being made. With the above observation, the petition stands disposed.
75, Srikanti Patil.
For respondent.
None appears for the petitioner released on 20th.
76, HR Gundappa.
For the petitioners, my lord. Petitioners called in question the 28-1 notification and also 28-4.
You are appearing. Wrong. Challenging?
Challenging the 28-1 notification dated on 5th June 2009, my lords. Wide annexure B, my lords. And also final declaration that is on wide annexure F, my lord, that is dated on 7/7/2022. There is a delay of 13 years, 1 month in final declaration. So far, no award being passed, possession not taken, and award not amount not being deposited by the respondents before this before the any of the courts.
For kind submission, I have not filed a statement of objection. I will file.
What objection will you? 2006.
9. Please, my lords.
2022.
Kindly appreciate, my lord, their prayer. Second prayer can be allowed. First prayer, they are seeking to quash the notifications. Second prayer can be allowed in accordance with law. We will consider their, we will pass award, if my lord direct.
Second prayer allowed.
Only
third will
alternative,
reserve
my lord,
liberty
in
to you
case-
to initiate fresh acquisition proceeding.
That's why we will consider. We will consider. We will pass appropriate order.
Under 2013
In accordance with law, we will pass.
2013 Act, my lords.
2013 Act.
In accordance with law, we will pass.
28-1 ಹೋದ್ಮೇಲೆ ಮುಗೀತು.
In accordance with law, we will pass.
Petitioners in all the above matters are before this court seeking for the following reliefs. In all the above matters, what is essentially challenged is the preliminary notification under subsection 1 of section 28.
Please, my lords.
Dated 5/6/2009 stroke 8/6/2009. The order of the SLAO dated 3/3/2010 and the final notification under subsection 4 of section 28 issued on 7/7/2022. The submission of Shri H.R. Gundapal and counsel for the petitioner is also that post the final notification, no award has also been passed and the position continues to be with
the
that of the
petitioners.
petitioner.
No. Immediately after issuance of the
No, no, no.
28-4 notification.
So, automatic vesting.
Please.
And nimmed argument barte. See, PNRT learned counsel for the KADB would submit that immediately on issuance of a notification of subsection 4 of section 28, the land is automatically vested with the state. And therefore, whether physical possession is taken or not, the possession is deemed to have been vested with the state. And on that ground, he submits that the petitioner cannot take any advantage of the said possession not being taken over. Having heard both the counsels, what is only clear is that there is a preliminary notification was issued way back in the year 2009. The final notification has been issued in the year 2022, and the possession continues to be with that of the petitioner, though a claim of automatic vesting is made by the KADB. There being a completely inordinate delay in issuance of a final notification, if the final notification will continue to subsist, if the preliminary and final notification will continue to subsist, then the compensation which is required to be awarded to the petitioner would have to be computed as on the date on which the preliminary notification was issued, that is 5/6/2009 stroke 8/6/2009, which in my considered opinion would cause grave loss, hardship and injury to the landlord, providing an unfair benefit to the KADB and or the state.
There is inordinate delay in filing the writ petition also. 2023, they have filed writ
No,
petitions. 2023.
Want to make that submission?
Inordinate delay in passing an award. Inordinate delay in filing the writ petition also.
Which cannot be so taken by either by the KADB or the state. By the KADB being an instrumentality of the state and the state being vested with a duty to preserve the rights of its citizen. Though a faint submission has been made by Sri PNRT that the petition filed is belated, inasmuch as the final notification having been issued on 7/7/2022, the writ petition has been filed
17/4/2023.
On
17th March 2023.
17th March
23,
23.
Please.
There being a delay of
inordinate
nearly
delay.
8 months inordinate delay of 8 months,
No, no.
I am of the considered opinion that there cannot be any such delay which could be attributed to the petitioner. More so when the delay on part of the KIDB and the state is glaring on the face of records. The preliminary notification having been issued on 5/6/2009, the final notification having been issued on 7/7/2022. In that view of the matter, I pass the following order. Writ petition is allowed. Writ petitions are allowed. In all the above matters, the preliminary notification bearing CI 120 SPQ 2009 dated 5/6/2009 issued under subsection 1 of section 28 insofar as the land of the petitioners are concerned is hereby quashed. The final notification as subsection 4 of section 28 bearing number CI 33 SPQ bracket E 2021 insofar as the lands of the petitioner are concerned is hereby quashed. Liberty is however reserved to the respondents to initiate fresh acquisition proceedings
no.
insofar as the lands of the petitioner are concerned under the Right to Fair Compensation Zones Act 2013. ಒಂದು ಟೇಬಲ್ ಮಾಡ್ಕೊಡಿ ಎಲ್ಲಾನು.
Please, my lords.
Writ petition number, party's name, survey number.
Please.
A table incorporate.
Please, my lords.
Well, kindly of sheep, the notification has been quashed. We will consider second petition number, second prayer. No, notification cannot be quashed. Notification cannot.
This date we will record your submission and dispose of the matter.
Notification cannot be quashed.
Yeah, okay.
Initiate. That's why. If that is so, man, I will file my statement. For second prayer, I am restrict one.
If you are willing to make payment of compensation in 2013 Act as on today's rate, no problem.
We will
2009,
we will pass award in accordance with law as per 2013 Act.
what is 2013 as on what date?
When the notification was issued, my lord.
Sorry. ಅದೆಲ್ಲ ಮಾಡಕ್ ಬಿಡಿ.
Mala, kindly appreciate. If notification of question, I will file my statement of objection. Please.
Already been quashed.
No, I am sorry.
Submission ಎಲ್ಲ record ಆಯ್ತು.
Kindly appreciate, my lord. Notification cannot be quashed at this moment, my lord, because
It has to be quashed after 20 years. Yes, Mr. Case.
77.
I am appearing for the petitioner, my lord. We will take in a 1 week time, sir, please.
Report ಹಾಕಿದ್ದೀರಾ?
That's no, sir.
Along with report and
ಹಾಕಿದ್ದೀರಾ ರಿಪೋರ್ಟ್?
ಮೆಮೋ ಅಲಾಂಗ್ ವಿತ್ ರಿಪೋರ್ಟ್ ಅಂತ ಇದೆ ಇದರಲ್ಲಿ. ಮೆಮೋ ಅಲಾಂಗ್ ವಿತ್ ರಿಪೋರ್ಟ್ ಅಂತ ಇದೆ ಇದರಲ್ಲಿ.
ಬಂದಿದೆಯಾ? ಕಾಪಿ ಬಂದಿದೆಯಾ ನಿಮ್ಗೆ?
No, sir.
ರಿಸೀವ್ಡ್ ಅಂತ ಇದೆಯಲ್ಲಮ್ಮ? Lord Counsel for the petitioner seeks for and is granted a week's time to go through the report submitted by the ADLR and make a submission. Relist on 24th.
Please, sir.
78, Nandish Patil.
For the petitioner, my lord, contesting respondent. Ready?
Yes, ಹೇಳಿ.
My lord, annexure F, my lord, the order passed by the respondent number 1, cancelling the grant is under challenge, my lord. Lord, petitioners, my lord, are the minority, belong to the scheduled caste community. Lord, in 1994, my lord, the petitioners, my lord, purchased survey number 354/C, my lord, to 3 different extent from, my lord, respondent number 3 herein. Lord, after purchase, my lord, khata was transferred. RTC entries were also made. Lord, till 2023, my lord, there was no disturbance. Till in 2023, my lord, respondent number 4, my lord, started to raise compound wall in the scheduled property. On enquiry, my lord, we learned that, my lord, respondent number 1, my lord, way back in 1996, has conducted enquiry under section 80 of the Karnataka Land Reforms Act, and, my lord, the grant of the respondent number 3 was cancelled. On the ground that, my lord, the vendor had filed a false affidavit, my lord, under section 81 of the Land Reforms Act. Lord, we are the bona fide purchasers. Lord, no notice was issued to us. And, my lord, Insofar as petitioners are concerned, it's an ex parte order.
Cannot be said as an ex parte order. The vendor was already notified, my lords, and they have purchased the property during the pendency of the proceedings. If I may invite a lordship's attention to page 70, my lords.
Page
70.
70.
70, my lords.
Yes.
It's the order impugned. 1990, my lords, the proceedings are initiated. Notices are issued, my lords, to respondent number 3 and through RPAD. He remains absent. Being aware about these proceedings, my lords, he alienates the property, my lords.
1990.
Please, may I read the relative portion of the order, my lords, the first paragraph. ತಹಶೀಲ್ದಾರ್ ಹಗರಿ ಬೊಮ್ಮನಹಳ್ಳಿ ಇವರು ತಮ್ಮ ವರದಿ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ದಿನಾಂಕ 16/6/90ರಲ್ಲಿ ಶ್ರೀ ಸಿ ಕೆ ರಾಮಚಂದ್ರ ರಾವ್, ದಟ್ ಇಸ್ ಥರ್ಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್, my lords.
Where are you reading?
ಇದು ಯಾವ ಪೇಜ್?
Page
67, my lords. In my this thing, the page number is 70. 67.
Yes.
Please, my lords. Lords, it's an order passed by, my lords, Assistant Commissioner Hospete. May I read, my lords? ತಹಶೀಲ್ದಾರರು ಹಗರಿ ಬೊಮ್ಮನಹಳ್ಳಿ ಇವರು ತಮ್ಮ ವರದಿ ಸಂಖ್ಯೆ ಸೋ ಅಂಡ್ ಸೋ ದಿನಾಂಕ 16/11/90ರಲ್ಲಿ ಶ್ರೀ ಸಿ ಎಚ್ ರಾಮಚಂದ್ರ ರಾವ್, ದಟ್ ಇಸ್ ದಿ ಥರ್ಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್, my lords. ಇವರು ಡಾಕ್ಯುಮೆಂಟ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ದಿನಾಂಕ ಸೋ ಅಂಡ್ ಸೋ ಅನ್ವಯ ಹಗರಿ ಬೊಮ್ಮನಹಳ್ಳಿ ತಾಲೂಕಾ ವರದಾಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 354C ವಿಸ್ತೀರ್ಣ 5 ಎಕರೆ ಜಮೀನನ್ನು ಖರೀದಿಸಿದವರು ಕರ್ನಾಟಕ ಭೂ ಸುಧಾರಣೆ ಕಾಯ್ದೆಯ ಕಲಂ 79A ಉಲ್ಲಂಘನೆಯ ಕುರಿತ ಕಲಂ 79C ಅನ್ವಯ ವಿಚಾರಣೆಗಾಗಿ ಖರೀದಿದಾರರಿಗೆ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿದ್ರು. ವಿಚಾರಣೆ ದಿನಾಂಕ 28/7/1990 ಮತ್ತು 31/10/1990ಗಳಂದು ಗೈರ್ಹಾಜರಾಗಿರುತ್ತಾರೆ ಹಾಗೂ ಖರೀದಿ ಸಮಯದಲ್ಲಿ ಕಲಂ 81A ಅನ್ವಯ ನೀಡಿದ ಘೋಷಣೆಯಲ್ಲಿ ಸುಳ್ಳು ಘೋಷಣೆ ನೀಡಿ ಖರೀದಿ ಮಾಡಿರುತ್ತಾರೆ. ಅಂದಿನಿಂದಲೂ ಪ್ರಸ್ತಾಪಿತ ಜಮೀನನ್ನು ಬಿಟ್ಟಿದ್ದು ಗೈರ್ಹಾಜರ್ ಪಟ್ಟದಾರರಂದು ತಿಳಿಸುತ್ತಾ ಸಂಬಂಧಿಸಿದ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸುತ್ತಾ ಕರ್ನಾಟಕ ಭೂ ಸುಧಾರಣೆ ಕಾಯ್ದೆ ಕಲಂ 80 ಮತ್ತು 83ಯಲ್ಲಿ ವಿಚಾರಣೆ ಮಾಡಲು ವಿನಂತಿಸಿರುತ್ತಾರೆ. ಮೇಲೆ ಕಾಣಿಸಿದ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ವಿಚಾರಣೆಯನ್ನು ದಿನಾಂಕ 29/1/1993 ಗೆ ನಿಗದಿಪಡಿಸಿ ಖರೀದಿದಾರರಿಗೆ ವಿಚಾರಣೆಗೆ ಹಾಜರಾಗಲು ನೋಂದಣಿ ಅಂಚೆ ಮೂಲಕ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿದ್ರೂ ಹಾಜರಾಗಿರೋದಿಲ್ಲ. ಪುನಃ ದಿನಾಂಕ 12/7/96 ವಿಚಾರಣೆಗೆ ಹಾಜರಾಗಲು ರಿಜಿಸ್ಟರ್ ನೋಟಿಸ್ ಮುಖಾಂತರ ಜಾರಿ ಮಾಡಿದ್ರು ಖರೀದಿದಾರರು ಹಾಜರಾಗಿ ತಮ್ಮ ಹೇಳಿಕೆಯನ್ನು ಇಡಿಸದೆ ಗೈರ್ಹಾಜರು ಉಳಿದಿರ್ತಾರೆ. ಅವರು ಗೈರ್ಹಾಜರಿಯನ್ನು ಗಂಭೀರವಾಗಿ ಪರಿಗಣಿಸಿ ಪ್ರಕರಣವನ್ನು ಲಭ್ಯ ಇರುವ ದಾಖಲೆ ಅನ್ವಯ ಪರಿಶೀಲಿಸಲು ತೀರ್ಮಾನಿಸಲಾಯಿತು.
96.
Before that, my lords, proceedings were initiated on 6/11/1990.
When was the purchase made by the petitioner?
Purchased by petitioner was in the year 1994, my lords. 11/8/1994. Before that, thrice the notices were served on the, my lords, the vendor of petitioner. That is 28/7/1990 and, my lords, 31/10/1990.
So the date on which the order was passed.
Please, my lords.
He had a right in the property.
But, my lords, he is a subsequent purchaser. And, my lords, the property was purchased by him during the pendency of these proceedings. The vendor was very much aware about these proceedings.
But should not he be given a right to defend him being a purchaser?
But, my lords, as on the date of the, my lords, proceedings were initiated way back, my lords, and now, my lords, there is inordinate delay also, my lords, in filing the present petition. The order is of the year 1996.
Lord, the order.
Was it allotted to you?
My lords?
When was the property allotted to you?
My lords, there is a lease, my lords, in my favor. My lords, along with my statement of objections.
When was it, please?
Please, my lords. My lords, since 2010, my lords, the proceedings were initiated. The recommendation was made by, my lords, the principal, deputy commissioner to principal secretary. And 2011, my lords, there is a government order.
When is the lease?
2011, lease, my lords.
My lord, page number 77, annexure G. Page number 70 is the relevant portion, my lord. 2014, there is an order.
R11, my lords.
In my petition.
77 of what?
77 of my petition, my lord. Annexure G.
That is petition.
78 is the relevant portion. Lord, there is an order on 15/9/2014 in favor of respondent number 4.
14.
14 months.
You come in
Lord, we were
23.
not aware of this proceedings, my lord. Only after they started raising the compound wall, Lord, we made an inquiry and we were notified that it was already.
Entry was made in the RTC in 2007.
Lord, they are all the village, rustic villagers, my
Seven
lord.
only, my lords. Yeah.
They are illiterate.
Illiterate hengagate. What have you been doing with the property?
Lord, I have annexed the photograph at page number 58, my lord. We are cultivating.
There's no
Page number
cultivation as such, my lords. Even the
59,
impugned
60.
order says, my lords, build, what's like there.
When was the entry of Sarkara made in pursuant to this order of 1996?
It's 2007, my lords, if I'm not wrong.
RTC ಎಲ್ಲಿದೆ? RTC ಎಲ್ಲಿದೆ?
Please, my lords.
Annexure A in my petition, my lord.
Annexure?
Annexure A, my lord.
Page.
Page, my lord, page number 40, page number 41 onwards. Annexure C, my lord. Page number 41 onwards.
Onwards, where is the entry made?
Entry, my lords, my apologies. Without memo, my lord.
Sorry. When is the entry of Sarkara
Lord,
made?
page number 44, last portion, 96, 97. Karnataka
96,
Sarkara.
97, my lords.
Lord, it shows Karnataka Sarkara.
The,
Page number 44, last column.
This is though for the year 2023-24, my lords, but the entry is, my lords, affected in the year 1996-97, my lords. M number, my lords, mutation number. Even the petitioner's name are also deleted, my
You
lords.
produce ಮಾಡಿರೋದ್ರಲ್ಲಿ page 50 Karnataka Sarkara ಅಂತಿದೆ.
Sarkar ಅಂತ ಇದೆ.
96, 97. So you are aware of it. ಎಲ್ಲಿ ನೋಡಿದ್ರು ಏನಿಲ್ಲ. Petitioner is before this court seeking for the following reliefs. The petitioner claims to be aggrieved by the order dated 19/7/1996 passed by
Respondent number 1, my
first respondent assistant commissioner. What have you challenged? First respondent assistant commissioner at annexure F. Under section 80 and 83 of the Land Reforms Act, holding that the sale in favor of the vendor of the petitioner was in violation of section 79A and 79B of the Karnataka Land Reforms Act. The said purchaser, not being an agriculturist, entitled to purchase the aforesaid land. The petitioner claims that the petitioner having purchased the land on 5/8/1994, the petitioner ought to have been issued a notice before any action was taken, since there is a right created in favor of the petitioner in persons of this registered sale deed. Having gone through the documents, it is seen that the impugned order of the first respondent assistant commissioner was passed on 19/7/1996, in furtherance of which VM number 9/9697 was entered into on 13/9/1996. And the name of the petitioner's vendor came to be deleted from the RTCs, replacing it with the name of the government of Karnataka. The same is also evidenced by the RTC which has been produced by the petitioner themselves at page 50 of the above petition. Thus, The entry in the revenue records have been effected on 13/9/1996. The above petition, which has been filed on 21/9/2023, after the property had been leased to respondent number 4, is hopelessly barred by delay and laches. In that view of the matter, it being clear that the petitioner's vendor had purchased the property in violation of section 79A and B, and the said vendor of the petitioner not having contested the matter before the Assistant Commissioner, despite of notices having been issued to him on 2 earlier occasions by Regis Post acknowledgement due. The petitioner cannot have a better title than his vendor. As such, both on account of delay and laches, as also on account of merits, no grounds being made out, the petition stands dismissed.
Obliged, my lord.
39 on third.
Pass for matter, cell number 39. Chetan,
Yes.
There are so many documents.
Release tomorrow,
Tomorrow.
2:30 PM. Please, 39.
Submission, serial number 99, no conference motion. Hardship has granted the stay, my lord. During, for that stay, my lord, we can't put.
99.
Please.
99 release tomorrow at 2:30 PM.
Serial number 84, my lords. Serial number 84, my lords.
No confidence motion.
No, my lords. Day after tomorrow it may be taken. There is some.
ಏನಕ್ಕೆ ಅದು urgent? What is the urgency?
I have purchased the property, my lords. So, there is, day after tomorrow it may be taken.
Lord, serial number 96. Serial number 96, my lord. The learned trial court has granted TI in my favor against the defendant, and learned lower appellate court has confirmed the TI order. They have filed this WP, and the stay is granted. Liberty is given to seek vacation. I am filing the application for
You
vacation.
file it.
But serial number request it to be taken on 18th.
94, my lord. Serial number 94. Interim order.
Urgency ಏನಪ್ಪ?
Urgency is, my lord, for restoration of power supply. It has been
Restoration of power supply.
Yes, it's disconnected.
94.
Okay. Next tomorrow or day after tomorrow.
Hello, Mr. Kamte.
Come this.
Please come there.
94 released on 13th.
Serial number 92, your lordship. Next week, any date, your lordship.
ಏನಕ್ಕೆ urgency ಇದ್ರೆ ಹೇಳಿ.
Interim order may kindly be extended.
Next week, your lordship.
ದಿನ 100 matters ಮೇಲೆ ಲಿಸ್ಟ್ ಆಗಿದೆ, ಅರೌಂಡ್ 30 ಮೆಮೋಸ್ ಮೂವ್ ಆಗ್ತಾ ಇದೆ, ರೀಚ್ ಆಗಲ್ಲ.
After 17th, your lordship.
ಲಿಸ್ಟ್ ಮಾಡೋದು ಬೇಡ.
After 17th, your lordship. 17th, your lordship.
After 17th March told.
No, your lordship.
18th, one matter. 18th.
ಆಗಿಲ್ಲ Mr. Misley. 18 there are already around 70 matters plus listed.
Road is there. Road is
ಆಯ್ತು, ಲಿಸ್ಟ್ ಮಾಡಿ. ರೀಚ್ ಆಗಲ್ಲ ಹೆಂಗೋ ತಗೊಳ್ಳಿ.
Please.
Shiram.
96.
Shiram.
92.
Shiram.
96 ಅಲ್ಲ ಸರ್?
Shiram.
19th ಹಾಕಿದೆ.
Shiram.
Shiram.
19th. 88. 95 ನಾ?
18th ಕೊಡ್ಸಿ.
95 ನೀವೆಲ್ಲಿದೆ
ಸರ್ 18th ರಿಕ್ವೆಸ್ಟ್.
ಹಾ, ಆಯ್ತು.
Number 88.
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀನಿ.
ಅಲ್ಲ 19th ಬದಲು 18th ರಿಕ್ವೆಸ್ಟ್.
24 ಸರಿ, ಯಾವುದು ಕೊಡ್ತಾ ಇಲ್ಲ ಸರ್.
Serial number 9 entry.
ಆಯ್ತು.
19th ಅಲ್ಲ 18th ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡೆ. ಸ್ವಲ್ಪ 18th ಅಕೌಂಟ್ ಮಾಡಿದ್ರೆ ನಾವು ಬರೋದನೇ ವಾರದಲ್ಲಿ ಒಂದು ದಿವಸ ಬರ್ತಾ ಇದ್ದೀವಿ.
ಆಯ್ತು ಸರ್. ಹಾ, ಇಲ್ಲ ಅಂದ್ರೆ ಆಗ್ತಾ ಇದೆ. ಇಲ್ಲ, ಕೆಲವೊಂದು ಇಂಟ್ರಿ ಮಾಡೋದ್ರಿಂದ ಅಷ್ಟೇ ಕಷ್ಟ. ಮುಗಿತಲ್ಲ. 84 ಫ್ರೈಡೇ ತೋರಿಸ್ತೀನಿ ನಿಮ್ಗೆ ಲಿಸ್ಟ್. 21st ಹಾಕಿದ್ದು, 20th ಹಾಕಿದ್ದು. ಅದೇ 20th 18 ಕೊಡ್ಲಾ? 17 ಹೇಳಿ ಸರ್. ಥ್ಯಾಂಕ್ ಯು. 19 ಮುಂದೆ ಹೇಳಿದ್ರು ಸರ್. 18
So 93.
Entry order extend ಆಗ್ಬೇಕು.
ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ.
ಆಮೇಲೆ ಇದು
ಮಾರ್ಚ್.
ಸರ್ 95 ಎಂಟ್ರಿ ಮಾಡೋ ಎಕ್ಸ್ಟೆಂಡ್
ಮಾಡ್ತೀನಿ.
ಸರ್ 92 ಡೇಟ್ ಯಾವ್ದು ಕೊಟ್ರಿ ಸರ್?
92 19/2.
ಎಸ್ ಎಸ್
ಹ್ಮ್. 26 ಅಲೋಡ್ ಹಾ ಕವರ್ಡ್ ಅದಾವ ಭಾಳ ಅದಾವ ಇವು ಮೊದಲು ತೊಗೊಂಡೋಗಿವು ಎಲ್ಲ ಡೇಟ್ ಇವು ಅವು ಮೊದಲು ಕೊಟ್ಟವ ಇವು ಜಗ್ಗು ಇದು ಡಿಸ್ಪೋಸ್ ಇತ್ತು ತೆಗಿ ಇದು ಮಿಕ್ಸ್ ಮಾಡಬೇಡ ಅವು ಬೆಂಗಳೂರು ಅವ್ರು ಬೇರೆ ಕೊಡ್ಬೇಕು ಇವ್ರು ಬೇರೆ ಕೊಡ್ಬೇಕು ಮಿಕ್ಸ್ ಮಾಡಿದ್ರೆ ಮತ್ತೆ ನಾ ಡೇಟ್ ಬರಲ್ಲ.
ಆಯ್ತು ನೀವು ಓಡಾಡು ಸ್ವಲ್ಪ ಪಟಾಪಟ.
ಸರ್ ನಮ್ದು CPC ಬರ್ಲಿಲ್ಲ.
ಮುಂದ್ವಾರ ಹಾಕತ್ ನೋಡ್ರಿ ಮುಂದ್ವಾರ ಎಲ್ಲಿ ಮುಂದ್ವಾರ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರ್ತದೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನಾಳೆ ಕೊಟ್ಟಿರ್ಬೇಕು ನಮ್ಗೆ
ತಗೋಬೇಕು ನಂಬರ್ ಇನ್ನು ಆಗಿಲ್ಲ ಯಾರು
ಎಕ್ಸ್ಟೆಂಡ್ ಮಾರ್ಚ್
ಕಂಪ್ಯೂಟರ್ ಬ್ರಾಂಚ್ ಕಡೆ ಹೋಗಿ ಅಲ್ಲಿಂದ ಪ್ಲೀಸ್ ಬರ್ತಾರೆ ನೀವು ಕಂಪ್ಯೂಟರ್ ಬ್ರಾಂಚ್ ಕಡೆ ಹೋಗಿ ಇಲ್ಲೇ ಬಾ ಫೋಟೋ ಬರ್ತೀನಿ ಬಾ ಬಾ
ಹಾ 85 ಯಾವ್ದು ರೀಚ್ ಆಗಿಲ್ಲ ಯಾವ ರೀಚ್ ಆಗಿಲ್ಲ 85 ತನಕ ಡೇಟ್ ಮಾರ್ಚಲ್ಲಿ ಕೊಡ್ತೀನಿ ಎಲ್ಲ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಎಲ್ಲ ಮಾರ್ಚ್ ಯಾವ್ದಿಲ್ಲ
ರಿಸ್ಟೋರ್ ಮಾಡಿ ಡಿಸ್ಪೋಸಲ್ ತೋರಿಸ್ಬೇಕು ನಮ್ಮಲ್ಲೇ ನೋಡಿದೆ ರಿಸ್ಟೋರ್ ಮಾಡಿದೆ ಅದು ಎಷ್ಟೋ ಪರ್ಸನ್ ಸೀರಿಯಲ್ ನಂಬರ್ 50 ರಿಸ್ಟೋರ್ ಅಂತ ಹೊಡೆದು ರಿಸ್ಟೋರೇಷನ್ ಅಂತ ಬಂದು ಹೆಡ್ಡಿಂಗ್ ಕೇಸ್ ಟೈಪ್ ಹಾಕಿದೆ